almost annual event that Brett Olander and I sponsor. We're very proud to have you and grateful that you came. And if the numbers show up today like they have been registered, we really expect to have far in excess of 150 people, maybe 160. So when Brett first came to me and he said, you know, I want to do this CLE, you and I can do it together. It'll be kind of a plaintiff's perspective defense. And I said, oh, yeah. Thinking in the first year, what do we have, 30 or some people? And I thought, this is going to die on the vine. And it's done just the opposite. We keep getting more and more folks. And we're committed to a format, though, of only having like 20-minute presentations. So nobody is allowed to go too long. If they do, I usually come and stand right next to them on the stage and stare at them for a while, and then they sit down. But it's the only CLE in town where you get free BS and free booze all on the same day. So throughout the day, we're going to be giving away, we actually have wine and beer and hard liquor that have all been donated, and we'll figure out a way to do that. The other request I would make is please stop by the booths of our sponsors. These folks come here for nothing and oftentimes donate things or pay a fee to present to you. So please stop by their booths. Please try and use their services. They're wonderful people, and many of them have been coming back to us for years. Our first speaker, if I can read it, is Jeremy Estenson and Joel Carlson. Jeremy and Joel are both very politically active. They're at the Capitol. They're going to give us kind of a rundown on public and political issues. And as you know, with the midterms and everything else, there's, I think, a lot to be said. Joel Carlson has been a friend of mine for 40 years, and I was at one time, believe it or not, president of the Trial Lawyers Association, and I worked very closely with Joel, and both Jeremy and Joel are considered the best of the best at the Capitol. So, Jeremy and Joel.
Well, thank you again, Mr. Carey, for that. I'm Joel Carlson. I own a legal research and government affairs business here in St. Paul, and I apologize to all the MAJ members in the room. You've probably heard some of what I'm going to say 4 or 5 times already since session ended, but we're going to we'll get through that. And I have known Jim Carey a long time, and despite that, we continue to be very good friends. I've represented the Association for Justice, or it's hard to wring out the trial lawyer out of the title, but since 1994 at the Capitol, and I've been their chief lobbyist for a long time. But I also represent the court reporters. I represent another group of lawyers at the Capitol, and so a lot of what I do at the Capitol involves and touches the work that you do. And I've appreciated being invited to speak at this seminar because of the collegiality that you bring to it. And quite frankly, we are in a hyper-partisan and sometimes non-productive atmosphere at the Capitol right now. And the way this group cooperates and can work together to resolve legitimate legal disputes that you have, I think is in short supply at the Capitol, and please feel free to come over anytime and give them some advice. So I'm going to note a few items of interest that passed or received some attention in the 2022 legislative session. I'll briefly touch on the 2023 session that is going to start on January 3rd of 2023. And then I'll mention just a couple of points about the upcoming election. Then Jeremy's going to take it over from there and do a deeper dive into the election, and we hope to leave a little bit of time for questions at the end. So The 2022 legislative session began on January 31st. They had high hopes for success. They had $1 billion surplus. They were going to run in new legislatively redrawn districts because of reapportionment. Everyone wanted to cooperate. They had such high hopes. They were going to have tax relief. They were going to do a huge bonding bill of $1.6 billion, which benefits everybody running for reelection. Unfortunately, whether it's Lucy pulling the football away or the legislature again showing its ability to snatch defeat from the jaws of victory, none of that happened. They couldn't reach an agreement on a tax bill that included many popular positions, including eliminating the tax on Social Security benefits, and I see that's going to impact some of us at some point here soon. They couldn't agree on a bonding bill, a capital investments bill that were, $400 million of local projects that you all get to go to a ribbon cutting for in your districts, investments in roads and bridges and college campuses. They couldn't come to an agreement to pass a bonding bill. They had agreed to the overall scope of spending for a human services bill for long-term care, and I don't know if you've been watching in the news, but that industry is struggling with both staffing and funding issues. They had committed $1 billion, an agreement to commit $1 billion to human services, $1 billion to education, $450 million to public safety, a little over $60 million to increase funding to the judiciary. None of that happened. It all crashed in the last week of session. And so on the major issues of the session, which they had high hopes for going into the session, they kind of scored a 0. And that's unfortunate, I believe. They'll go into the 2023 session with about a $12 billion budget surplus. If trends continue, revenues have increased every single month ahead of projections. The August projection, they collected about $70 million more than they projected. And so they're going to be flush with cash. We just don't know. We'll hear more about what's going to happen with the election, and that'll set the tone for the agenda. They were able to reach agreement on a few bills, and I'll briefly mention them. They continued a health insurance premium finance plan to help buy down the cost of health insurance premiums in Minnesota. That was about a $300 million price tag on that program, and they did pass that. They did refill up the unemployment insurance trust fund, which affects all of you as employers. Without doing that, that was about $1.5 billion. Without doing that, an assessment on everybody's unemployment insurance would have gone up, and all employers would have paid that. We ran a huge deficit in that unemployment fund during the pandemic, and that needed to be paid back, and they were able to reach an agreement on that. And they did reach an agreement on, and maybe some of you worked on it, but the opioid settlement, much like the tobacco settlement, these funds that are coming to the state through the opioid settlement and how they would distribute that to municipalities and tribal government. But beyond that, it was pretty meager. And for the biennium, for 2021 and 2022, they only passed 99 bills to the governor. And to put that in perspective, in the heydays of lawmaking, when Wendell Anderson was governor and they passed all kinds of bills, the legislature would send 1,200 bills to the governor. 99 bills is what went to the governor in a 2-year period. So cooperation is not in a great supply at the Capitol. A couple of things that also passed that may impact your practice. They extended the COVID-19 presumption for first responders and healthcare workers so that if they contract COVID at work, it would be presumed that it's an occupational disease. And they extended that until January 13th of 2023. After a series of egregious stories in the Minneapolis Star-Tribune about some very predatory practices for people that were buying structured settlements that many of you work out for injured clients or for your insurance clients that are paying claims to injured people, these stories were just horrible of how people would prey on these, buying them for 10, 12 cents on the dollar. And the lack of disclosure and court oversight over that process was glaring and graphic. And the legislature did respond, and they did pass a law in the 2022 session that kind of changes that practice, and we hope for the better. The most important thing, and I worked on this bill a lot, the most important thing that they did, right prior to August 1st of this year, you went to court and there was no independent evaluation of the sale of your settlement, and the standard is if the person who owned the settlement and was trying to sell it thought it was in their best interest to sell it. Well, they're in front of you. There's no adversarial party. It's the purchaser and the seller asking the judge to approve the sale of their own asset. They've changed that now, so that now the court has to make a determination that it is in the seller's best interest to do this. It's in their best economic interest, and it really rarely is for them to sell their long-term structured settlement payments. It also provides greater disclosure to the consumer when they are making this transaction. They have to express this to them in the form of a loan. If you were going to the bank and borrowing this money you're giving up, you'd be paying 182% interest, right? In terms that consumers can understand, and we think that's a good thing, that they're going to have better disclosure there. And so that is one of the things that did pass in the civil law area that we think is a positive. A couple issues that didn't pass but got attention that I think we're going to hear again about in 2023. There's a major push by municipalities to change how we treat first responders, police officers, firefighters who have PTSD, and how their claims are handled and processed and the treatment that they may get. There have been a number of instances of first responders. Minneapolis is not the only example, but I think they have over 200 PTSD claims that have been filed in the last 18 months. And it is a heavy cost on local units of government, and they would like to have a better way to provide treatment to their employees. And that was a major issue in the session. It didn't advance, but I anticipate that is going to come back. For those of you that are doing car accident and motor vehicle cases, there was legislation that was proposed that would regulate and require insurance coverage for this new business model called peer-to-peer car sharing. And you can put your car on the market right now by Car2Go, or and somebody else can use your car when you're not using it. And there's questions about who's got primary coverage in that situation. Does the person renting the car have it? Does the platform have it? That did not advance after the first committee hearing, and there were some real problems with how the bill was written. But I think that's an issue that is ripe for legislation. It does need to have some parameters put on it. I will say this, it was a bill that everybody hated. I mean, it was fun to go up as trial lawyers, and sometimes we stand alone. But the rental car companies and the auto dealers and the insurance company, everybody hated this bill. So it was nice to have some company for a change on something that we opposed. They once again had a hearing to repeal the seatbelt gag rule. I think I've testified on that bill about 41 times in the last 20 years. I assume that they will attempt to do that again. And the last thing I will mention is the Minnesota Medical Association has approached MAJ about an alternative form of dispute resolution when they have an adverse event in medical care. And it's called Candor. A couple other states have passed this, and they want to have a mechanism where they can deal with their patients in a way that that isn't held against them, so that they can speak with them in candor. This is what happened, and it's a voluntary process. And that didn't pass in 2022, but there are some positive aspects to that program that I think we all could agree upon. And so that's an issue that I think if you're doing medical malpractice work, that I think is going to surface in 2023 and may get attention. So I'm going to turn it over to Jeremy here, but as Jim mentioned, we are in the middle, about 47 days to go to the midterm elections. And, Minnesota, electorally, we're a little crazy, but we're not that crazy. So I don't know exactly what's going to happen in the election, but we do know this. In 15 of the last 16 presidential elections, Minnesotans have voted for the Democratic nominee for president. And at the same time, in 15 out of the last 16 state elections, our voters have produced divided government. So there's a message there. Only one time in the last 16 election cycles did we have full control of our government in one party. And that was in 2012 when Governor Dayton was in office, and the 2012 election produced majorities for the Democrats in the House and Senate. Every other election of the last 16, we've produced divided government. And I think that is not an accident. I think Minnesotans like divided government. I think they like checks and balances. And the other just brief thing I'll mention with the new legislative district boundaries that were redrawn by the courts, they were not part of the partisan gerrymandering that you've seen across the country. Everyone has kind of said the courts did a very good job of redrawing the lines without regard to partisan makeup or where the incumbents live. I'm a little biased. My brother was on the 5-judge panel that helped redraw those lines, but I think that they did a good job. But what has happened in Minnesota over the last 20 years, we have gone through a very significant political and geographic alignment, and that is reflected in the new legislative district maps. You are seeing a concentration of voting power in the core metropolitan area, the 7-county metropolitan area, outstate regional centers, Rochester, Moorhead, Duluth, and that has made it extremely difficult for Republicans to win statewide. You're winning your margins in Hennepin County for a Democrat. You're winning Hennepin County, the most populous county, by 40 points. And we haven't had a Republican win statewide since 2006. And I think that is a reflection of the geographic and political realignment that Minnesotans have experienced. So, that you just can't ignore it. That is where the votes have shifted, and I think that's going to continue in 2022. So with that, Jeremy, I'm teeing that election up for you, and then hopefully we'll be able to have a chance for questions. And thank you again for having me here. I always appreciate being invited to come and speak to this group. So thank you, and thank you for what you do.
Well, thank you, Joel, and thank you, Brett and Jim, for having me. The seatbelt gag rule is one of my clients' bills, and Joel likes to beat me up on it every single year. And so to that point, you've got some pretty capable representation here. Frequently, I represent folks on the other side of some of those discussions at the Capitol, and Joel always does a great job representing those of you who are part of the association. I also want to talk to your brother, Joel, because I live in CD8 now, or I will. I live about 3 miles north of White Bear Lake, and so what I have in common with the Iron Range and International Falls and some of those things I don't entirely know, but nonetheless, I now live in CD8. When I listen to election previews, I always hope that somebody gives me, some crystal ball indications, but I think if I've done my job at the end, you'll be as confused as I am, just with more facts. To Joel's point earlier, the geographical and political shifts, in addition to that, the whole world has gotten more partisan, and there's this purity test now that exists among the party faithful on both sides that probably didn't exist, or maybe there wasn't a mandate quite like there was before. And so we've seen fracturings within caucuses. You now have these subgroups within the House Democrats or the Senate Republicans or whatever the case may be. And we saw that even play out into how they caucus. Some getting kicked out, some, get this, there were at the beginning of 2022, maybe it was 2021, there were the Republicans in the House, then there were the new Republicans in the House, and then there was a guy who was too nuts for the new Republicans that they kicked out, and he had to have his own group. And the worst part about that is I think he's probably going to get reelected. The gentleman who was ostracized from the House DFL party lost his primary. I don't know anything about the new person, but anyway, it's messy. The reflection of what you see on Facebook, it translates to the Capitol to a certain extent, and it's messy. These folks, Joel mentioned not a lot got done. On the one hand, that's too bad. On the other hand, thank God, because if the stuff we wanted to get done got done, so would a whole bunch of other things. And last year, the recipe just wasn't there. The fact that they couldn't get together around a massive surplus and just do some sort of feel-good election spending, couldn't send the Walls checks back, couldn't do some middle-class or low-income tax relief. I mean, there were two pretty good plans out there. It was telling of the fact that these purity tests have just gotten in the way. Now, 51 people are not seeking re-election. It was 1972 the last time, the only time more people didn't seek re-election. And I'll be honest with you, I think a lot of it has to do with the fact that people are tired of the fighting. It's gone from sparring and the way politics used to be conducted, families got left out of it, to this social media evolution where there's a bunch of people who make money delivering body blows. And when I talk to people who have decided to retire, it has a lot to do with the fact that they don't want to go through it anymore. You know, it's a part-time legislature. They make 40 grand or something like that. And it's just not worth it. And it's no longer, despite what the Constitution says, it's no longer part-time work. If you're in a competitive House seat, there will be probably this cycle $3 to $4 million spent on one House seat, 134 of them. So it's gotten tough. And so, you know, they all left, but in reality, I think they felt like they were getting out of the asylum. There were a bunch that this year just threw their hands up and said, you know what, this is not what I signed up for. And people with a lot of experience, it's always a tricky spot for folks who like to think about how our governing system should work, about the institutional knowledge versus term limits. And we're losing 600 plus years of experience this cycle, and that means something. Joel mentioned the redistricting. This is a shot of the House maps. They've changed over time. 2012 on the left, if you're in the back, 2020 on the right. There is a plan that, I don't know if there's a pointer on this deal. Right here is the last holdout of light blue in greater Minnesota. Kurt Doubt, who's the current leader of the House Republican Caucus, believes that without a single suburban seat flipping, they can take a narrow majority by just winning all of the greater Minnesota seats. And now that doesn't include Mankato or Rochester, where folks who caucus with the DFL already have seats. It does include a Paul Marquardt seat up in the northwest part of the state and a few seats up in the northeast part of the state. One thing that's worth pointing out, I think, is that the Senate DFLers, longtime DFLers, Tom Bach and David Tomasoni, who have been the quintessential DFL, particularly L in that equation, started caucusing with Republicans this year. And if you ask them, they would say, we think just like we've always thought. But there's a group in Minneapolis now driving the party politics who have succumbed to the purity tests that make it impossible to negotiate, arrive at deals, so on and so forth. And for reasons that I'm not going to try to explain, they felt it was more beneficial for them and their constituents to caucus with Republicans. It would not surprise me at all if Kurt Doubt is right and they pick up those 3 or 4 greater Minnesota seats that they don't currently have and probably flip a few in the meantime. In the suburbs, I'm sorry. Okay, so every election has a unique fingerprint, but there are some basics. Joel talked about some of the basics. Presidential midterm, almost always good for the opposite party of the president. I'm just going to mention a couple of things that I think are unique to this particular cycle. Well, let me back up. Money. In Minnesota, Democrats always outspend Republicans. We end up in this purple situation, like Joel mentioned, 15 out of the last 16 cycles, and that gets done with Democrats typically outspending Republicans at least 3-1. I would expect it to be more this year, and the reason I say that is just a gut check. You've seen all of the ads running, the independent expenditures running against Scott Jensen and some of the Republicans. Those things have been on the airwaves now for going on a month, and the Jensen campaign just got on air, I think this week, or maybe at the end of last week. The IEs against Walz aren't going to put anything on the air till probably at least next week. So there's just a time factor there, and Republicans in this state have a hard time raising money, particularly since I think it was 2006, the Emmer kerfuffle, when Tom Emmer ran for governor and lost to Mark Dayton. He made some enemies with the corporate community. He's obviously gone on and had a successful political career in Washington, D.C., but that set a stage that I don't think we've been able to recover from. Here's what I see as the exposure and the tailwinds. The exposure for Tim Walz is his record. He inherited a bunch of stuff that I wouldn't wish on my worst enemy, but he also made a bunch of decisions that a lot of Minnesotans don't like. Okay, so you tack those onto the nationwide themes of, you know, abortion on the one hand and economy and crime on the other. Jensen, on the other hand, undisciplined. He's run for one seat. He's held a Senate seat for a little while. And keep in mind, when he was a senator, he was the left flank of that Republican caucus and real mavericky. Well, his maverickiness has extended into his campaign. On the other hand, Walz, the tailwind for him is money. He's got a bunch of it, the power of the incumbency. I think he's always done well in front of a camera. He's very affable. People like him. But for Jensen, you know, his strongest attribute, and I don't mean this as a dig, he's not Tim Walz. He doesn't have the record that he's got to defend right now. Though, as you've seen in the IEs, if you've paid any attention to TV or social media, he is, you know, the Antichrist when it comes to abortion issues. And those ads have been very effective, and there's been some polling to indicate that. Speaking of polling, I don't take it particularly seriously. It's fun. It's kind of like reading the opinion pages. It's a snapshot in time. But what I do think is interesting is that RCP, which is, if you follow politics at all, there's a website called Real Clear Politics. They do a good job aggregating and finding averages in polling. Those things seem to tell us a little bit. What RCP has now is a Walz +5 advantage. That's pretty unheard of for Republicans. That shouldn't be good news for Republicans in Minnesota. That's good news for Republicans. Never that high. Nate Silver, on the other hand, if you follow his baseball predictions that have turned into political predictions, he is giving Walz the same chance that he gave Hillary to win in 2016, 95-5. RCP, on the other hand, has it as a toss-up. So internal polling from the Jensen camp, the Walz camp, the Democrat caucus, the Republican caucus, have things pretty well in toss-up territory, which in shorthand in Minnesota elections generally means pretty good things for Republicans, but there's a long time till we get to the election. Speaking of split government, Joel mentioned, he was talking about what this weighted map shows. So imagine you're a statewide Republican candidate. Well, you can just forget about it, roughly a third of the state, more than that, but you can just forget about it. You've got to go find votes in all kinds of other places. It means traveling a lot more. It means spending a lot more money to try to target your message, so on and so forth. I know that Attorney General Ellison is coming later. Not only has Minnesota divided government, this is a year where Minnesotans turn out and vote. They're more educated voters than most other states. I would not be shocked this year if there was something among the constitutional offices, governor, attorney general, secretary of state, auditor, where the parties split among them. And How that works for governing, for guys like Joel and I trying to figure out how to engage with the administration is beyond me, but it'll be an interesting problem if we get it. Joel talked about some of the scenarios there, but I think for the hyper-partisan folks among us who hope that their team wins it all, well, we saw it once in the last decade, and it wasn't that great. It was kind of terrible. They had a hard time governing. Minnesotan stakeholders, voters, and legislators, elected officials, are used to divided government, and they kind of know how to make it work. Let's take 2022 as a flyer and set it aside. It's generally been in everybody's best interest to see that happen. And like Joel said, it would not surprise me if that happened again. Finally, if you want to get involved, I'm sure that we can provide you some resources, but just Google candidates in your area. They'll put up a sign in your ditch. You can knock on doors. You can make phone calls. There's a now retired legislator who, for those in the back, Sandra Erickson up in the Princeton area, she ran this sign. All right, this is electoral capitalism at work. You can drill in my yard if it will lower gas prices. Sandra Erickson, and we all thought that was a really bizarre ad, but she kept getting reelected. So with that, I know we're running long already, and I hate to be responsible for starting off that way. So a couple questions? Or no?
Does anyone have any questions or issues you want to raise? Well, as usual, they both did a great job, and I'm very grateful for you guys coming. Thank you.
Yeah, thank you.
Okay. Good morning, everybody. So thanks for coming. Those of you that came and those of you that are here in past years know that the rest of these seats would be filled and maybe next year for that, but we're doing well. Mary Batchelor is up next. She's going to talk about confidentiality agreements. And the one great thing you can say about Mary, unlike everyone else in this room, especially me, she was number one in her law school class. Anyone else? Number ones? Don't be bashful. All right.
That's not the only good thing you can say about
Well, it's one of the things that I know about you that's true. So anyway, Mary Batchelor. Oh, and Mary is, she's originally from Fargo, correct?
Well, I live in Fargo.
She lives in Fargo. Pete Kessner, who was here, Pete wandered out there, I think, but Pete brought her down here virtually, it sounds like, with his firm. So, and Pete's been a regular contributor here. So, Mary, have at it.
So one of the problems with having a really cool PowerPoint that doesn't have any words on it is that all my notes are not available to me, apparently. So I'm just going to put my computer right here so I can read my notes. So as Brett said, I'm going to be talking about confidentiality agreements, and I work with Pete Kessner, PKM law firm. We represent people who've been injured by commercial motor vehicles, semis, that sort of thing. And so today we're going to be talking about the problems basically with some of these confidentiality agreements. I'm going to talk about basically the basics, and specifically what I'm talking about, some of the reasons that they're used and some of the ways that they're used. I'm going to give you a case study based on a real-world example of a case in Michigan that was presented to the Michigan Ethics Board, and the ethics opinion that was provided there, and some of the ethical implications of that. And then we're going to talk about some public policy considerations that these confidentiality agreements bring to bear. First of all, the basics, what are we talking about? Obviously, I think everybody here has dealt with confidentiality agreements, and specifically what I'm talking about here is a contract that attempts to limit the attorney's ability to talk about the settlement. So obviously, all of these situations, there's a released party, offers money in exchange for promises from the releasing party, including a release of liability, among other things. And plaintiffs are often asked to sign these in the context of personal injury cases, trucking, mass torts, products liability, basically any situation where there's a corporate defendant especially, and a corporate defendant wants to prevent the settling party, the plaintiff, from talking about the terms of the agreement, talking about the facts of their case. Certainly talking about the amount of money that they were offered, but also to prevent evidence of those bad acts getting out in the public. And so the main reason for using them is exactly that. Corporations want to prevent bad publicity and the perception of frivolous lawsuits or copycat lawsuits. So encouraging, in their mind, other plaintiffs from bringing claims against them because there's this perception out there that they're going to offer a lot of money in exchange for silence, without admitting liability, of course. So that's why defense typically wants to use them, and they work in a lot of cases because the defendants are the ones that have the money. The corporations and the insurance companies have the money. The power is in their hands, and so they're able to use these to their advantage. Why do we not want to agree to them? There's a lot of ethical considerations that come into play, and we're going to talk about that. There's also other implications too, practical and tax implications. They have a tendency to harm the public and inhibit the proper functioning of the justice system, which is something that as attorneys we commit to uphold those values of upholding the values of the justice system, so that's a problem. And they really, there's also several public policy reasons that you don't want to use them. And they limit your ability to practice law, and that's a big thing that we're going to talk about. They can, though, be used ethically and effectively in a very narrow way and in a narrow scope. And I'm going to provide you with kind of a guiding principle to think about when determining whether you should be agreeing to these kind of agreements. So I'm going to give you a case study, like I said, and this is an actual case that happened in Michigan. And a plaintiff's attorney provided this factual scenario to the state ethics board, which then issued an opinion. So this is dealing with an exploding kitchen appliance. A plaintiff's personal injury lawyer is faced with the following scenario. The lawyer's client is the widow of a man who died when a kitchen appliance exploded during normal use. So the case mediated for $2 million. And the lawyer feels that this is a fair approximation of what the case would generate at trial. This is in 1998, by the way. Discovery has disclosed that many other individuals have died under similar circumstances, and the appliance manufacturer had knowledge of this. The manufacturer could have cured the defect in a design with a 50-cent part, but chose not to do so for financial reasons. So, $2 million at mediation. After mediation, counsel for the appliance manufacturer offers to settle the case for $3 million, subject to the following conditions. The court file must be sealed and the terms of the settlement must be secret. Plaintiff's counsel must agree to return all discovery materials and not retain copies. The expert witnesses lined up by plaintiff's counsel must agree to not testify in future similar cases. And plaintiff's counsel must agree to not represent any new clients in similar cases against the appliance manufacturer. So, the offer is communicated to the client who wishes to accept immediately, as you can imagine. And the client's not concerned about any of these conditions since they don't directly affect her. The lawyer, however, is concerned and does not want to accept this. And you might be able to guess what some of those reasons are. And I'm going to get into that, specifically the ethical considerations. But even before that, there's some other practical considerations and tax implications as well. And anybody who represents plaintiffs probably knows that under the Internal Revenue Code, compensation for bodily injury is not subject to taxation, subject to income tax. But in this case, arguably, that $1 million difference was not in compensation for bodily injury, but in compensation for silence. Okay, so there's the potential that there could be tax implications on that $1 million, and that's something that you would need to counsel your clients on and consider. There's also some practical implications with some of these provisions, and not all of these provisions were found to be unethical by the Michigan board. For instance, the provision that plaintiff's counsel return all discovery materials and not retain copies. This is actually something that the Michigan board said that could be ethically accomplished. But there might be some other considerations you might want to think about. One would be, whether there's potential privilege or work product issues involved there. And then whether or not you're subjecting yourself, if you are if you're concerned about a potential legal malpractice claim, there's a 6-year statute of limitations in Minnesota on a legal malpractice claim, and so you might want to keep your file for at least 6 years just to protect yourself in that situation. So those are some not necessarily ethical considerations, but other things that you might want to think about. The other provision that was not necessarily unethical according to the board was that the court file be sealed. This is something that you're going to have to get agreement from the court, obviously, but that is something that could potentially be done ethically as well. But there are lots of ethical implications with respect to the other provisions, and so we're going to look at the ABA model rules of professional conduct, which I'm sure everyone here is very familiar with. So the first thing that comes up in these situations is your duty to your client. And this is the big one. We all know that duty to clients is first and foremost, and in fact, Rule 1.2a says that a lawyer shall abide by a client's decision whether to accept an offer of settlement. So if you're just looking at that rule, it's a no-brainer. You should accept this offer of settlement, right? And that's what the client wanted. Rule 1.3 also says that a lawyer shall act with reasonable diligence and promptness in representing a client. The comment to that rule states that a lawyer should pursue a matter on behalf of a client despite opposition, obstruction, or personal inconvenience. So even if this is personally inconvenient to you, maybe you should accept it anyway. Unfortunately, this rule has to be read in conjunction with the other rules of professional conduct. And the big one there is that not only do you have a duty to your existing clients, but you have a duty to former clients, you have a duty to future clients potentially, and you also have this conflict with your ability to practice law and restricting your ability to practice law in the future. So it's not as simple as it looks. And Rule 5.6 is the one that comes up in pretty much every single ethics opinion you're going to read, and in every potential scenario in terms of putting any sort of restriction on your right to practice in the future. So a lawyer shall not participate in offering or making an agreement in which a restriction on the lawyer's right to practice is part of the settlement of a controversy between private parties. So as you can see, this is in direct conflict to the idea that you accept the settlement if your client wants you to. And I think one of the really interesting things about this rule is it says a lawyer shall not participate in offering or making an agreement. So if you're offering an agreement that restricts another attorney's right to practice, you're also violating this rule. Okay, so keep that in mind. If you're a defense attorney and you're putting this in front of a plaintiff's attorney to sign, you're actually violating the rule just by offering that. So one of the comments to this rule also prohibits a lawyer from agreeing not to represent other persons in connection with settling a claim on behalf of a client. So you're actually explicitly prevented from agreeing to not represent future clients. And why is that? One of the foundations underlying the model rules of professional conduct is to make legal representation available to as many people as possible. And by restricting your right to represent people in the future, you're obviously violating that. And not only obviously are you doing that, but you're also affecting your livelihood and putting yourself in a position to not get future clients, which you don't want to do either. Rule 1.7 piggybacks on this too. So this rule prohibits representing a client where there's a significant risk that the lawyer's responsibilities to a former client will materially limit the lawyer's representation. So if you're getting, if you're seeking new clients that are going to be bringing claims against the defendant that you already signed this agreement for, you're going to be putting yourself in a position to have a conflict between a potential future client and a past client. How can you represent a new client without discussing anything that you've learned in the past, or any evidence about that client, about that defendant, information like their policies and procedures and practices, information like the existence of certain types of evidence? You're going to be basically reinventing the wheel every time you have a new client. And so not only is it impractical, it's probably impossible, as well as unethical. And you may also want to share this information with a mediator or some other neutral when you're presenting your case in mediation or settlement conference in order to help resolve the case. So these are all reasons that you might need to use that information, and it's going to materially limit your ability to represent your client if you can't share any of that. So that basically takes care of the provision that was that a plaintiff's counsel must not agree to represent any new clients in similar cases. There was also a provision with respect to evidence. So Rule 3.4 governs fairness to opposing party and counsel, and basically tells you that a lawyer shall not unlawfully obstruct another party's access to evidence. And evidence does not belong to any particular party, and either do witnesses. So in this situation, it's against the rules, and it's completely unethical to say that you're not going to allow an expert witness, for instance, to testify in the future. So you can't really do that anyway. I mean, you can't, under the rules, prevent someone else from providing evidence to another party either. And party in this context is construed broadly to mean not only an existing party to the litigation, but also a potential future party. So a potential future litigant, someone who could have a claim against this defendant in the future. You are not allowed to restrict their access to evidence. And even if you wanted to, let's see, this rule tells you that a lawyer shall not request a person other than a client to refrain from voluntarily giving relevant information to another party, unless, and there are a couple exceptions, or there's one exception, the person is a relative or an employee or other agent of a client, and the lawyer reasonably believes that the person's interests will not be adversely affected by refraining from giving such information. And so this is used to prevent someone who's an employee from sharing maybe confidential information or trade secrets or some other piece of information that they would have by virtue of the fact that they're employed by the defendant from sharing that in the future, if you believe that it won't adversely affect their interests. So that is something that you can ask them to do, but only in that very narrow case. So as you can see, lots of ethical considerations and potential problems that arise with those provisions that were requested in that Michigan case. And the main one is the restriction on your right to practice law. And the public policy concerns that underlie that, the main one is really restricting the public's access to the best attorney for their particular case. So attorneys with the most experience handling certain types of cases shouldn't be prevented from using that experience and using that knowledge and using that expertise to benefit people in the future. Obviously, that affects your ability to make a living, but it also affects the public and their ability to pursue justice. So, you know, it's contrary to really the spirit underlying the criminal or the justice system, as well as the model rules of professional conduct. These agreements are also seen as an effort to kind of buy off plaintiff's counsel and bribe, for lack of a better term, litigants into settling. And then it also places the attorneys in a position where the interests of the current clients are in conflict with future clients. And I think that, I skipped a slide. So it's important to note, though, that, you know, you really can ask for these and you can agree to them in certain limited situations. And I found this guiding principle in one of the ethics opinions that I think, you know, sets up sort of the rule that we can use to determine if these agreements are ethical or not, and that is that a claimant's attorney should not agree to or request a settlement restriction giving the attorney significantly less discretion in prosecution of a claim than an attorney independent of the agreement would have. So you can use this as kind of a guiding principle when determining whether to sign one of these confidentiality agreements or to offer it in the first place. And, you know, the opinions that I've read that are out there, you know, there are narrow clauses that you can include that are held to be ethical. And a lot of times, I mean, most times, just the existence of the settlement and the terms of the settlement, including the amount, that can be held confidential in an ethical manner, as long as that's not publicly available information, obviously. We may not want to do that, we may not want to agree to that, but it has been found to be ethical. And in the same way, certain non-disparagement clauses, if they're narrow enough, have been found ethical as well. And I think, you know, in the way that this often comes up is kind of at the last minute, right? And it's just like the situation that I used as the case study in Michigan. It was at settlement, or it was at mediation, and then it was after mediation that this was presented to the attorney and to the client. And at that point, it's kind of too late, and the attorney is put in a position to really be pressured by their client to do the right thing by their client, but also to uphold their ethical values as well as what they feel is in their best interest. And so really the way to hopefully prevent these from coming up at the last minute going forward is really to talk to your client right away and to talk to the defense as well and tell them up front that you're not going to agree to these kind of settlement agreements. At least then the expectation is set on the front end that hopefully they won't spring this on you at the last moment and put you in that pressure situation where you feel like you're in a tough spot with your client. So with that, any questions? I know this is a very interesting topic.
Oh, it really is.
Well, I know it is. That's why I said that.
I'm multitasking and actually thinking of some things, and then not sure I should ask them because you probably already said it. So.
Well, that's okay. I don't mind repeating myself. Yeah. So the question was, would it be prudent to have some sort of separate agreement with consideration stated for the confidentiality aspect of it?
Just separate consideration, not a separate agreement.
Okay. Maybe. I mean, that's an interesting suggestion. Sure. I mean, that might help from a tax perspective, as you said. I think, you know, generally there's no question in a settlement agreement that the settlement amount is for bodily injury. So it shouldn't be a problem unless it's obvious in a situation like this that the only difference is the secrecy clauses. So it shouldn't typically be a problem, I don't think, but in this situation, that might be prudent. I don't know if anybody else has a suggestion there, or just don't ask for it in the first place, I guess, but, yeah.
Another way around it, just put in that it's mutual confidentiality that is sufficient consideration, so any punitive damages that might be involved aren't taxable.
Well, and I think, I mean, and again, the real issue here is that the attorney is the one that's being asked to maintain confidentiality. So it's not uncommon for clients to have to maintain confidentiality, and some of them may want to do that anyway because it protects them too. So I think that here the real issue is the attorney making that agreement. And the attorney can also be held liable on behalf of their client if their client breaches the confidentiality clause, unfortunately. So it doesn't, leave you completely in the clear if it's only signed by the client, but the real problem comes when the attorney is the one that's signing these. I don't know if that answers your question or not. Okay. You're welcome.
By staying on schedule, Mary, you've potentially earned yourself a repeat visit, so nicely done. All right, next up, we are pleased to provide you with your annual hour of ethics. And actually, I could have probably petitioned for another half hour because Mary's presentation dealt with ethical issues as well, but I will not be petitioning. I have petitioned and lost with the lawyers board even when I was on the board. So anyway, so our friends from the Bassford firm, R.M. Destian and his was summer associate and now back at school, right? All right, Olivia Lisfonce, and just R.M., so you know, you are going to be the winner this year of the Not Standard sport coat. So in case you ran out of here after you're done like you're prone to do in past years, I will be emailing you that certificate, but this is at least 4 or 5 years for you guys, and I know we gave it to Jessica last year, the year before, and I know you're now a shareholder at the firm, so congratulations there. I feel like we might have had something to do with that, pushing you up the ladder at the firm. So anyway, and I was down in Northfield yesterday, and my son goes to St. Olaf, and so I figured it should go to an Ole this year. So anyway, congratulations on that, and come on up and let's have some ethics. Oh, one other thing. Veritex Paradigm out in the hallway, one of our sponsors, they've been with us for a long time. Jan Ballman's back, by the way, for those of you that know Jan. They're going to raffle off a pair of Viking tickets to the Lions game this week and to one of you lucky winners. And so make sure you get your card in their fishbowl out there. Okay.
Well, thanks, everybody. It's good to be back. I'm R.M. Destian from Bassford & Remley. I'm a shareholder there. My practice primarily consists of complex commercial litigation, and then the other half is representing lawyers in ethics, malpractice, and risk management issues. So I'm very happy to be back. For those of you who've been here in past years, you'll know that I usually present with my partner and good friend, Jessica Klander. Jessica is in San Diego right now, and when I suggested that she pay for all of us to go out there and do this there, she thought that was a bit much, and so I'm bringing along my other colleague, Olivia, who was kind enough to, as you guys all know, do all the work in preparing this, so I figured let's actually let her come and talk, and she knows more about it than I do, frankly, on the facts of these cases. So I'm very happy to have her here with us. Do we have the PowerPoint up? You don't have one? All right, well, hold on one second. Thank you very much. Mind if I grab that? Thank you. So what we're going to try and do when we get our PowerPoint, I think we'll get that taken care of in a couple seconds here. We're going to go over a couple of things. We're going to go over some recent developments in legal malpractice law, some recent decisions in legal ethics and risk management issues, and then we're going to talk about some hot topics. What I generally try to do with this, aside from scare all of you into, paying attention to the P's and Q's of ethical compliance, is identify the things that I've seen in the past year as being common issues raised in disciplinary investigations or risk management issues that I've seen. I serve as Associate General Counsel for our firm, and so I see things in that capacity, and I represent dozens of lawyers a year in dealing with ethics issues and malpractice issues. So these are things, especially some of the stuff that we'll talk about in terms of fee agreements, that will that are very, very common in the cases that I've seen. So while we wait for our PowerPoint to come up, I'll have Olivia come up and explain the first case that we're going to talk about, and it's the Supreme Court iteration, the final end of a case we've talked about, I think, 2 or 3 times now, which is the Middlestead v. Henney case, which is a legal malpractice decision that we finally got final clarity on a pretty important issue for those of us who defend lawyers and for those of you who may sue lawyers. So I'll have Olivia come up and provide some additional explanation of that.
All right, so Middlestead v. Henney. So the expert requirement for the malpractice claim under the Minnesota statute 544.42 provides 2 things when a plaintiff brings a legal malpractice claim. First, submit an affidavit of expert review with the complaint. And then a more detailed expert disclosure that sets out the opinions of that expert on the claim within 180 days after discovery has started. So briefly, Middlestead involved allegations that an attorney represented the plaintiff, Middlestead, in a business transaction and failed to disclose to Middlestead that he was part owner of the owner party of the business transaction. So when the dispute arose, the parties to the transaction, Middlestead brought a claim for breach of fiduciary duty. Because Middlestead did not submit an affidavit, the court the court granted summary judgment, I apologize. And the argument was that it was a breach of fiduciary claim versus malpractice. So there was a distinction there, which the court did not buy.
Yeah, and so what's the important part about this? I mean, it's inside baseball, and for those of you who don't either sue or hopefully get sued, it's good for me but bad for you. What's important about this is it's a couple of things. One, Minnesota has a 6-year statute of limitations, which you heard the prior speaker discuss, right? And so one of the things that has been created by the legislature in order to, given that this goes on, you've got a tail on these claims for quite some time. I mean, it's 6 years from the accrual date, and our accrual date in Minnesota isn't the date that the work was done. It's actually something, it's called the sum damage rule, which requires some analysis as to when legal rights have changed. So it could be multiple years after the work was performed. So it's not inconceivable that you could have 8 years, 9 years, even since the work was performed for a claim to be brought. So because of that, the legislature has imposed these restrictions that require someone to vet the claim and determine it to be non-frivolous. It's important for a number of reasons, but what I have been seeing is it's not uncommon for plaintiffs' attorneys in these types of situations to bring claims attempting to split them and allege that they're effectively different. And this claim, or this case here, has assisted us in saying, well, look, that may be partially true and that there can be different relief available under breach of fiduciary duty claims, but where you're alleging a breach of the standard of care effectively, it doesn't matter which term you use. You have to get an expert to vet that and determine that, in fact, there was a breach and there was causation. Great, here we go. Perfect. All right, and then the next thing is a couple of new ethics decisions that came out. This is the majors decision. I'll have Olivia explain a little bit about this one is, and then I'll tell you why this scares the heck out of me.
All All right, so in re disciplinary against majors, the misconduct arises from two separate client matters. The first client matter, the client paid advanced payments, and the attorney deposited that into a business account, into the operating account versus a trust fund or a trust account. Throughout the representation, the attorney withdrew his business account to pay business expenses such as payroll, and this led to repeated shortages. And there were times where the account didn't have enough funds to cover the client's advance and unearned expenses or funds. In the second matter, the attorney represented a client who agreed to a flat fee agreement, which stated that the legal fees would be held in a trust and would not be refunded if the client terminated the agreement. However, the agreement didn't provide the 5 non-refundable fee agreements required by the Minnesota Rules of Professional Conduct. So the key in these two matters is that the flat fee did not comply with the agreements that is required when you have a flat fee agreement, and advance fees going into the operating account versus the trust account.
So I'm gonna talk about this for a little bit, because I'm seeing this a lot. This here is the rule that deals with flat fee agreements, all right? If you use flat fee agreements and you have not reviewed them for compliance with this rule, you are sitting on a liability problem that will explode the minute you get any type of complaint, because the first thing that an OLPR investigator is going to ask for, no matter what the issue is, if there's an allegation that it's a flat fee retainer agreement, is they're gonna ask to look at your retainer. And so let's say you have a complaint against you for, you didn't respond to my emails fast enough, all right? I see that all the time in representing lawyers. The OLPR is not limited to investigating what has been alleged in the complaint. Once a complaint is filed, if an investigation has been opened, it's open season. And what I very, very frequently see, all right, is exactly that fact pattern. You have somebody who says, my lawyer didn't respond enough. Or frankly, I have had some crazy allegations that they were conspiring with the county attorney's office and all these other things. And for some reason, it got sent to a district ethics committee for investigation, even though it seemed on its face to be one that you would want dismissed. And despite all of the actual allegations being found to be completely without merit, there is a private admonition issued as a result of the fact that there is a fee agreement that has been used in that case that is not compliant with this rule. So you can do everything right over there, and you can have a huge, or not a huge problem, but a problem over here. On its own, this is probably a private admonition, okay? Here's where it gets bad, and here's where the major's case is illustrative, all right? Oftentimes, people don't realize that they don't have a non-compliant fee agreement. They think they're allowed to do this, right? They think, well, all right, I'm allowed to do a flat fee. And they don't include what I call the magic language. These 5 provisions here at the bottom are absolutely mandatory for every flat fee agreement. And if you want to place your flat fee into your business account and you do not have these, right, you can't do that. It has to go into trust. It is not, if you do not comply with this, it cannot be your property upon payment. It can't, as a matter of rule. And so what happens is people place them into their trust accounts, or into their business accounts without putting in their trust, and there's a problem, right? The really big problem then comes when they've said, all right, I'm gonna do this for $1,500 plus expenses, right? So $300 in costs, and they give you an $1,800 check. You've got a non-compliant fee agreement, you put it in your business account, and you include the $300 as your advanced costs. You've now misappropriated funds because you've placed advanced costs, which should never go in your business account, into your business account. And if you draw that down below the balance, so let's say it's $300, if you draw that down to below $300 in your business account because you're paying your normal expenses, that's intentional misappropriation that the court takes a presumptive, the default position is disbarment. I just had one of these where it was entirely unintentional and we had to stipulate to a 12-month suspension Because absent litigation, that is the lowest the OLPR would go. When there was an agreement that there was absolutely no intention to steal the money. But the way that the court has defined the terms intentional misappropriation means if you put those advanced costs into your trust, into your business account, and you draw it down below that value, you have intentionally misappropriated funds. I've seen 3 of these now in the last 2 years, and they are brutal. They're career enders, and they're almost always unintentional. So, what do you have to do? All right, first off, your first thing, you need to vet every one of your flat fee agreements to ensure that they comply with this rule. There's no such thing as a non-refundable flat fee. There's no such thing as a non-refundable fee agreement. That's just not a thing. The rules are very clear about that, all right? If you do a flat fee and you terminate before, if either you terminate or the client terminates you before the full amount of work is done, you, by rule, must give them a refund of some amount that is reflective of the work performed up until the time of the termination or withdrawal. In fact, as you see here, it says, will be entitled. That is a must. That is not a permissive. So if you get the case literally up until the last possible thing and you get fired, right, and you've done 98% of the work on that case, you have to give them something back. It may be $20, but you have to give them something back. There's no way unless you've completed all of the services for you to keep the entire amount, all right? So that's number one, you're gonna vet your fee agreements. And I do this for so many I serve as outside ethics counsel to 15 law firms now. This is everyone, every time they wanna do one of these with a new fee agreement, I vet it. Because these are, especially if you have a consumer-facing practice, you're gonna get an ethics complaint just based purely on the fact that you have clients who think that they should have won. And so there's gonna be an ethics complaint, and this is the trigger, okay? So that's number one. Number two, you need to go over your trust accounting procedures in your firm. And most people that I deal with, most of my clients before they've met with me, they have their office manager who handles these things, right? And they've never reviewed, they don't even know that Appendix 1 to the Rules of Professional Conduct exists. I'm gonna bet there's a good chunk of you that don't know that Appendix 1 to the Rules of Professional Conduct exists that set out the requirements for trust accounting, okay? Everyone has to review that. They have to know that when this comes in, if they get an $1,800 check, that's supposed to be costs and fees, that has to go into trust. The $300 comes off, that stays in trust, and the $1,500 goes into your operating account, okay? It can't go in to business and then even if it's the best of intentions. I have had clients tell me, well, yeah, I mean, I was gonna file the case the next day. Why do I have to put it into my trust and let it clear, and then I gotta do this and that? Yeah, well, that's the rule. And if you don't do it, the OLPR will, if given the opportunity, will most likely find it. And they're very good at doing that, I will tell you. Okay. And then the last thing is you have to have conversations. You have to make sure your fee agreements are abundantly clear about what is advanced costs versus advanced fees or flat fees, all right? Those things must be treated differently, and it must be clear, not just for this reason, but under Rule 1.5, just generally that's required. So flat fee agreements are the number one thing I'm seeing right now. I am seeing small firms get hit with so the definition for private discipline is isolated and non-serious. If you've been using a non-compliant fee agreement for 6 years, they may look at that, they may say, I don't know that we can do isolated here, right? And now you're looking at potential for public discipline based on this stuff. So hopefully that scared the heck out of all of you, and you're all gonna go back if you use flat fee agreements and take some time and review them. If you don't, I'll give you my card later.
All right, so Hansen v. CBS Construction. So this is a case where an employee was hired as a business development director of business development. The employee then agreed with the president of CBS to create a new entity to use to invest in different construction projects. So the attorney then joined them, the employee, the president, and the attorney talked about creating this other organization. That fell through, and eventually the president and the attorney created an organization. So that caused quite a dispute, and then the employee filed a civil complaint against the organization and the president, and the attorney ended up representing both the president and the organization. So what's important in this case is that the employee, the president, and the attorney had confidential discussions. So this discussion involved information about future operations, corporate opportunities, deal financing, participants, and the attorney drafted the operating agreement. So he was well aware of what was going on. So when the employee motioned to disqualify the attorney based on the conflict of interest, the court held that the lawsuit involved the same transaction. So this deals with Rule 1.9, which provides that the lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same matter or substantially related, which that the person interests are materially adverse. So in this situation, there was a conflict of interest.
So this is one of the ones I use to try and illustrate broader concepts, right? Which is, this is a case that the reason I thought it was interesting, it's actually just sort of a standard disqualification case, is that it illustrates a problem I'm seeing more and more, which relates to Rule 1.9 conflicts, so former client conflicts. I see it a lot in when people leave firms, right? So this one's interesting because you've got someone who is, sort of holding on tight to that role as well. No, I was just the company's lawyer, and didn't really realize who they were representing, right? And so that's one of the big takeaways from this is, you need to be abundantly clear about who you're representing and what the circumstances are. And if you think you've learned something that could be then in those prior conversations, right? You have you can't use that information against them in the future. Now, interestingly, you can do that with a potential client, which is kind of weird under Rule 1.18, which deals with your obligations to potential clients, right? There was a recent ABA formal opinion that allows you to, that says that it's permissible to explicitly state and have a written agreement effectively saying, before I represent you, we're gonna meet, you're gonna give me some information, but we agree that this is not confidential, right? And that this would not disqualify me, this meeting would not disqualify me from future representation of somebody else on a similar matter. Okay, so that's permissible. But once you sort of establish that, once there's an attorney-client relationship, which, hopefully we all know is not just contractually based, right? The tort-based standard to establishing an attorney-client relationship is, would a client essentially reasonably believe that you've provided them legal advice? This is the dreaded, cocktail party circumstance where, you're sitting there and they say, yeah, I need a lawyer that do this. You go, oh, I do that. And they tell you the facts and you say, yeah, well, look, here's the deal. Statute of limitations is this, you're fine, don't worry about it. Give me a call, we'll get this taken care of for you. And then you go on about for the rest of the cocktail party and then they think, oh, well, I've got 2 years to get this done. They don't call, their claim's gone, and they claim they thought you were representing them, right? So that's the thing. That circumstance with former clients happens too. And so that's when you get into these circumstances here where you've got former client issues. But the one that I've seen more and more now is we are in a weird time, in my opinion, in the market. There's a lot of lateral movement, right? There's people leaving firms, there's new firms coming into town, picking up entire sections of law firms and going over. And a lot of people take the position, well, if the lawyer did not work on the client matter at the prior firm, there's no problem, right? So firm A, lawyer was at firm A, moves to firm B, firm A represents a client, right? But that lawyer never worked on it. Then they go to firm B, and the firm says, all right, great, well, actually, suing on a similar theory the same, so why don't you just hop on that, right? Well, you can't do that. You can't do that. The fact that, first off, Rule 110 says that there's imputation of conflicts, all right? If one person in your firm has a conflict, we all do, right? So unless you get a waiver, they can't switch sides. They certainly can't switch sides directly, but even on something that's substantially related, so involves similar facts, it's not permissible. And I've had this situation come up multiple times this year, and it really arises most often from these lawyer movement scenarios, right, where they're switching firms, and these circumstances arise. So this is an interesting case. You need to be very aware of who you're representing, and when you're establishing an attorney-client relationship beyond a contractual situation, right? It's not just retainer agreements. So that's the takeaway and the scary thought of this one. I feel like this is like the pre-Halloween attorney scare fest, right? My job is to come here and sort of like tell horror stories around a campfire. But these are times where the lawyer honestly didn't think they did anything wrong, and then they're facing a disqualification motion in district court, and they lose, and now there's a decision with their name in it for the rest of their life about how this back scenario. So you want to avoid that.
All right, so in the case of Nielsen, this involved an immigration attorney who provided, through his paralegal, incorrect information to clients. There were 2 clients in this instance. Yeah. Yeah, is this better? Oh, great, now you guys can hear all my mistakes. No, absolutely. So there were 2 clients in this situation. Both clients were filling out immigration forms, and those immigration forms were provided by the paralegal, and the paralegal communicated that a qualifying relative could either be a spouse or a child under the age of 21. Both clients had daughters under the age of 21 and believed that a qualifying relative could be their daughter, which was incorrect. So this situation led to a couple violations. The first one being 1.4b, which involves communication to the client. The rule provides that an attorney must explain a matter to the client to the extent reasonably necessary to permit the client make an informed decision. So the clients were told that their qualifying relative could be their daughter, who was under the age of 21, which was incorrect. So they went ahead and filled out this form incorrectly. The second one is 5.3b, which provides that a supervising attorney is responsible for the conduct of their non-lawyer staff. Here, the attorney was copied on the email that the paralegal provided. So the communication did go through the paralegal. The attorney saw and admitted to seeing this communication, but didn't make any effort to correct the mistake. So then there is a 0.4c, which addresses the conduct involving dishonesty, deceit, or misrepresentation. So through the paralegal, again, the attorney misrepresented the fact that a qualifying relative can be a child under the age of 21. So there are a couple different violations in that situation.
So this leads to the new one new topic, all right, which I'm going to see if I can get us to this. Rule 5.3 deals with the obligation of supervising non-lawyer assistants, all right? This is a case, this Nielsen decision, is a case in which the attorney relied very heavily on their, this is a fact scenario I'm sure is resonating with many of you, relied very heavily on their paralegal to handle most of the intake and initial discussions in determination of client strategy, like, telling the client what the strategy was regarding a case, all right? And the paralegal was just wrong. It's just wrong. It was just not accurate. It is not a legally accurate statement that she made. And that resulted in because this was an immigration practice, and for whatever reason, this particular this law firm operated, the paralegals operated with, I would say, less oversight than was permissible, as is indicated by the Supreme Court decision that we're talking about. This continued over and over again, and what ended up happening is the lawyer ended up being disciplined severely for this, because you have to watch what your associates, or well, certainly what your associates are. That's Rule 5.1, right? That's Rule 5.1, so that's associates. And then 5.3 is your assistants and your non-lawyer staff. In the COVID and now permanent, effectively permanent remote hybrid world, all right? Most of the law firms I deal with have a dramatically decreased level of understanding of what their staff and associates are doing on a day-to-day basis. All right? They aren't meeting as frequently, they aren't communicating, they aren't doing updates, they aren't having the conversations that we used to have in the hallway, right? Or a break room or whatever it was, right? And as a result, I am nearly certain that these claims are going to increase because people act independently. This is not nefarious. It's not people trying to hurt anyone. They're doing what they think is actually right, but it's not. And because it's not, it's your license that's going to take the hit, right? These issues, I just saw a case litigated, participated in it for a while, that related to oversight of a trust account. There were problems with a trust account that resulted from a failure to oversee, and that went all the way to trial. And the issue that was litigated were the firm's procedures reasonable? Because under Rule 5.1, you have to make reasonable efforts to oversee what's going on for subordinate lawyers. Same thing here under 5.3. So if you are the managing partner of a law firm, that's on you. You could have nothing to do with the case. Not a thing, right? There was a case that got litigated and actually was overturned, not overturned, but the referee decided it was not a violation, about an associate's mistake in failing to file in the 1 year, you hip pocket serve it, and then you have to file it within a year, right? So the associate didn't know that rule and didn't file it. They litigated that. Now, in that particular instance, the referee determined that wasn't a violation for the managing partner. But I'll tell you what, that law firm probably spent six figures in getting that win. So I don't really think you'd call that a win, right? That's a loss based on the fact that the view that the OLPR seems to be taking now, and I think is going to become more and more prevalent in our remote world, right, is that you as the managing partner of a law firm have an obligation to actively monitor compliance with firm procedures, firm policies, to oversee the work of everyone, and if you don't do it and they screw up, that is on you. So I would, if you don't have, I've represented a number of firms. I've said, so what's your policy on remote work, right? How do you oversee remote work? And they said, well, we don't have one. I said, okay. So what happens with something goes sideways? What's your defense going to be, right? What's your defense going to be that they just went completely off the rails on a representation, right? An associate that you hadn't seen in 3 weeks come into the office. You didn't see them for 3 weeks because they weren't working. They were in the middle of a mental health crisis, right? And you didn't know, and all of a sudden things are getting missed. And there was no policy of the firm that someone had to check in, that we had to, review work. Those things will come back and they will hit you and this is the one time where it rolls uphill, right? Normally it rolls downhill, but when you run a law firm or you're a partner in a law firm, it goes, a supervising lawyer, it goes uphill. And so be aware of that, and you should be, especially if you're allowing, as we all, I think, probably are now, people to work remotely, you should have some policies in place, you should have some protections, you should be thinking about, when something happens, how am I going to show that I was reasonably supervising these people, right? So, yeah, please.
Somebody who's rolls uphill.
Yeah.
How do we do this? I mean, is there a structure where I say to my employees, you have to call me every other day and tell me what you're doing, or if you have any guidance?
Yeah, no, I mean, this is a good question, and the question is, how do you do this, right? And you know, thanks to lawyers, everyone in this room, we define everything as reasonable, which means it could be anything. But what I will tell you is the policies that we have in place at my firm, because we were, I mean, as associate general counsel, we were concerned about this during the pandemic, and thankfully we were able to avoid problems. But we have now instituted policies that require shareholders overseeing associate work to check in, you know, periodically, which I think we've defined as some number of weeks or something like that around cases, and then there's also, we have very clear policies about where things have to be saved. One of the things that I have seen in one case is we had an associate who was saving everything offline because they were having trouble using whatever their system is, right, for documents. And so all these documents were offline and available only on his desktop. And so one of the policies that I suggested in that circumstance is you have to have a policy that says every piece of work product must be saved to whatever your firm's document management system is, so that, God forbid, something happens to that person, the work can be picked up by somebody else and move forward. There isn't a loss of work, all right? And in that case, there was work that was billed. There was a mental health problem for the associate. Associate has to go and get help. There was work that was billed, that was done, but was not available to the firm. So the client paid for something that had already paid for something that that was not in their benefit. That is not a good fact pattern for anybody, right? So again, it's the idea, these are the kinds of policies you have in place. You want to talk to one of the things, I don't know if you have, for those of you that have associates, I personally check in with the associates on my files at least every week. And it's a lot, I know, and it's a lot of time. And it's usually, by the way, not billable for both of you. So someone's got to eat that, right? But that's just the kind of stuff that you have to do if things are happening in your case. This dovetails, it's a slight diversion, but I think we've got plenty of time. A slight diversion, these issues dovetail with the mental health, the lawyer wellness issues that we've been seeing. As you guys all know, and I think we talked about this 2 years ago, the Supreme Court issued 2 or 3 years ago, sort of a call to arms, if you will, about issues of lawyer wellness. I am seeing mental health, substance abuse, stress management, just breakdowns in 40, 50% of my cases now. And it is isolation, it is pressure, it is all of the things that always existed before the pandemic, but now you don't know they're happening because you never see these people. You don't see them when they come into the office and they're just red-eyed and, and lethargic and unable to work. You don't know that because they're working from home 3 days a week, right? So, if we're going to move towards, and I don't think we really have a choice, I think the market has pretty well told us that remote work is going to be here in some form for most of us if you want to recruit. These kinds of policies of being in the office some amount of time, interacting with shareholders, having policies about document management, stressing the importance of oversight to your shareholders and your supervising attorneys are all things that you absolutely have to have. And just write them down. I mean, the fact of the matter is, you're going to want to have things written down, right? The idea that we have a de facto process here for these things, with the 5.1, 5.3 issues I'm seeing come up, my advice to every law firm is write them down. Have a policy manual. I know that seems impractical, but I'll tell you what, when I get involved, you're going to want that, right? You're going to want me to have something to defend you. Because otherwise, if the answer is, well, we've just had this practice, and it's me and an associate and 3 paralegals, and we've always just done it this way, and if the OLPR investigator talks to 2 of those people and they don't line up, right, on what the policy or practice has been, well, that's not going to be good for you. So write them down, talk to people, and implement them. So yeah, that's the Nielsen case. And I'll tell you, this case, you know, this is a really pretty standard case. This is not a, oh my God, situation. This stuff happens all the time. And so I apologize to Mr. Nielsen, who's getting stuck being the exemplar for this, but I've seen 4 or 5 of these in the last 12 months. There we go.
All right, so one of the hot topics that we'll be discussing today is in relation to attorney-client privilege. So December of 2021, the Supreme Court of Minnesota adopted the predominant purpose test, which is for assessing whether attorney-client privilege protects a document that contains both legal advice and business advice. So briefly, the background of this case, Polaris recalled a line of ATVs for potential fire hazards. When the U.S. Consumer Product Safety Commission launched an investigation, Polaris retained an attorney. They retained an attorney to conduct an audit of its safety policies and procedures. This attorney and the team created an audit report. That audit report provided recommendations in safety, engineering, design, corporate practices, so touched different areas. The audit report was marked privileged and confidential. Fast forward to a year later, Polaris was sued by a consumer who was severely burned by one of these recalled ATVs. Polaris inadvertently produced a copy of this audit report during discovery. They were unsuccessful in clawing it back. And the question was, is this audit report truly protected by attorney-client privilege? So in determining this, the Supreme Court considered the fact that the audit report was discussing design, engineering, other practices, with the goal of improving the process Polaris uses to assess safety risks. One of the discussions was that there is a difficult line drawn between business advice and legal advice in certain situations, because often attorneys rely on their experience, on their expertise to provide business advice. So it's hard to make that distinction. Ultimately, the Supreme Court said, well, we need to consider quite a few things. So consider the purpose of the report or the document, the content, the context in which it was communicated, the recipients, whether the legal advice permeates the document, or whether any privileged matters can be redacted. So this is a critical point as well, because even though it may have legal advice in it, that doesn't mean that the document in its entirety can be privileged, can be protected. You would then move forward to just redact those legal components of that document. So again, ultimately, the Supreme Court in this particular case held that the primary purpose was business advice and not legal advice, because it took practices and policies and to determine whether they were compliant or not. And they truly did emphasize the redaction component of these situations.
So when this case came out in December, our firm sent an email to everybody and said, read this immediately. And the reason is, we're a defense firm, right? We represent a bunch of big companies, insurance companies, we do trade secret litigation, we do non-competes, we do all types of stuff, right? And now, I mean, thankfully, our practice has always been to redact as much as possible because it just reduces discovery fights, right? And we've always, I think, thankfully, applied what is effectively the predominant purpose test. But we very frequently would see in cases, and our firm does some work on the plaintiff side too, just the wholesale withholding of documents that are hybrid business legal, right? And what this case says is you better be pretty careful if you're just going to mark that whole thing as privileged and not redact it, all right, and produce it as on a redacted basis. And this puts lawyers and I think in a tough position in the sense. One of the reasons why I wanted to talk about it, not just because it's important and you all should know about it, because for those of you on the plaintiff side, this is awfully helpful. For those of you on the defense side, this is a risk management problem for you, right? Again, you're not watching which associate's putting together your privilege log, and all of a sudden you get a sanctions motion because there's a bunch of documents that were withheld entirely because the associate didn't know about this, and you hadn't told them about it. That sounds pretty familiar to a fact pattern I just talked about, right? Things that you gotta make sure your associates know, make sure your paralegals know if they're doing them. This case, I think, is one of the bigger decisions that's come out for anyone who does commercial litigation in at least the last 4 or 5 years. It's a huge decision. It fundamentally changes the way that attorney-client privilege procedurally is dealt with in district courts. And so it's a weird case. It has a very odd procedural posture. Olivia did a really good job of summarizing what the predominant purpose test is. Good luck trying to figure that one out, right? It's like, well, okay, well, is it predominant meaning what? Is it 50.1? Do you have to create some sort of a spreadsheet and aggregate the amounts and words and which was what? No, I mean, that's the problem, right? It's going to be hard, but you're going to have to make a good faith effort to comply with this if you want to avoid sanctions motions for improper withholding of documents that should have been produced as redacted. And so I think this is a huge case, and I think it's a really important one for everyone to be aware of. Also, one thing that it does brought to mind is the issue of inadvertent production. Who watched any of this sort of the Alex Jones trial stuff, right? And that lawyer effectively produced text messages, privileged text messages, during trial, and my recollection is didn't even really attempt to claw them back afterwards. That person is screwed because those were completely used or absolutely unquestionably used to the detriment of the client, right? There's a bunch of ethics violations. It is in my opinion, I'm not gonna, I wasn't involved, and so let me disclaim everything, right? But there's a big asterisk right here when I say this. But to me, it's like, well, let's see, you've got a negligent act that caused damage. Got pretty good shot at taking a run on that one in the district courts. So I think that one of the things that you really have to be aware of when you're doing any case that's got text messages, heavy email use, is inadvertent disclosure. You should be QCing your productions. It costs more. It costs more, but we have a second level review on pretty much every document production that goes out the door if it's in any level complex. If there's anything more than 500 documents, we're doing some sort of second level review to try and make sure, whether it's 10% or whatever, to try and make sure that you're not having these inadvertent disclosures. Because this wouldn't have come up if the counsel hadn't turned the document over by accident, right? This whole case doesn't exist. This decision does not happen if there wasn't an inadvertent disclosure by somebody during the underlying litigation. So there's my scary statement for that one. You want to talk about the rule a little bit here?
Sure.
Go for it.
So Rule 1.15, let me just grab my notes here to make sure. So this goes back to one of the cases that we talked about client funds being, client funds within connection with representation must be deposited in identifiable funds or identifiable accounts. So this goes back to whether it's in the business account or a trust account. So to be compliant with the rule, the lawyer must withdraw earned fees within a reasonable time. So the key in here is earned fees, right? So if there are advanced fees, you can't withdraw any of that amount until you have earned the fees. Also, provide the client with written notice of the time, amount, and purpose of the withdrawal and accounting with the client's funds in the trust account. So this goes back a little bit to an earlier rule, which is communication. You have to communicate with your client what you are doing. It's not about their case necessarily, but you do have to communicate about their fees and what they have, what you have processed as an expense. So just transparency is important with this one.
And the reason we're talking about 1.15 is, in addition to the fact that it dovetails with what we talked about earlier with the Majors decision, I've had a number of cases recently that involve inadvertent overdrafts of trust accounts. And they almost always are bank errors, right? Just bank screws up, pulls it out of the wrong account. I hope most of you know that when a trust account overdraws, there is a requirement that the bank notify the board, the OLPR, and the OLPR initiates, as a matter of rule, an investigation, all right? If you don't have fully compliant trust account records, which are substantially more complex than you probably think they need to be, but they subsidiary ledgers, all of these trial balance reports, a written memoranda reflecting electronic transfers from your trust account, right? So you earn fees, you would electronically push them out of that account into your operating account. Appendix 1 requires there to be a written memoranda of some kind. Now that can be an email that says, authorizing lawyer says, please transfer X amount from the trust account in this subsidiary ledger for services performed, approved by the client, right? But if you don't have that, you're not compliant. A lot of my clients, when I tell them, they don't realize that you can't have more than $100 in your trust account of firm funds, that, right? So if you can have $100, up to $100, as essentially a buffer, just in case there's something like, and to cover things like checks, right? Check expenses. If you don't pull your earned fees out within a reasonable period of time, you're going to exceed that, right? And you're now commingling firm funds with client funds. That is a violation. If something happens to some of those funds, that could be negligent misappropriation. Negligent misappropriation, thankfully, is much less than intentional misappropriation, where, Mr. Majors got the lowest I've ever seen. What was that, 3 months? Majors got 3 months, but he had to litigate the thing. So he spent months, I've litigated these cases, months, and if he had counsel, tens of thousands of dollars to get a 3-month suspension, which frankly, when I came out, I was floored. It's the lowest I've ever seen. And one of the reasons, by the way, that he was able to get 3 months is he was retiring. He was retiring. So, unless that's your fact pattern, you're probably not getting 3 months. So the point is, all of these things are to show you these technical components that you're like, oh, well, that's just a technical rule. Unfortunately, there's no such thing as a technical rule. It's a rule that must be complied with. And so if you have fear about your trust accounts, call an ethics lawyer, call an accountant who's got experience dealing with trust accounts. By the way, a lot of CPAs that I've dealt with, because I do a lot of trust account work for the firms that I represent in trust account investigations, a lot of the CPAs don't really fully understand the trust accounting requirements, right? They apply normal accounting principles. That's not their fault. They're just weird. It's a weird subset. So you really want to look at and find somebody who's got an experience dealing with it to ensure that your stuff is compliant. We had a case not long ago where an attorney passed away, solo practitioner, suddenly. Really sad, right? So we get brought in to try and help because they're trying to figure out what the hell to do. And the trust account hadn't been done, really had anything done to it. They hadn't really reconciled it in years, right? So now you're having to go back and recreate that stuff because there's clients that need refunds. There's former clients that need refunds. There's amounts of money that you don't really know where it comes from. It might be firm fees. It might not be firm fees. There might be a client from 4 years ago that's sitting there, doesn't realize that they have $500 coming from, right? So I think you guys can all see why that's a problem. So this is my scary statement about trust accounts. That is, I think that's it for us, but I'm going to talk for 6 more minutes in order to make sure we get, is that about right? 5 more minutes? What do we need?
No, you guys stopped early last year
Did we?
and gave us a full hour.
Oh, all right.
Can I ask one more question?
Yeah. Yeah, there we go. We'll take that.
More and more, I'm a plaintiff's lawyer.
Yeah.
And more I'm seeing diversity in my clientele.
Mhm.
I mean, people who aren't here are first generation
Yeah, right.
Americans, and they don't speak English.
Yep.
It's impractical to get a translator for every time I want to talk to them. So I end up most often talking to their teenage kids who are in school and know how to speak English.
Yep.
And then they translate for mom, and mom gets back to me.
Yep.
And, are there ethical problems with doing that?
So that's a good question. And the question is when you've got a client who's maybe first generation doesn't speak English very particularly well, or at least needs assistance in understanding the concepts and the legal advice being provided and giving you the information. Is there a problem with using, say, a teenage, a child or a family member who might be able to assist in translation? So there is some case law that says that as long as the intention is to keep those privileged, right, those communications privileged, and there's a discussion essentially that what the purpose here is that this person is translating and assisting the client in understanding the legal advice and providing information necessary for the provision of legal services, that's still privileged. Same thing with, there are exceptions under Rule 1.6 for disclosure of information, right, confidential information. The important is being intentional about it and talking about it. Never presume that everyone understands how this works. Your first discussion where this happens is there's going to be a discussion with both of them that says, you're here for this purpose. Everything I'm telling you is a privileged communication. It's incredibly important that you and your parent understand that we don't have a conversation about these issues absent a lawyer. These are supposed to be kept confidential, and you have to kind of have that conversation with everybody. So that there's the intent element of the privilege is maintained. And I do see that a fair amount. It is a really common problem, but the case law is clear that you can use, well, I shouldn't say clear, no, it's never clear, but there is case law that says that you can use third parties who are not like official translators for the purpose of the client understanding legal advice. Yeah. Yes, sir.
I want to go back to imputed disqualification for lateral transfers. As I read the changes that have been made in 1.9, it seems that they added in this qualification that if I go to a new firm, I'm only disqualified if I have actual knowledge of confidential information. There's a comment in paragraph 5 that says the firm isn't disqualified and I'm not disqualified unless I have some information from my client.
Couple of things to know about that. The Minnesota Supreme Court has determined that the comments are not authoritative. So that's one thing. The second thing is you should just screen. I don't think the firm would be knocked out, right? The issue is that there's a screening mechanism, because the fact of the matter is that unless there were restrictions within the firm, there's no real way to know whether confidential information has been disclosed. And so what I would tell everybody, and what I do in my cases, when we have people come in from firms, we automatically screen them. In doing that, it eliminates any threat, right? Any potential question, and it complies with the way that I read 1.9A and 110 as they work together. I agree with you that there was a change. I know, and trust me, I'm aware of that. But that is an issue that is really hard to, who do you ask? What do you say? The associate says, yeah, I never heard anything about that case. I have no clue. I never looked at the file. I mean, it's really hard to confirm that, right? And I think a client has a reasonable basis to say, well, that's concerning to me, when they've switched firms. So I think you just put up a wall and no issue at all at that point then, and there's completely risk-free. Any other questions? Otherwise, I think we're dead on. All right.
So with all the things we read in the newspaper about the lawyers board, has that impacted from your perspective how they're doing things?
Yeah, it has. I mean, the turnover has been incredibly high. I mean, it's not uncommon for me to have now gone through 3 or 4 investigators on a file before it's done. I have really good working relationships with the folks at the board, at the OLPR. I've got a good working relationship with the director. I don't really have any opinion as to her efficacy or anything along those lines, but I will tell you that the turnover has been incredibly high. And it has impacted operations. I think resolution of complaints is slowed. I just tried a case where the underlying acts were 4 years ago. That's tough. I mean, we had a witness die in that period, right? I mean, it's that long. So those are. I think it is slowing things. I think it is making it difficult to get. I think it's also making it harder to get consistent resolutions because there's just isn't as the institutional knowledge isn't really there. I think the director's doing the best she can with the facts, with the circumstances, but it's been it's slow. It's really slow. I tell my clients now, you could be doing this in 18 months without any doubt. Like this could be resolved in 3 months. It could be resolved in 2 years, and it could be resolved in 2 years with a complete dismissal, right? With no public anything. So it's not just that it's the bad cases that are taking forever. So, yes, sir.
One of our listeners, viewers in our remote audience, just to prove they were listening, said, please ask Aram to correct something he said. Lawyers are allowed to keep a nominal amount of $200 extra.
Oh, 200, that's right. You're right. Sorry about that. You're right. It's 200. Yeah, I apologize.
Jeff Stolman out there, and I
No, you're right. Thank you. All right, I'm willing to admit when I'm wrong. But yeah, but still, 200 is. Yeah, right. Don't go over that. When you get the I've had $1,500 sitting in my trust account because I just thought, hey, we want to make sure it doesn't overdraft. That's the problem. So.
And I just asked Jim while you were talking. I said, do plaintiff's lawyers actually know all this stuff? And he assured me they do.
Yes.
So it turns out he's right.
Yes.
I assured him that I have people who work for me.
And you're adequately supervising them, of course. Right, exactly. So, all right. Any other questions, or else we can call it and be exactly on time within. All right. Thank you very much, everyone.
Okay, next up is a former sport coat recipient, Shane Hammond, one of our frequent flyers here, always does a great job keeping us up to date on the happenings in the no-fault system. Shane is a partner at Arthur Chapman, who I'm sure you all know. Also, Shane, one of our viewing audience said make sure that they repeat the question before they answer it, which I thought we were doing a pretty good job of, but just as a reminder. Don't forget to put your card in the Viking drawing if you're so inclined, if you're willing to go to a Viking game. Should refrain from commenting, but go Gophers. Here we go.
morning, everyone. I'm here to deliver kind of a light topic after talking about, you don't have him? Okay, well, I'll just start talking anyway. A little lighter topic, right? We've talked about kind of heavy, dense topics that kind of make us sit at the end of our chair and wonder if we're kind of monitoring all those people in our firm, those who are working on our cases. So hopefully the next 20 minutes or so will be a lighter topic. Brett always tells me, make sure you're kind of neutral. Don't give too much defense side stuff away. Don't give too much claimant side stuff away. So while they're pulling up my slides, I would encourage all of you to take out your smartphone, right? We've all got them here, right? We've probably all checked them. How many of you have gone on the AAA website and looked at, the no-fault portion of the American Arbitration Association? A few people, good. There's some interesting information out there, right? You don't probably want your name on there, but there are a couple people who have kind of violated some of the rules, and the conduct has arisen to being publicly reprimanded. Some kind of notes from, I talked to Krista Peach and Kelly Baker, who run the AAA. The AAA was the only arbitration services organization that submitted a bid in the spring of 2020 to re-up for administering these claims. And they've been the only arbitration organization that has administered these claims. And I think, some of that provides continuity, right? We know who these people are. We know what these systems and procedures have in place. So I think that helps all of us do our job. But remember to copy the case administrator on all emails. I know most of us say, gosh, you've probably told us that before, Shane, right? But I can tell you the fair number of cases I have, something happens and someone isn't carbon copying the case manager needs to know what's going on. If you're an arbitrator and a hearing is left open for additional records or bills or parties to comment or make an argument on something, let the case manager know, because that differentiates and determines when the award will be due. If you're the arbitrator, make sure that you complete all the hearing record information, including the claim amount. Make sure your math is correct. Back in the old days, we used to fill out a form and then fax it, email it, mail it to the case manager. They would type it all up, send it back to us, and we would proof it. So gone are those days. So just make sure that your math is correct, and everything should be more streamlined now, especially since COVID and most things are happening via Zoom and electronically. You can fill in these forms, create it into a PDF if you want, email it back to your case manager. Another reason why I asked you to take your phones out, for those of you who are arbitrators in the audience, there is a AAA application. How many of you have it downloaded? Anyone? Jody. So yeah, you can download the Panelist eCenter mobile app. So this will allow you to access your cases. If you're running late for a hearing or you're having Zoom technology issues and you're hosting the hearing, you can reach out to the parties, because that information will all be in your Panelist eCenter, and it's all at the ease of your mobile app. And it's available, obviously, through Google Play and the Apple Store. And I did have a slide of what it looked like, but if you just, it's up now? Okay. So there's what it looks like. So very, very user-friendly, intuitive, allows you to kind of move forward with your cases kind of wherever you are. Another thing that AAA kind of reminds you about is gone are the days of kind of snail mail checks, right? Mail is slower these days. It takes longer to get things. So if you want to be paid quicker and you're an arbitrator, sign up for ACH payments. Then you'll receive that payment quicker. If you need that form, it's on the AAA website. And so very easy to get to. Filing fees, they've gone up. Sometimes I'm not quite sure why things have gone up, when you'll see in a few slides the number of cases filed has significantly gone downward. There's a downward progression since about 2013. But claimants' filing fee is $50, up 10. Respondents' filing fee is up to $200, up from $150. So some additional changes in the fees. I'm going to talk a little bit about motions. How many think the AAA process for motions is a bit cumbersome? Yeah, it's a little bit, back and forth, not as streamlined probably as the court system, right? You have a meet and confer, you have a phone conference with the judge, you might submit some letter briefs, 1 or 2 pages, quick emails, things of that nature, you try to resolve it. So I would encourage all of you, if you have a discovery dispute, try to work it out amongst yourself, because the problem is this process is so cumbersome. So if Mark Malzahn, who's checking out that Panelist eCenter app, and I have a discovery dispute, we have to meet and confer about it. We have to talk about it over the phone. We have to exchange emails. If we can't agree, I advance my motion. I deposit my $150. Then when Mr. Malzahn replies, he submits his $150 and his motion. And then the AAA sends everything to the arbitrator. The arbitrator makes a decision and then determines who's going to pay his fee of $100, and the AAA gets $50 for the administrative aspect, and then whoever doesn't have to pay is refunded that money. So there is a lot of back and forth. And I was on the AAA Standing Committee when this was put forth, and there was a lot of collaborative discussion about it. And I think kind of the intent was, we hope most of these people can work through their discovery disputes, whether they're pertaining to an examination under oath, an IME, different discovery materials that someone wants, someone else doesn't want to provide. And so we intentionally kind of made it a little bit more difficult. But just kind of keep that in mind when you have your discovery disputes. If you end up paying, having to pay the $50 administrative fee, and then you want to advance it back as, say, a counterclaim in a portion of your case if you're the respondent attorney, or tack that on to your case if you're a claimant attorney, you can do that under the rules to try to get that cost-saving measure back. And I think that's another avenue for parties to hopefully, come to the table and find a resolution or an agreement, so they're not going to the arbitrator and requesting a motion. The updated arbitration petition form, so this was updated obviously because of COVID, and it was updated because a lot of hearings are not going forward in person, so some of the information does not need to be in the electronic form anymore. But on those electronic forms, obviously, you get to select, do you want it telephonically? Do you want it in a video conference format? Do you want it in person? Do you want it documents only? I do see plaintiffs' attorneys, claimants' attorneys checking off telephonically and video conference, and I think that was done initially because letting the other side know, or letting the AAA know, we're fine with telephone, we're fine with video conference. Now the petition form specifically says, just choose one. If you choose more than one, we're going to default and think your first choice is telephonically. So just make sure that you're adequately filling out the form. And then on the back of the form, because it is a requirement to make sure that the insurance company who you've listed as the respondent has received adequate notice of that petition, that you indicate how you provided that information to that adjuster at an insurance company, whether it was through email, through mail. If you look on the AAA website, they do have a list. Certain insurance companies have designated one individual to receive all of those claims. So I would encourage claimants' attorneys, check the website before you're filling out your petition or having your staff fill out your petition. Some more of what I just talked about. The other thing I'm going to talk about too probably dovetails and kind of is in line with the heavy discussion we had on professional responsibility. But the AAA and the No Fault Standing Committee really looks at arbitrator disclosures. And the new arbitrator disclosure form was implemented probably 4 or 5 years ago. And I think that it warrants me reading it again, because I'm going to go over some recent scenarios that I've had that I'm kind of bewildered as to why these arbitrators accepted this case and then kind of wasted the parties' time only to be removed and another arbitrator appointed. But the rule says no person shall serve as an arbitrator in any arbitration in which he or she has a financial or personal conflict of interest. Under procedures established by the Standing Committee and immediately following appointment to a case, every arbitrator should be required to disclose any circumstances likely to create a presumption or possibility of bias or conflict that may disqualify the person as a potential arbitrator. And this is it's an active, ongoing disclosure. So if you find something out during an arbitration hearing, don't wait. Go ahead and disclose it. Regularly update your arbitration disclosure. It's fairly easy. Send a quick email to the AAA, hey, since I completed my last arbitration disclosure form pertaining to this case, here's some new and updated information. It might be significant to the case, it might be significant to the counsel, it might not. Don't wait is the kind of underlying message. Here's some common scenarios. A couple of these I've seen this week. 2 arbitrators on 2 of my cases were removed. One, the arbitrator was sharing a fee with the claimant's attorney on a file. So I commend the arbitrator for disclosing that. He was sharing a fee. But then he said, I can be fair and impartial. And I said, well, wait a minute, how can you be fair and impartial? You're violating Rule 10. Claimant's attorney says, well, the rules are in place and the arbitrator has indicated that he can be fair and impartial. Well, the AAA removed that arbitrator, appointed a different arbitrator to hear that case. So in my mind, I was thinking, why did this arbitrator kind of waste the party's time on this? He should have said, listen, I've developed a conflict. I can no longer hear this file, hear this matter, told the AAA case manager, and the AAA case manager could have appointed the next arbitrator. That didn't happen. Related to one of the attorneys on the case, I had a case recently where I didn't know this, different last names. The arbitrator was the cousin of the claimant's attorney. So he disclosed that, but then said, well, I can be fair and impartial. Yeah, personal conflict, family conflict. Probably should remove yourself. Just don't even accept the case. Having represented a medical provider who has medical bills in dispute, and you have germane knowledge about how that company functions, how that company decides how to bill medical providers. You've handled intimate cases for them, not just ABC Chiropractic refers a file to John Doe for an injured individual. That's a different scenario. I've had cases recently where a claimant's attorney who is an arbitrator said, oh, well, I previously represented the claimant in this lawsuit, but I think I can be fair and impartial. And you laugh, it's a lot of this stuff we sit and chuckle, right? But I'm standing up here telling you that, either people have shown me these particular conflicts or I've been a part of them. So I think when you're filling out those disclosure forms, just take the time that you need, disclose the information that you need to, and if there is something like a family connection or you're sharing a fee with someone, just tell the AAA I've got a conflict, I cannot be appointed as the arbitrator in this case. Then they move on to the next arbitrator. You haven't wasted anybody's time. Same thing goes with, we're a small legal community. If you've talked about a case with somebody and you've got intimate knowledge, you shouldn't serve as an arbitrator because we want arbitrators to be fair and impartial. Same thing goes for arbitrators who have gone through a hearing. Even though you've been appointed and you've heard a case, arbitrator complaints are a little bit on the rise, and sometimes that's because all of us are so familiar with stuff. So you have to make sure that you're procedurally handling the case. If someone wants to give an opening statement, allow them to give an opening statement. If someone wants to, belabor a certain point, ask one more question, let them do that. Because arbitrator complaints are a bit on the rise as far as not allowing parties to complete, whether it's direct examination, cross-examination, things of that nature. So the arbitrator complaint form is a 2-page document. You can find it on the AAA website. Generally, these complaints arise after an arbitration hearing, because of some sort of conduct that happened. What happens when there is complaint is the AAA and the No-Fault Standing Committee will appoint usually a 3-person panel to investigate those complaints. Someone will talk to the claimant's attorney, someone will talk to the respondent's attorney, someone will interview the arbitrator as well. They compile, all of their information, put it into a memo format, it goes to the committee as a whole, and there is a vote as to whether or not there should be some disciplinary action. Is it private discipline? Is it public discipline? You can look at our website and see, like I talked about earlier, those who've been publicly disciplined for, things that may seem minor to some of you, some that may seem fairly major to some of you. It also goes with, your disclosure forms that you fill out, keep those up to date. But it also goes to, each year you recertify as an arbitrator, right? Make sure that you're filling out the components of your practice. If you practice 100% plaintiff's personal injury, indicate that. If your practice has scaled back to, gosh, I only do 50% now and I do 50% wills and trusts, make sure that you're also indicating that so the parties who are selecting you know what your background is. Because one of the arbitrators who was publicly recommended kind of just haphazardly filled out his certification form and it wasn't accurate. And he was caught by one of the parties. So if you do this, you allow this process to continue, right? We like this arbitration process. These no-fault arbitration claims run much smoother. We've been able to continue on despite COVID, right? Some jury trials that we have in court cases in different counties are, at a standstill or are now finally moving forward. But no-fault arbitration hearings, we kept on going, right? Maybe there was a week or two lag after COVID, and then we jumped on with Zoom. So it's really allowed the process to move forward. Any comments regarding opinions that you may have about what a particular insurance company does or what a particular medical provider does? Keep those to yourself. I primarily handle defense-related claims, so don't tell me you don't like it when an insurance company retroactively suspends benefits, or that you don't like Dr. Nipper's independent medical examination reports, and when you've read one, you've read them all. To certain individuals, that could potentially be something of a relate to a bias matter, and that's what we want to avoid. Qualifications to be an arbitrator. This has changed a little bit. It used to be 1/3 of your practice had to be within the personal injury arena. Now it's 1/4. Over a 5-year average, 1/4 of your practice has to be in the personal injury arena. Or if you are actively practicing, not actively practicing, but have an ADR practice, 1/4 of your ADR practice has to be within the no-fault arena. You have to have practiced at least 5 years in this state. So if you come from a different state and you've practiced there for 20 years and, Wisconsin, and now you're in Minnesota, you have to be actively practicing here for 5 years before you can apply to be an arbitrator. You have to complete the AAA standing committee's approved arbitrator training. You have to have at least 3 CLE hours within your reporting period. So me up here speaking would be about that. You'd get about 20%, you'd be 20% there. And then arbitrators are required to certify each year. We've streamlined that process. So you're certifying prior to the end of this year for next year. They used to kind of do it more on a rolling basis. So now, just make sure you get that certification in prior to 12/31 of 22. Otherwise, you'll have to reapply. Now I'm going to go through some statistical data, so some color-coded slides. So, this illustrates the number of arbitrators on the panel. I don't think it's probably any surprise to either claimants' attorneys or defense attorneys. 74% are claimants' attorneys, 25% are defense attorneys. 1% can claim that they handle equal amounts of claims for both sides, and I think that's probably more in outstate Minnesota. So based upon that, the number of arbitrators, so you've got a little over 300 arbitrators total. Looking at the statistical data, maybe 2-3 years ago, lots of people were applying to be arbitrators. It seems to have gotten, kind of dovetailed downwards from that. So if you want to be an arbitrator, the information is on the website. The AAA and the standing committee would meet in January. So just make sure you'd have your information in. Popular hearing locations continue to be, Twin Cities metro area as far as where arbitrators are pooled from. Eagan, Minnetonka, Roseville, probably no surprise there. Same thing with outstate Minnesota, St. Cloud, Rochester, Mankato, Duluth. The next slide is fairly interesting. You can see in 2013, there were about 7,400 arbitration petitions filed. And you can see it's steadily gone down to, in 2021, there was about 3,500. So we don't really know what that is, if more insurance companies are paying up bills, or attorneys are adequately able to settle those cases prior to going to an arbitration hearing, but you've continued to see the decline, and that has also corresponded to, we don't have quite as many case managers as we once did, but those numbers continue to decline. The next slide shows, just kind of a compilation of how many hearings are going forward. They're kind of, almost 50-50 phone versus video conference. Some are going forward in person. I think since COVID, I've had one in person. The claimant was blind, so we had to go forward in person. So, kind of absent those special circumstances, most of them are going forward kind of in that virtual format. And that has made probably all of our lives easier in that you're not traveling. You can get all the parties on fairly quickly. The next slide shows, it's probably a little bit hard to see, but just kind of medium and maximum awards between wage loss replacement services, medical expense benefits, and it's kind of hovered around that $7,000 average award for kind of medical expense benefits. So there hasn't, despite the number of cases that have gone down, when cases actually go to an arbitration hearing, that's about the median size of the award. And you can see there's obviously numbers that are higher than that, numbers that are lower than that, depending upon how much coverage is available when you filed for arbitration, how much care and treatment occurred after you filed for arbitration. And then the last slide I have talks about, the number of cases that went forward as far as how many were settled versus how many actually went to the arbitration hearing. And you can see that those two numbers, that 45 and 46, they're almost 46, and they're almost exactly the same, 45.8 and 46.51. Half the cases, once they're filed, go to our arbitration hearing, and the other half settle. So that's what I have for statistical data, and I'm around if you have any questions, or I can take any questions now. And my friend Jim Carey always has a good question for me.
Since you were expertly trained at my law firm as a law clerk, I've had many good questions for you. I have been doing this for 35 years now. I'm an arbitrator often. I'm still on the panel, and I enjoy it. But there are occasions where the issue is pretty straightforward, and it's reasonableness and necessity. And I've had plaintiffs' lawyers, claimants' lawyers, and respondents' lawyers who want to talk and argue for 45 minutes on something that seems very apparent. Am I going to get spanked by the AAA if I tell folks before we begin that they have 20 minutes to give a closing argument? Is that a no-no?
Do you want me to repeat the question?
Sure.
Okay, so Jim had a question for those in the on the live stream about he understands the process of no fault. He's been doing this for 35 years. He understands the standard reasonableness, necessity, causal relation. Is he going to get in trouble by one of the parties if he says limit your question or limit your arguments to 20 minutes? The answer is kind of a slippery slope answer. Yes and no. I would say it's know who the attorneys are on the case. I think if arbitrators come in and say, I have read your statement of the case for both sides, I understand the issues in dispute, I've read the independent medical examination, I've read the narrative report of, Dr. Smith, I understand that, claimant was involved in a motor vehicle accident and she went on to have a low back surgery, and there's a question as to the reasonableness, causation, and necessity for this. I think you've set out at the outset for the parties that you understand what's going on with the case. You know, so in that particular situation, you'd probably be fine saying, you know, limit your closing arguments. I do have attorneys, arbitrators on my cases will say, you know, go ahead with your closing. Here's the 3 things I want you to hit. I want you to talk about, you know, causation, or I want you to talk about, you know, why your IME report is more solid than Dr. Smith's narrative report. So I think if you, you know, streamline it into, here's the areas I want you to focus on, you're fine. If you've likely given them an opportunity to make an opening statement too, that's another opportunity for them to present their side of the case. I think a lot of times it comes with maybe newer attorneys who are less experienced with the process, and maybe they're working under someone who says, okay, you've got to make sure that you say these 5 things. You know, obviously, if you've got a court reporter there, there might be some additional concerns there to put more information on the record. But every case is different, so use your best judgment would be my recommendation. Yep. Anyone else? All right, thank you so much.
Okay, so hopefully everybody is, I know they were still here when I put this list together. We had a little drawing out in the hallway. Tattersall Distillery in, used to be northeast Minneapolis. Now it's in River Falls, Wisconsin, because we should have taken this up with our reg folks, but they don't allow Minnesotans to produce enough alcohol, apparently, so they had to move their operation to Wisconsin. But it's a really cool place over in River Falls if you want to go over there. Tattersall, they have a really nice setup, great dining and so forth. Plus they donated 6 bottles of hard liquor for us to give away. So that's always that's a win-win, right? And we had a drawing out in the hallway, and there's no favoritism here. This is just how it worked out. Danielle Bird. So you want clear liquor or brown liquor? All right, 1 clear for Danielle. And you can go out and get it. It's out in the hallway there. Lindsay Carpenter. Clear liquor, I assume, or brown liquor? Clear it is. Alex Klein. A first-year attendee here and a member of the Cousineau firm that's one of our most solid customers, so we're happy to pull him out. Tim O'Connor. Brown liquor, I assume, right? Yes, sir. Out in the hallway. And I don't know about you, Alex, you better get out there. Brian Stoffern, because I know Brian, we already cleared with him, he does drink hard liquor, so he may have already captured one of those brown liquors. And Chris Villione, last but not least, you're the winner of either brown or clear, whichever left as soon as you get out there. So have at it, all right. Congratulations, and on to Jim. There we go. When Marty Cole used to come here to do the ethics, we asked him specifically, is it okay to give away liquor at this thing and still not have to worry about there being some ethical violation or some issue? And his answer was absolutely, as long as you don't open it. So this is all good. Nobody has to wonder, geez, I wonder why they're doing that. Are we in trouble here? So according to Marty Cole, who was the director for a long time, we're all good. All right.
Oh, Brett, you better put that bottle under your table out in the car then. Our next presenter, and as long as we're in the mood to give things away, is also the recipient of the Woman's Blazer that one of our vendors is giving away. And Not Standard has been a presenter here at our event for many years. And Melissa Stahl has been a speaker here for many years from the Sewell and Stahl law firm, and I am happy to have her come and speak to us about products liability issues. So Melissa, you want a jacket?
Thanks, Jim, and thanks for the jacket. As Jim said, I have presented at this the last few years, and I used to give a hot topics and products liability presentation, and for those of you who practice in the products liability realm, there are not a lot of new cases and new developments in that area. So this year I decided to do a more primer of sorts. I learn a lot at these CLEs about areas of law that I don't practice in, but I often am left thinking, I don't know the first thing about that. I could use a 101. So that is what I decided to frame my presentation on today. I do practice in primarily products liability, law, and commercial litigation. I have a firm here across the river in Minneapolis, and we represent manufacturers of farm equipment, hand tools, construction equipment, vehicles, etc. So what is product liability? Under Minnesota law, strict liability, negligence, and implied warranty have all been lumped together under one products liability theory. In products liability claims, we almost always see these three causes of action: design defect, manufacturing defect, and failure to warn. A design defect claim essentially requires three elements. First, the plaintiff has to show that the product was in a defective condition that was unreasonably dangerous. So, for example, you've got a lawnmower, and there was an accident involving a rollover of the lawnmower. The plaintiff has to establish that the lawnmower was defective in a way that made that mower unreasonably dangerous. The second element is that the defect existed when it left the defendant's control. So sometimes in a lawnmower case, you'll get a claim that it was defective because it didn't have a rollover protection system. Well, if the manufacturer designed the product with a ROPS and at some point someone cut off the ROPS, that becomes a harder claim to make, because that product was not in the same condition as it was when it left the manufacturer's control. They might say that you should have made it so you couldn't cut it off, for example, but that is an element. And then the final element, as it is across the board, that the defective condition caused the injuries. So in every state, there's a little different standard for what you have to show to prove a defect. In Minnesota, it's the reasonable care balancing test. So in Minnesota, you have to show that the product's design is defective and unreasonably dangerous by balancing the likelihood and gravity of the harm with the precaution that would have been effective to avoid the harm. In Minnesota, oftentimes what is looked at for that precaution is an alternative design. So the precaution has to be possible and feasible by the manufacturer, and generally requires an expert to talk about what the alternative design is. An alternative design is not actually an element of defective design, and I think this is an area that is often litigated. But there are a lot of cases in Minnesota where the courts have decided that if a plaintiff is arguing that a product should have been modified as opposed to just completely taken off the market, if you're arguing it could have been made safer by putting a ROPS on it, it could have been made safer by changing the inherent design of the product, then you need an expert to proffer an alternative design, because that design is the, quote, precaution that could have been taken to avoid the harm. And there's a Minnesota District Court case that says without an expert explaining what that alternative design is and how that design could have prevented the harm, the jury can't possibly engage in that balancing test as is required under Minnesota law. Manufacturing defect has essentially the same three elements, but here we're looking not at whether the design is defective. In other words, every lawnmower that doesn't have a ROPS is alleged to be defective by design. Here we're looking at an actual manufacturing defect, an error that occurred on the factory line. I have a case now where a forklift is alleged to have a manufacturing defect because a component in the brake pedal assembly was allegedly manufactured defectively. So it could be a one-off, just only this one forklift is allegedly defective. But it's the same three elements. The product was in a defective condition and unreasonably dangerous. That manufacturing defect existed at the time it left the manufacturer or the defendant's control, and that defect, that manufactured component caused the injuries. The third claim is that we almost always see as failure to warn. A plaintiff has to show that there was a duty to warn. In other words, the defendant knew that there was a possibility, they knew that an injury was foreseeable, and needed to warn against it. Here, for example, if we have a stump cutter and there is a rotating cutter wheel on the front end of the stump cutter, there is going to be an argument that there is a duty to warn that stump cutter can cause a hazard. The second element is that the defendant breached the duty by providing an inadequate warning or no warning at all. Typically, a warning needs to identify the hazard, talk about how to avoid the hazard, and what might happen if you encounter the hazard. So for a stump cutter wheel can cause serious injury or death. Stay away. The third element is, again, causation. The defendant's inadequate or non-existent warning actually caused the harm. Here, you look at, did the plaintiff read the warnings and instructions? It's hard to establish a failure to warn claim if the plaintiff testifies in deposition. I didn't read the manual. I didn't read the on-product warnings. I didn't attend the training. I never do that. I never read manuals. Well, then no matter what the defendant might have warned against, you can argue would have had no impact because he never would have seen a better warning. You can also establish that the plaintiff knew of the hazard, independent of what the defendant warned. Back to the stump cutter example, you can establish in a deposition that the plaintiff knew that a rotating cutter wheel can cause serious injury or death, and he did not need to read that in a manual. He did not have to have anyone tell him that. So essentially, would this failure to warn often comes down to, would it have changed the outcome? No, failure to warn also has, in addition to what was in the manual, what did you tell the user at the outset, a post-sale duty to warn component. And up until 2018, the post-sale duty to warn was mostly reserved for, quote, special cases. There was a Goodyear tire case in 1988 that recognized that a manufacturer can have a post-sale duty to warn. In other words, the product is out there. It's in use in the field. The manufacturer, the defendant, learns of an issue and then has to go out, find the consumers, find the users, find the owners, and issue a warning after the fact. So in the Goodyear case, it was found that can be the case in certain situations. In 2018, the Minnesota Supreme Court defined this a little bit better. And in that case, there was a fire in a home in Eden Prairie, and the allegation was that the fire stemmed from a component of the HVAC system that had been installed in that home 16 years before the fire. The allegation was that the manufacturer of that component knew that there were issues and should have gone back and issued warnings for all of those components that were out in the field. So the Supreme Court in Great Northern adopted the Restatement Third of Torts, Products Liability Section 10, which essentially says that a reasonable person in the seller or manufacturer distributor's position would provide a warning after the time of sale if the seller reasonably knew the product could pose substantial risk of harm, and that those to whom a warning would benefit can be identified, which is an interesting issue when it's a component. It's a lot easier if you've got a registered stump cutter or vehicle where you are the manufacturer and you know where those products are. If it's a component integrated into another product, that creates a whole different set of issues. But the user also has to be unaware, assumed to be unaware of the risk of the harm. You also have to show that the warning can be effectively communicated and acted upon, and that the risk of harm is sufficiently great to justify the burden. Oftentimes, post-sale warnings come in the form of some sort of service bulletin, notification, generally not a full-on recall, but that type of process. And that can be burdensome depending on how many products are out there. So there is a weighing factor that the risk of harm is sufficiently great to justify that. And all these four factors are conjunctive. So the plaintiff has to prove all four to establish post-sale duty to warn. Causation, as I've said throughout these three main causes of action, causation has to be established that the defective condition or the lack of warning actually caused the injury, and that oftentimes requires expert testimony. If the causation is beyond a layperson's knowledge, then the plaintiff typically does have to introduce expert testimony to causation. Another essential element throughout products claims are foreseeability. So in design cases, manufacturer's duty to make a reasonably safe product arises when the injury sustained was foreseeable. There's no requirement that manufacturers make fail-safe products that can never cause an injury, but it has to be reasonably safe. And the duty arises when that injury is foreseeable. And typically, duty is an issue for the court and can be decided at the summary judgment phase. But there was a case in 2017 that makes that summary judgment likelihood a little less now. That case was Montemeyer versus Seabright Products. And it involved a high-density extruder machine, and it processed discarded food containers. It essentially crushed the containers with a hydraulic ram. The injury resulted when the plaintiff climbed into the extruder to that discharge chute to clear a clog. And there was a warning on the product that said, danger, do not enter. Unfortunately, the coworker did not know that he was in this chute. The coworker discarded a safety device that was on the product. No one had locked out or tagged out the machine when he climbed in. And again, not knowing, obviously the plaintiff was inside, he started up the high-density extruder machine, and the plaintiff sustained significant injuries. There, the district court granted summary judgment, saying that it was reasonably foreseeable that a person might get into the machine in disregard of the warning, or that somebody might have activated and run the machine without implementing the safety device. But it wasn't foreseeable to the manufacturer that both of those things would have happened. The Minnesota Supreme Court disagreed and found that this was a sufficiently close case that it could not be decided on summary judgment and should be left to a jury, that it was a factual dispute regarding the defendant's awareness of whether this was foreseeable. So that case is significant in that it changes a little bit the landscape of summary judgment on product liability cases. Next aspect that is in almost every products case is expert witness testimony. I have never had a products case that didn't involve multiple experts. You know, we're dealing with design engineers, different types of mechanical engineers or electrical engineers that talk about how the product was designed, what is happening in the industry, how it compares to other products. Usually there's a warnings and a human factors expert talking about whether the warnings were reasonable, what they should have said, how a person interacts with these warnings, and a biomechanic. You know, back to the lawnmower example, if you have a rollover incident that results in a death and there are no witnesses, biomechanics can come in and figure out how the product rolled, how the injuries were sustained, what actually caused the death. Similar with accident reconstruction, get folks in to examine the scene, examine the product, examine the injuries, and try to piece together how something happened. The courts in Minnesota have decided that certain products, most products do require expert testimony. They've found that when a product and its, quote, inner workings are beyond the ken of a lay jury, we need to have an expert witness. Some examples where courts have found that expert witnesses were required are cases involving pacemakers, and how the pacemakers work, as well as the reasons why they fail to perform, required expert testimony. The design of an electrical and a mechanical system of an elevator required expert testimony. And the expert must be able to testify why the defects constituted an unreasonably dangerous condition. And an expert's testimony, everybody probably recognizes this movie, every lawyer's favorite reference to expert witness testimony, My Cousin Vinny. Under Rule 702, both in the Minnesota state rule and the federal rule, require that if technical or specialized knowledge will assist the trier of fact to understand evidence, facts at issue, and the witness is qualified to testify. Everybody probably remembers from that scene, Marissa Tomei is testifying as an expert witness, and they wanted to challenge her qualifications, and she rattled off all of the reasons. Her dad was a mechanic, her uncle was a mechanic, her grandpa was a mechanic, and she knew everything about it. So just because she appeared to maybe come off the street in movie world, she was qualified. In Minnesota courts, it's a little harder to qualify an expert sometimes. The standard in state court is FRIMAC, and in federal court, of course, it's the Daubert standard. And essentially, the testimony has to be reliable and it has to be relevant. You know, it's going to be reliable if the expert can establish those qualifications, that he or she has the technical, educational experience background to help a jury understand what's going to be presented, and that the methodology is reliable. In other words, what the expert either did him or herself or what the expert relied on is reliable. And it will be relevant if they properly apply their opinions to the facts, and that's going to help the jury decide the case. Recent case in expert witness admissibility is this Kurjowski case. The Minnesota Supreme Court ruled in 2019 on this case. Here, the district court granted judgment as a matter of law after a $27.7 million verdict came in. The district court excluded the entire opinion of the plaintiff's sole causation expert. The Court of Appeals affirmed that ruling, and it went up to the Supreme Court in 2019. And the Minnesota Supreme Court found that the exclusion of the expert wholesale was improper, and it was an abuse of the discretion when they found that just one aspect of the opinion lacked that foundational reliability. So the Supreme Court determined the expert opinions were grounded on more than just one basis, and the other grounds were okay for the court to admit. That case actually was remanded, and the subsequent jury trial verdict found that plaintiff's fault was 100% plaintiff's contributory negligence was 100% of the cause of the injuries, and the defendants were not liable at all. But this kind of piecemeal exclusion of experts' opinion, I think is becoming more common. That's what happened with my last expert challenge. This summer, received an order that the expert's opinion as they pertain to design defect and failure to warn were unreliable and excluded, but opinions on manufacturing defect could move forward. The 3M bear hugger litigation, a lot of you have probably heard of this case. Some of you probably are pretty intimately familiar with it. But last summer, August of 2021, right before this event, I talked about this a little bit last year too. The Eighth Circuit Court of Appeals reversed summary judgment in favor of 3M, which revived plaintiffs' negligence and strict liability claims in a multi-district litigation involving nearly 6,000 lawsuits. So after the first bellwether trial of those cases, which resulted in a jury verdict for 3M, the MDL court excluded plaintiffs' engineering and general causation medical experts and granted summary judgment to 3M, dismissing all 6,000 of those MDL claims. But on appeal, the Eighth Circuit applied the standard for reliability of the Daubert test and concluded that the MDL court excluded those experts in error, finding that the underlying opinions were in fact reliable, and whether or not those opinions and that methodology was created just for litigation goes to the weight of the evidence, not to the admissibility. So that opinion was just denied recently certiorari by the United States Supreme Court, and as of earlier this week, that case is set to go to trial this month. So I am sneaking in under time. That's my Products Liability 101. If anybody has any questions, let me know. Otherwise, thank you.
I have a question.
Yeah.
How's a manufacturer, what's their duty to anticipate a potential injury from a particular product? How do they know whether a warning is really required?
Goes to, oh, yes. So Brett's question is, how does the manufacturer know if a warning is required? How do you anticipate what you need to warn against? Goes directly to foreseeability. Oftentimes what we as, I am a defense lawyer, what our clients typically talk about is the nature of the hazard. Again, a stump cutter, I think most people are going to say you need to warn that the cutter wheel can cause serious injury or death. There are certain situations, though, where accidents happen that you thought you either designed out or you just never even foresaw. A strange workplace situation that imposed a hazard on a product. A product is used in a way that you never anticipated it would be used. Misuse and product alteration are defenses to that, but it goes down to foreseeability. If you have a bunch of reports of accidents because of one particular fact pattern or one aspect of a product, it's probably going to be found foreseeable that you need to warn against that.
And is that a legal issue for a court, or is that a fact question?
Foreseeability is usually going to be a fact question, especially under that new, the more recent case in Minnesota, the name of which I'm completely blanking on. What? Thank you. Yes, Montemayor. Yes, found that it's going to be really hard to determine foreseeability at summary judgment now. Yeah.
The court decides that it is a close question of foreseeability for the jury. Does that become a standalone question on the special verdict form, or is it wrapped up into an element of negligence?
Well, in a products liability case, it wouldn't necessarily be a negligence standard. It's a strict liability standard. So it would, the question is whether or not foreseeability is a separate line item on the special verdict form. And I would have to double check the standard form. I don't think it is. I think it's just those three elements that are going to be on there, and you have to argue it in closing argument that it should fall under one of those.
Anything else?
Okay, thanks.
Thank you. All right. Yep. Next up is Andy Rorvig. Andy's been with us for many years. Always does a great job. Former sport coat recipient. Last year, actually, we gave him the Golden Gopher sport coat, which he promptly wore down in Iowa City. We were proud to see that. So anyway, was not necessarily a good outing, but maybe this year at the home, right?
Yeah, why not us? Why not now?
Right. Exactly.
Yes, we do. And who hates Iowa? Just checking. Just checking. I mean when I say, well, good morning, everyone. I'm going to take this thing off, otherwise I can't see my notes. It's fun to be here. This caps off an exciting week for me. I got to go try a case for the first time since March of 2020 when, where's Tupa? Tupa and I tried one the first week of March of 2020. And then from then until now, that there's been nothing else. So I told the jury I was excited to be there. And most importantly, I was excited that I was wearing pants for the first time in a court proceeding in 2.5 years. I guess that's the Stearns County and me. So let's talk about health insurance real quick and subrogation interests. My wife told me not to say that joke, but I couldn't help myself. So nobody tell her, please. Click, click. Here we go. So we're going to hit on 5 things. Hopefully. That's 3. Sounds like 4. Here we go. 5 things. We're going to talk about ERISA health insurance plans. And so the first couple topics aren't as germane for my defense friends, but I promise you there's going to be an application for you as we get to the 5th one, which is where Brett wants me to name some names. And so listen up as we get to number 5. But first one is, do we as plaintiffs' lawyers, have leverages with ERISA plans when we're trying to settle our cases for our clients? Do we have a leverage to reduce what we pay back a health insurance plan to maximize our clients' recovery? If you're taking notes, the answer is no. There is no leverage, and I'll tell you why. Mainly because the U.S. Supreme Court in the last 15 years has shut the door on every opportunity to reduce the powers and the rights of an ERISA plan. Second thing is, what if you don't behave as a plaintiff's lawyer? What happens if you violate this rule that you have no leverage and you try to be funny with the money? What happens to you? We'll talk about the ERISA plan's rights. Is there any benefit to taking an assignment of a health insurance plan? We'll quickly go through that, and the answer to that's going to be probably not either. And then we'll talk lastly about future medical. What happens when you settle the case and your client continues to treat and they've got an ERISA health plan? Are you going to have issues with getting coverage and coverage for those bills paid going forward? The answer is most likely, depending on what type of a plan you have. And then lastly, we'll name some names about what's the impact to the defense when there's a health insurance plan that's an ERISA plan involved. All right, so we're going to go quick. First one, and this goes to this issue about, do you have any leverage with the health insurance plan? And so the Supreme Court now has had 3 or 4 cases, and they all say the same thing, which is the health insurance contract governed by ERISA always governs. So whatever's in the contract is what you're stuck with. And of course, people like United Health and others have broadened the terms of that contract. And so now those contracts, those terms basically say, if you, the plaintiff, get any money, regardless of causation, regardless of fault, regardless of an itemization on a jury verdict form, it doesn't matter. We get paid first. And the courts have continually upheld that. So this is a case from a couple years ago. It was a very novel approach. It was a situation where someone down in Rochester couldn't get a deal cut with the Health and Welfare Fund, which, by the way, is the worst to deal with in terms of these plans. They couldn't get a deal cut. They sent the check to the health insurer along with an attorney's lien, which they tried to enforce. So in other words, they owed $200,000. They sent it with a 1/3 attorney's lien to try to recoup back from the plan a 1/3 fee. You want to guess if it worked? No, not so much, right? Again, the plans have the right. The court favored the plan. They cannot reduce for attorney's fees. There is no lien mechanism to allow reduction. So crash and burned on that, but a novel approach. Second idea, what if your settlement doesn't include medical? And this is kind of interesting. It's a little technical, but it was a wrongful death claim. It was in the 8th Circuit. And as we know, when we're making a wrongful death claim, generally the biggest part of the claim is the pecuniary loss. And so with regard to this, the plaintiff's lawyer said, listen, we're not making a wrongful death claim for any of the medical expenses. We're just solely making a claim for the pecuniary losses. And again, a wrongful death claim is based on statutory rights. It's not a common law claim. And so they painted by number, they thought, and said, listen, we've got a really novel argument. We're not making a medical claim. It's a pecuniary loss claim. The court has to approve the distribution. That's all it is. We don't owe you anything, ERISA plan. Sounds good, right? Couple problems. One, the release included mentions of medical expenses. So when the case got resolved, the smart defense lawyer puts the broad language in there. It says you release all claims, pecuniary losses, medical wage, yada, yada, yada. So the court says that's a problem, right? I know you're telling me there's no claim for medical, but that's not what the release says. And the plaintiff's counsel agreed and said, yeah, that's what it says, but there's been no consideration for it. There's a number of cases out there as well that say the same thing, which is you can't go ahead and put together and itemize your own type of settlement. We don't care. The contract says we get paid first dollar every dollar. So regardless of how you structured the settlement, at least in your mind, or even if a court verdict, a jury verdict would come forward saying these are the amounts, we don't care. The ERISA contract always governs. We get paid first dollar every dollar. So again, a novel approach, but that doesn't work either. ERISA contract wins. Somewhere I'm clicking. Click, click. This is for Jake Tomzik. This is something I learned from him way back in law school. It says, in the future, this is the judge speaking, in the future, please say I object rather than that's total bullshit. So one of those very technical type of defenses that I've been using for a few years. Okay, so you're the plaintiff's lawyer and says, I'm not going to pay the ERISA plan. My client told me not to. I don't think it's equitable. I don't think it's fair. I'm just not going to do it, right? Sounds like my 11-year-old. Go clean your room. I'm not going to do it. So the ERISA plan has, as a remedy, any equitable relief that they want to have. And so there's been a fight about exactly what that means. That's gone up to the Supreme Court. It's not a breach of contract. It's an equitable result to allow them to come after you to get the money, you being the plaintiff's lawyer or you being the plaintiff. And so here's the case from 2002. It says money or property identified as belonging in good conscience to the plaintiff that could be clearly traced to particular funds or property in or her possession. So in other words, if you got the money and there's a pretty clear paper trail of where the money went, either you as the lawyer or you as the plaintiff, they've got a right to come after you. They have a right to have a constructive trust to protect those funds, and they do. They will enforce it. They will come after you. It's not just a fake type of claim. And the reason I know that is this guy. You guys recognize this handsome fellow? That's my partner, Paul McElstrom, with a little extra hair. It says what it looks like after you've been sued by an ERISA plan. Paul got sued a few years ago, now probably 15, 16 years ago. He got sued by an ERISA plan under a creative argument to protect the funds from going to the plan. It got resolved favorably, but the point is they had an injunction hearing the day after the case settled, and then the day after that he appeared before Judge Davis. And when Judge Davis said, will the defendant rise, Paul rose. So first time ever. So that's what it looks like. They're serious about this stuff. They come after you. They're not joking. This is not just a veiled threat. So to my friends in the defense bar, when the plaintiff's lawyer says, I've got an ERISA health plan and I've got issues, they're not joking. These are real things. Here we go. What's the value of an assignment? Oops. The assignment's not going to change much. This is more of a collateral source issue. You know, back before we had Swanson v. Brewster, obviously all the plaintiff's lawyers got the full value of the medical bills. That changed with the Swanson v. Brewster decision. And then for a while there was an argument that, geez, If we get the assignment, we can still collect the full value. That's now been shut. So that's not going to impact anything. So this idea of getting an assignment from the health insurer doesn't really work to the advantage of the plaintiff. There can be some benefit with regard to how we look at collateral sources with a UIM claim, but for the most part, it's not going to be a big value to the plaintiff because you're not getting, again, the gross bills versus the amount paid, and that's an example of that. This was Doug Shrewsbury I saw at the Mayo Clinic here a couple days ago. It says, you can stop now. The results show your insurance doesn't cover the test. Is that true, Doug? Where'd you go? No, sorry, Doug. So what happens, and this is a true story. So you've got an ERISA plan, and this is what's happening now, folks. The ERISA plan will say after the plaintiff has received a settlement, after we, the plan, have been reimbursed, we do not pay for future medical care that's causally related to a particular accident. That has become the norm. 20 years ago, when I first started doing it, it was very, very uncommon. It was simply the health and welfare funds that had that language. But now almost all of them have it because, again, the Supreme Court in the last 15 years has given absolute carte blanche authority to ERISA plans to put whatever verbiage they want in their contracts. And the unions have always been following it, but now more than ever, all the other health insurance plans have. So it was a case when I was a baby lawyer long ago. Here it is, Mary Norby versus Twin City Carpenters and Joiners. Pretty lousy case for me on liability and on causation, but it was a case where she had slipped and fell, had a knee surgery, kind of related, kind of not, but we had a modified settlement where we would split the funds 3 ways. The union came to bat and said, yeah, we'll take a third. We understand you've got a problem on fault and on causation. And the case got resolved, and the fund signed a release that we drafted because we were pretty clear and pretty certain she was going to have future medical care, and we knew that the plan wasn't going to pay for it. So we had a document signed that said they would forever discharge all subrogation rights. Our intent was to use that to make sure that the fund would pay for future care going forward. So, of course, she goes in, gets future care. They deny it. We end up in federal court. And again, they denied the future care because it was subrogation related. So we sue them, away it goes. The case gets resolved. But the takeaway from it is that language, my release probably wasn't good enough. And the reason it wasn't good enough is because the Health and Welfare Fund would never have agreed to what I wanted them to put in the release, which is you're going to pay for future care going forward. So I bring it to your attention because it's a real issue, right? Especially when you represent plaintiffs and you know they're going to have future care or there's at least a chance of it. I think you have to, in good conscience, advise those plaintiffs of the fact that it might not be covered going forward. All right. Moving quick. Here we go. What do you want me to do? It's an ERISA plan, right? I mean, that's the truth. So this is the application for the defense bar. Here we go. So the myth and mystery, you can negotiate with an ERISA plan. So I had this about 6 months ago with a very nice adjuster, and we were kind of going back and forth, and I said, listen, I've got a $50,000 ERISA fund, ERISA plan lien. She said, well, those are negotiable. And I said, listen, it's not. I'm telling you in good conscience it's not. Here's what I'll do. I'll give you the name of the person to talk to at United Health, and I'll give you 2 weeks. If you're so confident you can get a deal cut, do it, and then maybe we can resolve the case. If you can't, I'm going to sue you. How's that sound? She calls back a week later and says, yeah, it turns out ERISA plans aren't negotiable, right? So it's a reality. So are there situations, and to be completely transparent and fair, are there situations where in certain times, certain ERISA plans will negotiate a little bit on behalf of the plaintiff? Yes, there are, but they're few and they're far between. And so I promised I'd name some names, and I will, but it's an issue, right? When you have cases where you've got liability disputes and you've got a $50,000 lien or you've got a causation dispute and you're on the defense and saying, I don't owe the 50 because my guy's not at fault or that injury's not related. All are great defenses and all are probably true, but the ERISA plan doesn't care. And they don't care because they don't have to care, because they have a universal right to say, whatever you get, regardless of the jury verdict, the jury's never going to award that, or they're going to have an offset for fault. The ERISA plan says we don't care because we don't have to. So it becomes a huge impediment to getting cases resolved. And as long as you know about it, right, it's important, but it's a huge impediment, and it affects every one of us. So again, you've got no leverage. Short of having the case adjudicated, but even the case law on that's not very good. Again, the courts have set aside the jury verdicts and said that's all fine and good, but the ERISA plan contract governs, and it says, like Pac-Man, we get everything in front of us. We get it all. So the practical differences with ERISA plans, here's the names. Health and welfare funds are the absolute worst. The worst of worst you can ever have. They take every money, they provide no discount. They'll tell you that it goes to a trustee to review, and the trustees will always come back with wah, 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 right? Because they're only there to protect the fund. They could care less about the plaintiff, the union member, could care less about him or her. They want to get their money back. So if you've got, as a defense lawyer, and the plaintiff's got a beneficiary of a health and welfare fund, there's about a 0% chance they'll ever reduce the lien. Never going to happen, ever going to happen. So that's the worst. TPAs, major health plans, oftentimes handled by law firms or companies. We see these a lot of, for whatever reason, Louisville, Kentucky's got a whole bunch of these people that do this, and so do different West Coast firms. There's a slight chance, not much, but a slight chance they might give you a 5 or 10% discount, but very unlikely. Again, they're getting paid on behalf of the health insurers that collect this money. And this money, based on the research that's been done, is all free money to the health insurers. It's not reducing your premiums or my premiums. It's just a windfall for them. So they go ahead and they outsource it to these TPAs. Once in a while, they'll listen to you, but for the most part, not so much. You send fax after fax, email after email, because you can't call anybody. And once in a while, they'll discount it, but very unlikely. Optum. Anybody do with Optum, right? The black hole, where you, again, can't get anybody to call you. Here's my 800 number and a 3-digit code, and then you wait for 6 months, and then it's changed about 100 different people, and you're like, I've had the same conversation with somebody 5 times. Kind of like the TPAs. For the most part, very, very little. I mean, it's a 5-10% discount at tops. Probably not going to happen, all right? So when the plaintiff's lawyer tells you, I got one of these 3 knuckleheads, one of the 3 stooges here, they're not kidding. This is a very rare chance to seek any kind of reduction. And again, out-of-state subrogation companies, Rawlings Group is the main one out of Kentucky, and there's another one out of Signuit out of Salt Lake City that seems to be new. Again, very unlikely. They don't understand what they're doing. The poor people that work for them have no clue. They're just there to push the paper. You can yell about causation and comparative fault, but again, they just don't know. So these are the bad ones. The usual suspects, the local ones, there's some hope. Blue Cross Blue Shield, Health Partners, Medica, not so much Medica anymore because they now use United Health, but Blue Cross and Health Partners both still have in-house subrogation departments. These folks are the most likely to work with you. A guy named Chris Seipel works at Health Partners, been there for 20 years. Starla at Blue Cross Blue Shield, she's my best friend. Those people will work with you. They will negotiate, they will cut deals with you. They're here, they get it, you know them, you deal with them all the time, either as a neutral or as a claimant. They will work with you. Not always, but they'll work with you. If you got a good story about, I've got all these causation or I've got limits issues, they will work with you. They usually want to have good results because, again, this is free money. This is making those health insurers free money, and they will work with you. They would rather take the easy money from you, the plaintiff's lawyer or the defense lawyer, than have a big contracted fight. And again, these are ERISA health plans where they don't have to do any of those things. So they're the ones that are the easiest to deal with. So the key is to know who you have and what you can do. But again, this idea that all ERISA health plans are negotiable is not true. And it's not going to get any better. And even the few health plans, the few ERISA contracts that are still out there that haven't included some of this doomsday language, they will. They'll eventually catch on because, again, the Supreme Court has been so favorable to those groups. So with that, the Attorney General's here. I'd rather hear from him than me.
General Olson to come and talk today, and I've always found him to be a captivating speaker, and he's done great things, in my opinion. And I'm not, just in all fairness to our listening audience, I'm not always on the same side of the political spectrum as Attorney General Olson, but he is my daughter's boss, and I will be enthusiastically voting for him in November. If I had any power out there to tell people that he's done things, and he will make our business, the work that both sides of this bar do, he helps us, I think, and he's a strong proponent of the civil justice system and how that works and how people's rights are enforced that way, and in turn, how folks are properly defended. So he's got an unbelievable resume, which I won't repeat. I do know this from, he doesn't know that I know this, but he grew up in Detroit, and he used to play a lot of basketball in Detroit, despite not being a tall person. And one of your former, it was a coach of mine who I went to lunch with recently here, as a matter of fact, and he said, do you happen to know Keith Ellison? And I said, I happen to do know him. And he goes, well, if you ever see him, tell him that if he comes back on the course, we'll take it to him, because he was not as good as he thought he was. Anyway, so, all right, with that, I don't know if that's even an introduction, but we do appreciate all that you do for us here in Minnesota, and my opinion, I hope that we have another 4 years of it, but that's me speaking, and this is not supposed to be political, but because I have the microphone, I get to say whatever I want. So anyway, with that, and just for your benefit, this is about half of in person we normally have. We have twice as many people listening live stream. So, but we are back together for the first time since COVID, and I'm really happy with those that have showed up, and I'm also happy that folks on live stream, we're having some difficulty, but I think Greg has got it corrected. Perfect. So with that, Attorney General Ellison, thanks for coming.
Thank you, Brett. And when you're my height, man, you got to work on your crossover dribble. You got to look for the open man, and you got to get a nice jump shot from the outside. That's right. Anyway, hey, good afternoon, everybody. And Brett, thanks a lot for putting me right before lunch. So I think that's an incentive to like get it going, right?
Just for the agenda says an hour, and I promised the Attorney General that he does not have to talk for an hour. So anyway.
All right. So as you all are having growling stomachs, I'll make sure that I only do 59 minutes. Well, so let me just tell you this. Brett's absolutely right. I am a very strong proponent of the civil justice system. I think that if you look at our country and you compare it to a lot of places in the world, and you compare it to a lot of different times in human history, what keeps us from going at each other's throats is our civil justice system. The idea that if you have a dispute with somebody, you can take them to court. It is important to the stability, to the democracy, and to the strength of our nation that people know that they have a right to pursue their interests in court, and that they will be heard, they will be listened to. It is enormously important. You all know this. I just want you to know I know this. And I'd say this because, you know, I spent 12 years in the U.S. Congress, and I decided to leave there because I really felt that there was more good to do in the Attorney General's office. So I left that job, and I decided to do this one. I have had a remarkably great last 4 years. I've enjoyed the job. It's a tremendous privilege to do it. And so I'm very, very honored to be here with you all right now. I just want to kind of tell you what we've been doing over the last several years, what our priorities are, what they will continue to be, and so then we'll go grab some lunch. The first thing I want to tell you is that every time we have a staff meeting, every time I talk to my staff, I tell them our job is to help people afford their lives and live with dignity, safety, and respect. That's what we tell everybody. It is a consistent message. I say it all the time, and it's so bad now that the second I say our job is to help people, and then they say afford their lives and live with dignity, safety, and respect. So I do that because I want to keep everybody clear on what we're doing. I think as the AG, I don't write the briefs generally. I don't make the arguments generally. I don't try the cases. They do it. Those 350 folks who work with me and I'm privileged to work with, like Katie Olander, do the hard lifting, the heavy lifting and the hard work. So I need them to understand what is the culture of the organization, what are we trying to do, and keep everybody on the same page. And so we're trying to help people afford their lives. So many of the things that I'm about to talk to you about are going to be pointed directly at the economic challenge, and my hope and prayer that America's greatest invention, which I would say is not the light bulb, nor it is the internal combustion engine, it is the middle class. In fact, we have that because of decisions that people made before you and I ever were able to assemble in this room today. And it has to do with the civil justice system like we started out talking about. And it is the idea that people can aspire if the rules are fair and if there is some justice. So we center victims. There's no amount of money that can ever make up for the losses that people suffer. So often they're emotional. They feel like they're treated unfairly. So that's one of the things we do as a consistent stream that we do. So let me get into some of the things that we're working on now. One of the most important things that I think we've worked on over the last 4 years is the opioid settlement cases. We've now settled 9 separate opioid cases. They've all been a mixture of litigation, multi-district litigation, and also legislation. Because after we went out and sued, settled the cases, and now bringing the money home, there was this issue of how the money would be distributed across the state. I think the legislature was wise to make sure that the money was distributed equitably, that it just didn't go straight to the general fund so that somebody can spend it on something else other than alleviating the opioid crisis. And so we spent a lot of time making sure that there was a 75-25 split between the state and the counties and the other litigating districts, making sure that the money went where the pain is. And what does that mean? That means, they got overdoses in Ely and in Zimbrota too. And then we got them in the Twin Cities. And the people who usually deal with this stuff are local health officials, local law enforcement officials, and we wanted the money to get there and not just end up somebody's giant tax break. Over the last several years, there's been about 5,500 people who have died. That does not count the family members of those people. That does not count the people who nearly died and somehow just took up room in the ER but barely survived, but did survive. It is a huge number of things. One of the things that I have insisted on is that when we get the maximum amount of money that we can, and but the other one is that there be full disclosure. I've been real clear with the more recent cases that we have settled that there's going to have to be a national depository in which all the documents are disclosed. We will go to trial before we sign a non-disclosure agreement in these cases. We're not going to let these folks perpetuate these huge pharmaceutical companies perpetuate this crisis. They have to have some sunshine and pay some money. So that's it. Though we've been holding these companies accountable, as I mentioned, though nothing can make up for the harm, we're going to continue to push. Monetarily, let me note that I mentioned the 9 settlements over about the last 2.5 years. Of the litigation, and the biggest of these settlements with manufacturer Johnson & Johnson and 3 distributors that money total amount is $300 million over 18 years. It's front loaded. We'll get more of it sooner than later. Just by show of hands, has anybody been involved in this opioid litigation who's here today? No, let me tell you, there have been a number of Minnesota members of the private bar who have been. And we've been working with them to make sure that they're treated with fairness as they fought for their clients as well. Next, we're holding these companies accountable with the non-disclosure agreements. As I noted, we've found that there are literally millions of documents, and some of them are really, really interesting. I commend you to look at them if you ever have the time or interest. We've insisted this at the national level, and it's been really important. The full transparency to me is something that we will not settle a case without. And I'll tell you a quick story. There's a Republican legislator by the name of Dave Baker, and he had a son who died as a result of the opioid crisis. So did Chris Eaton, a state senator. And both of them made it clear to me. They said, look, when we had a settlement offer, I said, well, how do you feel about this number? They said, I don't care about that number. I care about them being held accountable. And so part of that is the sunshine. The money is starting to flow, as I noted already, and that to me is very important. The money should be flowing by the time the month is out. $66 million is the first tranche, and that will be going to things like treatment programs all over the state. It will be going to things like education. There are not enough professionals who work in the area of recovery, so we need to educate some more, and so that's part of what the money will go to. Of course, there'll be, Suboxone and Narcan and things like that, but the main thing is to try to alleviate this pain. So that's one of the biggest bites that we've taken on in this area of dealing with the opioid companies. It's the long term. It's not over, and we'll keep keep on it. Next, I wanted to mention to you, and this is in the box of affording your life, is housing. We've spent a lot of time on housing. We're going to continue to spend a lot of time on housing because after talking to like literally thousands of Minnesotans all over the state, it's clear to me that if you can't get good housing, it's hard to do almost anything else. And what the Attorney General should be doing, we don't have a budget to make more housing, but the housing that exists, there needs to be fairness, it needs to be clean and safe, and people need to be able to be treated with up to the requirements of the law. One of the first cases that we did involved a landlord by the name of Stephen Meldal. He owned about 267 properties in North Minneapolis, and he had over 1,300 citations from the city of Minneapolis, which he ignored. So when we sued him, we were shocked by a few things. One is just the sheer volume of people. Almost all moms and their kids. That's who lived in these properties. They were in bad shape. And we actually went to trial. These women very, very courageously took the stand. We had an online trial. And the judge issued an order in which he found for our side of the case and against Mr. Meldal. And he wrote in his order that the testimony and the evidence in this case is of biblical plague proportions. Lice, mice, rats, gnats. He described the witness testimony where one lady said she just had forgiven up the bathroom. The squirrels had taken it over. She's just trying to keep them on the other side of the door. This is in Minnesota. And so I just want to, commend that judge for his decision. We got this landlord for over $1 million when you look at all the compensatory and the lawyer's fees. We did it to try to send a message that if you're a landlord providing good housing, God bless you. Thank you in this market. But if you're not, we might come knocking. And I think this is important because I think most people want to comply with the law. The court found that Meldal knowingly and in bad faith violated the rights of the 267 families who rented from him in North Minneapolis. And so when we think, all of us are Minnesotans, and most of us are from the Twin Cities. Every city in America has a neighborhood that has some element of being notorious. We can agree on that. And we know in North Minneapolis, sometimes brought up in the news in an unfavorable light. It's not that the people are not great people. They are great people. It's that sometimes folks like Stephen Meldal are allowed to get away with some things they should not. And so we're going to be there trying to make sure that those kids can leave home and go to school and come back to a clean, safe home. And that's one of our commitments. Viking Terrace is another one. It's not in the Twin Cities. It's actually in Northfield, Minnesota. We didn't even have to file a lawsuit in this case because we had gotten pretty kind of aggressive in the housing space. This Viking Terrace was purchased by a company called Lakeshore Management, and as soon as they got the property, they issued a new set of rules. And it's important for you to know that this is a manufactured housing park where the people own their units, but they don't own the land that they sit on. So when the property got acquired, the landlord said, "New sheriff in town, you shall not hang your drying linen on the lines outside. You will not have a vegetable garden. You will not have guests here past 10. Your children cannot play in other children's yards. You will not have a vegetable garden." Look, and about 80% of the people who lived there were Spanish-speaking in origin. And so it seemed to me that these folks were taking advantage of a vulnerable community. We contacted them. We told them that we were prepared to move forward with the legal action, and they agreed to settle with us. This 185 families, and they made these reports to us, and they told. And so what they did after we engaged them is they said, "Okay, we know you're willing to try the cases. We will work with you to rescind these requirements on the grounds that you cannot simply make these alterations to the lease, the substantial alterations to the lease without some sort of negotiation consideration, which we just, we unilaterally just imposed them. So they backed off. The people there got a lot of support from the local church community. That was very pleased to see that. We had a local community meeting where we heard a lot, and the 185 families showed up. I met a mom when I was up there talking to the people, and this is a single mom with a child, cerebral palsy, and the reason the single mom wanted to try to get out of Viking Terrace is because her son needs the use of a wheelchair, which is kept on the front porch because it doesn't fit through the doorway of the house or the trailer. And she was told by the corporation management that they had to remove the chair. So that story kind of got my heartstrings, and I said, well, we'll do something about it. And so that's that one. I mean, and another similar one we just wrapped up was Summit Management Manufactured Home Park, and that owned 9 parks across Minnesota. This particular manufactured home park suddenly imposed similar harsh new rules on longtime residents and threatened to evict them if they didn't comply within 30 days. That's not permissible under Minnesota law. And the residents were suddenly told that they had to repaint homes, repaint windows, install new windows, remove sheds, and do all kind of manner of things that are pretty pricey. Some people even had the money to do it, but they couldn't get it done within 30 days, and they were threatened with eviction if they didn't. So under Minnesota manufactured home park rules, they must be fair and reasonable. And we made it clear that these new rules were and did represent a substantial change. They rescinded them, they backed off, and that's good. We're not saying that the park ownership doesn't have the right to require some changes, but they can't threaten eviction, and they have to give people reasonable time. And of course, we have ongoing litigation regarding Havenbrook Homes, one of Minnesota's largest landlords. It's the first of its kind in the country. The landlord has, has property not kept properly, the whole kind of story. And our lawsuit basically alleges that the hedge fund-owned mega landlord failed to repair, maintain rental homes, lacked heat, had backed up sewers, doors and windows that would not close, mold, even pests and wild animals that they were not controlling. And that they violated Minnesota's lead paint rules. So I just offer that to you because it is part of our ongoing effort to make sure that, we can't build new housing, which I think our society should and needs to do. But for the housing people have, it's got to be safe, got to be clean, it's got to operate within the rules. Now, in terms of our crime issues that we've seen, let me just note that in Minnesota, for the last 157 years, crime is locally investigated and prosecuted. The Minnesota Attorney General's Office has some jurisdiction, particularly in the area of Medicaid fraud. We have original jurisdiction. In other areas, just about every other area, we only come in to prosecute when a county attorney or the governor asks us to do the case. You all are familiar with the Chauvin case. I just didn't walk in and tell Mike Freeman to move out of the way. He called in and asked for my help, and then the governor assigned me, and that's how I ended up with that case. And so when it came to some of the spiking, violent crime, we were asking ourselves, what can we do all on our own? And so we asked ourselves a question: what civil remedies exist to dry up criminal markets? If the catalytic converter doesn't have a place where it can be sold to somebody, and who's buying it, that might be something we can look into. One of the first cases we went into using our civil authority to try to impact this violent crime problem, we did not too long ago, and that was when we started our investigation on Merwin's Liquor and Winter's Gas. With the assistance of the Hennepin County Attorney's Office, we are investigating whether Merwin's Liquors and Winners gas station in Minneapolis are maintaining or permitting unlawful activity on their property. Both locations have been sites of numerous acts of gun violence. On September 2nd, 4 people were shot outside Merwin's Liquors. On September 8th, 4 people were victims of gun violence near Winners. And as early as a few days ago, there was another one. The intersection between these two businesses has been described as a open-air drug market. Now, let me just tell you, I live 4 blocks from this location, and I can tell you that I myself have seen what looks like suspicious activity on the grounds, and I think that the owners have a responsibility to provide security for their own property, not the public areas, but for their property, to enforce the no loitering requirements, and to work with neighbors to make sure that this is a safe place for people to walk and go. But I'll tell you this, one of our ongoing concerns is how can we be of benefit to make sure that we have safe communities and reduce gun violence. So you may see more from us on that, but it's part of an effort to make sure that we got safety and to augment the criminal justice system. Let me move along quickly now. Juul. We initiated a lawsuit against Juul some time ago. This was an effort to protect kids. If you are an adult and you want to vape, you can vape. But if you target it toward children, now that's a different story. We have reason to believe and filed a lawsuit, and we have a complaint that we filed long ago that Juul and Altria Group were marketing to kids with their product on the false pretense that it is safe. It's not safe. It may be less dangerous than cigarettes, but it's not safe. And what we found is a lot of young people graduate from vaping to cigarettes. So we started our case. We alleged that the companies violated consumer protection laws and created a public nuisance by deceptively marketing highly addictive e-cigarette products to youth. That case is ongoing. We defeated motions to dismiss in June 2021, and the discovery completed in June 2022, and trial is set for March 2023. So stay tuned for that. We also are working hard and have prioritized our antitrust group. And so we initiated it and joined a lawsuit regarding Facebook. Minnesota also joined with large coalition of attorneys general in filing lawsuit against Google and other high-tech firms. We also have a lawsuit regarding Suboxone. This is a product hopping lawsuit. Minnesota joined a group of 42 states bringing an antitrust case against the drug manufacturer Indivior and for misconduct related to its drug Suboxone, which everybody knows is used to try to ameliorate the effects of opioid addiction. The lawsuit alleges that in Indivior's patent exclusivity period for selling the tablet form Suboxone was expiring. Indivior shifted to manufacturing Suboxone in film strip form where it still had a patent and exclusivity. And, the bottom line is we believe that in our effort to help everybody afford their lives, one of the most important areas to work in is antitrust. We'll be doing more of this kind of work. I've been speaking on it. I've been writing about it. And the idea is that, look, our highly concentrated markets can account for and partially explain fixed wages, lack of product diversity, higher prices. We have highly concentrated markets in this country, and we believe that more participants in the market competing more fairly will be to the benefit of the public. And so let me just wrap it up now by just letting you know that we've been busy on multiple fronts, whether it's charities division. One case that we worked on right now and had a good result in was after Philando Castile. You all remember him, shot in Falcon Heights. He was known to be a school lunch supervisor, got a degree in dietary school issues to help the kids. when he was shot and killed. The students in Capitol Hill were aggrieved, very upset. They loved this guy. He was beloved in that school. And so somebody started a GoFundMe page called Philando Feeds the Children, promising to use the money to buy down student lunch fees. Because, you know, we got free and reduced lunch. Well, there's still a fee if the kid can't pay it all. And gathered about $180,000. And to her credit, she did pay down some of it, but she kept about $120,000 for her services. So we said, you can't do that. And we not only got a agreement for her to pay it all, and she's now since paid substantial amounts back, but you know, we alerted John Choi to this problem as well. So I don't know what they're doing, but we've referred the matter on. And we're doing a lot of things. You know, Feeding Our Future has been in the news a lot. Let me just tell you, we're actually proud of the work we did with Feeding Our Future, despite what some of my folks on the other side of the aisle say. This was a situation where federal money was administered by the state. There was a rush of folks who applied for the program. The Minnesota Department of Education saw that there were a lot of irregularities and said, we're not paying where it looks like fraud to us. So that's what we did. We said, we're your lawyers. We got your back on that. The judge ordered that the payment should start. We, brought motions to try to help the judge understand the situation. All the time we were talking to the federal authorities about their investigation. You all may remember a few months back there was a massive service of search warrants, and now there were indictments in the last week. Our office, we don't have criminal authority, as you know, but we did work with MDE to stop that fraud, to alert the federal authorities, and to give them the information they needed to take care of this with their criminal authority. So we're glad. I look at this as a collaboration of state and federal efforts to protect the public, the taxpayer, from fraud and abuse. So we're proud of the work that we did, and we think that it's the kind of collaboration we should continue to do. So I'll just wrap up right there. Few just last closing comments. We have spent a lot of time at the Attorney General's office working to focus on this issue of crime. And as I noted, we're using our civil tools to do it. But we do often get referred cases. In fact, over the last 4 years, we've referred about 40 cases from around the state. And I'll tell you, when you talk to some of the counties in greater Minnesota who have 1 or 2 county attorneys, there's a murder, they call us. We always step up to help. We never say no. In fact, we gained a conviction of somebody just earlier this week from a defendant in Albert Lee who shot off 80 rounds, actually shot a police officer. The officer survived because of the body armor. And we obtained a conviction for first-degree murder in that one. But we've done them in Todd County. We've done them all over the state. I have asked the state legislature to give us more prosecutors. They have chosen in the Senate caucus not to do that. But we will keep on pushing. Because even though crime is prosecuted and investigated locally, we have an important role to play in backing up our local counties, and we're going to continue to do that. We're also going to use our civil tools, as I already talked about. But we do regard the right of every individual to be safe to be sacrosanct and very important. So we're going to continue to do that. And then, of course, Dobbs. Everybody knows about the Dobbs decision. I personally believe that bodily and personal autonomy is top priority in our society. If you ask me what's your definition of freedom, my definition of freedom is I control my own body. And anybody who doesn't have that control over their own personhood lacks freedom. So we're serious about that. And so I've been touring women's health centers, including Moorhead, Rochester, all over the state. And, we're going to continue to stand up for that right as we have. So with that, let me just say that it's been an honor to be the Attorney General for the last 4 years. have more respect for the job than I did even when I started, and I had so much respect then that I ran for this position and left Congress to do it. Now I just see it as a very important role to be played. I think the Attorney General is a consumer advocate, must be a consumer advocate, must be there when you all encounter arbitration clause requirements. We are not bound by those, and we can walk through and help consumers, and we do that. And so I think that no matter what political party you may come from or anybody, it is important to remember that the AG is supposed to stand up for the little guy. And that should be how it is. That's how it is in every state, and that's how it should remain. It's been my honor to do the job. And thank you again, Brett, for having me here. All right.
And hope you enjoyed your lunch, and actually it was a good, first time we've ever had the buffet style. So next up is Jessica Richardson, who's going to give us some mediation information and tips and updates. And Jessica, as you know, is with the Thompson, Sonyason, and Tomsche firm in Minneapolis, and I've worked with her many times. She does a great job, and I'm sure she'll do an excellent job up here, too. So, Jessica?
Thank you. So I think I know most people here, maybe not all. Like Brett said, I met Tomsche, Sonyason, Tomsche that started at Ryder Bennett 20 years ago, probably next month. Couple things that I picked up during COVID of the positive takeaways we have now is, one, I converted all of my files to electronic files, and I'm never looking back, and trying to convince Scattergood to do the same. Two, I took the course to become a qualified Rule 114 neutral. So talked to Brett and said, how can I, sure, I'd be happy to speak, and how can I work that in here? So we talked about talking about some things that we can do as attorneys in terms of the things we can control to help have successful mediation. So I've just getting started myself in that role. I've mediated a few times, so I went out and did what I would call using all my resources, and I polled the usual suspects as well and got some opinions from them about things that we can talk about in terms of, what, again, within our control as attorneys, what we can do to be helpful. When Brett asked me about this topic, I had just gotten back from a trip to Italy. And so I said, well, I can talk about that, but really what I would like to do is just do a slideshow that's all pictures of Italy and talk about Italy. And I think he thought I was kidding, but so there's a lot of experience in this room. A lot of the things I have to say, I'm sure, are going to be more of helpful reminders or friendly reminders about things to do for mediation. But if this is things you've heard before and don't need to know, you can just enjoy the scenery. And my really tortured attempts to make the pictures somehow correlate to what I want to talk about. So the first is that was, across the board, everyone who responded to me and had thoughts about this was everybody needs to be prepared. Kramer talked about it. His comment was know your case, but more specifically, be prepared as if you lived at the foothills of Mount Vesuvius, maybe. It doesn't get any better either, so just be warned. So be prepared. So the things that to do, particularly, and Brett did ask me to really specifically point this one out, it came up from everyone though, is from the plaintiff's side, provide all the information ahead of time. The information about, I know I get responses, I serve discovery, I ask for collateral source information, I get the response that it's not relevant at this time until post-trial. As people who are dealing with insurance companies know, I have to, on the defense side, we have to do certain things. We have to write certain reports. We have to ask for authority before we can show up. And one of the things we need to include is how to evaluate the case. We need to know the information about what's a potential offset, because that goes to the value of the case. The comment I got from Paul McEllistrom, who said I could use his name, is refusing to provide this information is super dumb and short-sighted. His words, not mine. but true. So, the thing to keep in mind, I think, in terms of having all the updated information, if there's something that's really valuable and is going to substantially affect the case, and it would go from either side, at least from my perspective, is if you find this out the day before, or maybe even the week before, and provide the information, reach out to the other attorney and say, can this still be effective? Do you need more time? One of the things I got a response from someone whose suggestion was to be flexible while you're at mediation. And I think mentally that's a good strategy, but insurance companies aren't generally particularly nimble. So something that might be helpful and I might be able to use talking to an adjuster or whoever I'm reporting to, they may not have the authority to consider that. It might be something that they have to. It varies among companies, and I'm sure all of you have experienced the extremes of this, but I work with companies who have zero authority without going to their manager, and I work with companies who have authority up to hundreds of thousands of dollars before they have to go any further. But if it has to go through some process, showing up and having it at mediation or even having it the day before sometimes isn't particularly helpful. Second, before I move on, this is from Matt Steinbrink, was kind enough to let me share. This was information that he had. This was actually in a binding arbitration. Might look familiar to Brett, but he provided the kind of detailed information. Again, this was in an arbitration statement, but what I would say is not only did he lay out all of the numbers, he had all of the supporting documents with it, and carried on to the premium payments, did the math, did the calculations. So just having that information, substantial difference in the amount of offset that's available based on what the numbers look like and then what they were able to calculate and put forth in terms of the premiums paid. So all of that information ahead of time is incredibly helpful. Prepare your client. If any of you have walked up to the top of St. Peter's Basilica, the staircase is a little bit terrifying, but there's potentially a great reward at the top. So prepare your client. Another thing that very common comment from all the mediators that I had contact with was manage expectations, be prepared, and these, again, go to both sides. Make sure that anybody who's making a decision knows before they get there, the last offer, the last demand, what potential legal issues are out there. Lindsay Keller took the same courses I did to become a qualified Rule 114 neutral, used her recently, did a very nice job, and it was a slip and fall case in premises liability. Her comment was that she spent a lot of time explaining and going through with the plaintiff herself, the law and what it meant and what the hurdles are in Minnesota. And her comment was, it's really helpful if clients are prepared for these things going into it. And again, on the other side, in terms of if you're working for an insurance company, I am constantly going back to those guidelines because it's to know who needs what when. You get your reports in on time. Make sure that people have what they need in order to be helpful, have the authority you need. Greg Wyant had an interesting, maybe obvious, but interesting to think through. He said, I am at my most successful when I'm reinforcing what somebody has already told their client. I'm not coming in, this isn't a surprise, they don't have to process shocking new information. And if it really forms trust, if what you're telling the person is the same thing they've heard from the attorney or similar. Other thing I would point out, prepare your client, that I have from time to time also prepared the mediator. So I had a case where I had a client, an insurance agent in an E&O case, who there were some goofy issues with it. There were some personal kind of tangential issues that were gonna come up and create other exposures and things like that. But bottom line was he was sticking his head in the sand. He didn't want to talk about any of it. He just wanted it all to go away, but without really digging into things. He was also, I was afraid, might both metaphorically and physically run away if he got too upset. So, I called up, I think it was Rockford, called him up ahead of time and said, look, here's what I need you to push, but here's what I need you to be aware of. If it gets a little bit too touchy. Don't push too hard on, certain things. So I think it's helpful for both sides to know if there's something that you can communicate that is going to help everybody in the long run. Have a roadmap, follow directions. I'm not sure if it really goes, but the mediator, all of the mediators that I think we're all using provide us some sort of communication that tells you what they want to know ahead of time. Look at it, provide the information. Scattergood's been mediating quite a bit recently too. He recently had he told me when we talked about this, deposition transcripts. I'm not getting deposition transcripts as often anymore. So I attend, sometimes maybe my error there is that I assume that the other side might be sending things. And I think especially now in this era of everything's electronic, what does it hurt to send it more than once? But provide the information, provide the roadmap of what the issues are. I think another thing that I have seen, and the first case I mediated was an employment case, and there were competing claims. So, and it wasn't a high dollar case or anything like that. So I communicated with the parties, I asked for certain information. I said, keep it appropriate for the size of the case, basically. Don't worry about going overboard. And from the former employee's side, I got a very long letter with sort of emotional complaints and concerns outlining how everything went south with this employment, but nothing legal and nothing to support it. And then from the employer's side, I got nothing. So they showed up at the mediation, and the employer's attorney was very well prepared, and out on the conference table, he spread out about 20 different documents that he, wanted to walk through and show me how they addressed each of these concerns and complaints and, their defenses and things like that, which was helpful. But if the thought was, we don't want to spend a lot of time and money, we don't want to spend a lot of money on mediation, so I'm not going to send you a bunch of stuff ahead of time to review. I think in looking at it, I could have got 75% of the way there on my own before you had to walk me through it. So I think we ended up spending more time with, the attorney explaining to me the position. I didn't need a big statement, but it would have been helpful to see those documents ahead of time. So just remember, I got a couple of comments to assume the mediator is reading what you send. They really will pay attention to what you send and send the important stuff and send it ahead of time. That was another one. Send it, do give mediators enough time to review and absorb the materials. Make things clear. Again, Paul McEllistrom pointed out, if you think you've got a smoking gun, it might not be quite what you think it is, or it might be amazing. But if you don't rely on the mediator, don't rely on your communication to the mediator to say, hey, this is a really great point, and then that mediator to communicate it to the other room. Bring copies, highlight it, and bring something physical that can be left with the other party, because when it has to sit in front of them on a table and they have to consider it the entire time, might have more impact. Have concrete objective criteria for how you're evaluating the case. Pilney had about 20 years ago, I think, because I gave him a call and I said, Mark, I swear you had this personal injury evaluation checklist that said a whole list of things to consider and how you evaluate a personal injury case. And I can't find it. And he laughed and he said, I think that was at least 15 years ago. But I really did use it, and it really is helpful and he said, if anyone is interested in it, he'd be happy to provide it again. But it does give a nice outline of, if you want to have some clear criteria for how you're evaluating, at least in terms of a personal injury case, a checklist of things to walk through to present to the mediator. So teenagers, turns out, can argue anywhere and not let you get a good picture of them. But what I would say here is, at some point, kind of the flip side of having all of your concrete arguments, and this is one where I find myself reminding myself and my whether it's an adjuster or whoever I'm reporting to, the representative, is at some point you don't have to be right. And it usually takes me a while, and I have a feeling that most of the people in this room might have some of the same issues I have with letting go of being right, because at the end of the day, you know, especially when I have clients that maybe is more, you know, the individual client who has to participate for some reason, which, you know, on the plaintiff side, you always do, that at the end of the day, you have to agree on the number, not the why. And so at some point, you know, and some mediators, I think, get to try and move the parties here more quickly than others. But that at the end of the day, all you have to agree on is the number. You don't have to agree on why, and you don't really can let go of whether the other party thinks you're right or not about whatever your claim or your defense is. And then for those of you way in the back, there's a cat there on the roof. So this is there's more than one way to skin a cat. Be open to different possibilities. If you have if there's a potential that there's a more creative kind of settlement, like is there a Paringer option? Have you addressed a potential neg option, something like that? Look into it going ahead so that you can prepare your clients for potential, what would that look like? Would the evaluation be different in this scenario versus that scenario? When I called Pilney to make sure it was okay that I offered to have everyone contact him for his checklist, he said, don't forget, one of the things that he thought was important now is that if we're doing, use Zoom mediations where it makes sense. And I think I'm back to this, I want to get back in person. We can do all this stuff in person again. Let's get back in person. And he pointed out that by doing a Zoom mediation, you may get, something to consider for everybody's side is that you may be able to get, again, the claims rep or whoever is making the decision on if there's an insurance company on that side, maybe out of state, and instead of what we would do is, what he referred to as a warm body, just have someone who's not related to the case show up. You can actually get that decision maker there and involved by doing Zoom. That, might not otherwise be ideal. The other thing I've done, I know, is this combo of I'll show up, but have my adjuster on Zoom, and that way the mediator still has a direct connection, things like that. I think all of the Zoom and the remote working has some lasting effects in different ways, not just in the way we work and our employees work, but how can we use it in these situations like mediations. Other things in terms of being open, I know brackets aren't always everyone's favorite. Again, Rich had a recent example of parties being so far apart that maybe an early bracket and then moving away from it would have been helpful just to get everybody to agree. Nobody wanted to make the first big move. So to get everyone into a range where it could actually work. Mediator proposals is another one where I don't know if it's just me or about recently in the past couple years, I've had very successful mediator proposals. And I don't know if there's a mindset of, well, if I agree, but somebody doesn't, nobody's going to know that I was willing to agree. It's something that recently I've had more success than I expected doing that, and have had carriers pay more than I thought they would or had told me they would when it came down to that final number, and that will get it done. So the last point in terms of how to be successful is be open to those ideas, and if the mediator suggests them, worth giving it a shot. So with that, I am happy to answer questions about mediation, but also about Amalfi Coast, if that's more your thing. So let me know.
Jim was just in Italy too.
Well, and aren't your kids going? I think everybody I know is going, or.
Works for Keith Allison. One of the reasons I think she likes working for the AG's office, she's in Italy right now for 2 weeks.
They asked me,
She's gone now, so I can say that.
they asked me to be Pope, but I turned them down. I was a little busy.
All right.
Actually, I was scared to walk in the Vatican. I didn't know what was going to happen.
All right.
Next up, folks, is Matt Barber from the Schwabel firm. You've probably heard of them. And Matt's going to talk to us about the case law update. I'm sorry. Thanks, Matt. Come on up.
All right. Thanks for having me. Case law update. We're getting the slides up here pretty quick. Just a quick overview of where we're going to go with this. We're going to update on some of the cases we talked about last year, and then we'll move on to some other cases that we didn't talk about last year that weren't really pertinent last year. So the first case that we're going to talk about just came out on Wednesday from the Minnesota Supreme Court. It's Justice versus Marvel. And as soon as we get that, that'll be great. But the case, the facts of it are a 7-year-old, Justice Carter, was going to a inflatable amusement at a Pump It Up party for a friend's birthday. And in order to participate in that, his mom had to sign a waiver, a liability waiver on his behalf that we're all familiar with. And he was playing, and eventually what happened was he ended up falling and hitting his head and face onto concrete. There wasn't any padding around the bouncy house where this was. He had a skull fracture, traumatic brain injury, some seizures after that. It was a really significant injury. And when he turned 18, he commenced an action against Pump It Up for the negligence that happened there. And at district court, Pump It Up moved for summary judgment, saying the waiver that you signed, that your mom signed on your behalf, is enforceable. And the waiver's language, there we go, was something to the effect of you waive liability for any and all claims that could be asserted. And the only reference explicitly to negligence in that waiver was to the negligence of other participants. There wasn't anything explicit or clear that this was negligence on behalf of Pump It Up and its employees, only other participants. So the district court looks at the waiver and enforces it. It says that any and all is broad enough to cover Pump It Up's own negligence, so your case is dismissed. Justice appealed, and the Minnesota Association for Justice got involved in that appeal. I was involved with that on behalf of Minnesota Association for Justice. The Court of Appeals affirmed the district court. It looked at the waiver and went through the analysis that the Minnesota Supreme Court set forth in the Schlobohm case, looking at exculpatory clauses and these types of waivers. And it says, you know, we used to have indemnity clauses and we have exculpatory clauses, and there's a little bit of difference between the two of them and how we treat them. But at the Court of Appeals, we're going to look at this, and it could be overly broad as far as exculpatory language goes, but as applied, it covers Pump It Up's own negligence, so we're going to enforce it to that extent. And they affirmed. So then Justice appealed to the Minnesota Supreme Court. Minnesota Supreme Court granted review, and I again was involved with the Minnesota Association for Justice and Pump It Up, or Public Justice on that appeal, and the Minnesota Supreme Court reversed in a 5-2 decision. The Minnesota Supreme Court did a few important things with this appeal. It explained that when you're looking at the language of an exculpatory clause, you don't need to find an ambiguity in order to have strict construction apply. So it gets treated like an indemnity clause. The Minnesota Supreme Court said, you know, we used to have language saying there's a difference between the two, but we're gonna get rid of that now. Indemnity clauses and exculpatory clauses have the same strict construction application now. And then it answered another question, well, what does strict construction actually mean? It could mean different things based on the context, and in the context of an exculpatory clause, we need to have clear and unequivocal release of the party's own negligence. You need something express, unequivocal, very clear about that. And then given strict construction and its rule for strict construction, the Minnesota Supreme Court applied that rule to the any and all language. And the Minnesota Supreme Court said that just isn't unequivocal, it isn't express, it isn't clear that this is for Pump It Up's own negligence. And it pointed back to the one reference to negligence in that exculpatory clause, which was for the negligence of other participants. So that's the first case that I wanted to talk about. It's brand new, just published on Wednesday, so I wanted to let everybody know about that because we talked about it last year. Next case is Maslowski versus Prospect Funding. This is a litigation financing Champerty case. We talked about it last year because there was an appeal pending at the Minnesota Court of Appeals, and it was after the Minnesota Supreme Court had changed the common law. Before 2020, when the Minnesota Supreme Court heard this case, Minnesota prohibited Champerty. It prohibited third parties from financing litigation when repayment of those funds is contingent on the outcome of the case. Basically, a funder having a contingency fee agreement with the party. And the Minnesota Supreme Court looked at it and said, you know, our public policies have changed over the years when we enacted this in the 1890s, and we just don't see the need for this blanket prohibition anymore. So instead of enforcing this contract outright, the Minnesota Supreme Court remanded back to Hennepin County District Court and said, take a look at the terms of this contract and the contract in general and decide if some or all of it is unconscionable. So that takes us to the actual terms of this contract. It required that the injured person repay 60% interest for the funds that that the person was advanced. And it's 60% on the sum of the principal and the processing fee. The processing fee is about 25% of the principal. So if you were just looking at interest on the principal, it's well over 100% interest annually. So those are the terms. There are also some terms that kind of inhibit the person's ability to hire their lawyer, fire their lawyer, and it affects their ability to settle their case, really is what it comes down to. So Hennepin County held that a lot of these terms are unconscionable, including that 60% interest. And at base, what's going to happen is that the injured person has to pay back the principal, has to pay back the processing fee, but instead of 60% interest, there's only 8% interest because this is subject to our usury statute, which caps interest at 8%. The Minnesota Court of Appeals affirmed in its entirety. It took a look at the contract again and said, you know, the main issue was the contract says we don't treat this as a loan. So if you've got a contract that expressly says it's not a loan, do we still apply the usury statute? And the Minnesota Court of Appeals pointed to a line of cases from the Minnesota Supreme Court that says, you know, if you've got an agreement, we're not going to look at just the face of it. We're going to dig into the actual contents of it and the purpose and substance of it. And if it's usurious that way, we're going to apply the usury statute. So the Minnesota Court of Appeals affirmed. Right now, the petition for review to the Minnesota Supreme Court's pending, so we'll see what happens with that, if it finally gets resolved or if the Minnesota Supreme Court wants to take a look at it. But for anybody who's dealing with litigation finance, the takeaway from this is right now, the most interest the financier can get is 8%. So that's not too bad when we were looking at 60% just last year. Next case is Staub versus Myrtle Lake. This is a fall down stairs case. We talked about it a little bit last year when it was at the Court of Appeals. So the factual background for this one is Joyce Weeks had some kind of, I don't know if it was a formal employment agreement with Myrtle Lake Resort or if she was just kind of helping out around the resort. But she would help out by doing some of the laundry and moving things around and cleaning some of the cabins. So on the date of this incident, she was having coffee with her husband and her friend in the morning and was going to take some of the laundry in a laundry basket and go get it cleaned. The layout of this cabin is such that there's a porch on the back that overlooks the lake. And then after you go off the porch, there are two sets of stairs. One really short set of stairs that go to the parking lot and a long set of stairs that go all the way down to the lake. Nobody saw Joyce begin to fall down these stairs, but she ended up falling down the long back set of stairs. She had set the laundry basket down, and then a witness said they heard her keys fall, and then another was said that he or she saw Joyce begin to fall down the stairs, but no one actually saw what caused her to fall. So at the district court, the defense made a motion for summary judgment saying because there's no eyewitness direct evidence about what caused Joyce to begin to fall, there's no evidence of causation, and this case should be dismissed. The district court agreed, and the next of kin for Joyce Weeks went to the Court of Appeals, and the Court of Appeals affirmed. The Court of Appeals held that because there was no direct eyewitness evidence about what caused Joyce to begin to fall, the element of causation failed. In a footnote, the Court of Appeals mentioned that anything could have caused Joyce to begin to fall, including a mouse or a pesky owl, that kind of thing, even though that was not in the record. So the Minnesota Supreme Court took review after the next of kin for Joyce petitioned for further review, and the Minnesota Supreme Court reversed. And the Minnesota Supreme Court got into some really deep analysis about causation and how to prove causation with circumstantial evidence. First, the Minnesota Supreme Court cites a case called Majerus, and Majerus has pretty similar facts, but it cites it for the proposition that you don't need direct eyewitness evidence to prove causation. In Majerus, somebody fell down stairs while no one was around and wasn't found until the day after. But based on circumstantial evidence about the condition of the stairs, the Minnesota Supreme Court held that that was at least a question of fact for the jury because those stairs had been not well maintained, similar to the stairs in Staub here. So the next part was, okay, we don't need direct eyewitness evidence. So what happens when you're trying to prove a negligence case by circumstantial evidence only? And the Minnesota Supreme Court gets into, well, is the plaintiff's theory of causation consistent with the defense's theory of causation, or is it inconsistent with the defense's theory? If the plaintiff's theory is consistent with the defense's theory of causation, the plaintiff's evidence in order to survive summary judgment does not need to preponderate over it. It doesn't need to be stronger than the defense's evidence supporting its theory of causation. If the plaintiff's theory of causation and defense's theory of causation are completely opposite, if they're inconsistent, then the evidence that the plaintiff submits needs to preponderate over the defense's evidence in support of its theory. In this case, the Minnesota Supreme Court went through all of the evidence, including how poorly maintained these stairs were. The railing was kind of askew, the steps were deteriorating, and it was kind of heaving away from the building itself. And there was an expert report that the plaintiff submitted saying that the poor maintenance and degraded condition of these stairs was a proximate cause of Joyce falling down these and ultimately dying because of it. The Minnesota Supreme Court said, that's some pretty strong evidence, some circumstantial evidence, and the plaintiff's theory that the condition of the stairs caused Joyce to fall isn't necessarily inconsistent with the defense's theory. The defense's theories were, well, maybe she fell when she was picking up the keys, maybe she had kicked the laundry basket and fell, or maybe she was startled by this mouse or pesky owl. But the plaintiff's theory wasn't inconsistent because had the stairs been kept properly, or at least reasonably, she could have maybe grabbed the railing. She could have relied on the stairs that weren't heaving away from the building. So it's not necessarily inconsistent. And then the Minnesota Supreme Court says, well, even if they were inconsistent, the evidence of how bad these stairs were would have preponderated over the defense's theory anyway. So it reversed summary judgment and remanded back to the district court. And I think there's a bunch of motion practice going on in district court in that case right now. Another case we talked about last year was Poitra versus Short. This is a family member exclusion case in a homeowner's policy. The facts of this case are pretty sad. It involves a 2-year-old getting attacked by his grandparents' dog. He was a resident relative of his grandparents' home, and he was in the backyard playing with, I think it was their husky or like Alaskan Malinois, and the dog decided to bite the kid in the face and really terribly injure his eye and face. And he made a claim against the parents' homeowner's insurance, which was denied because there was a resident relative exclusion in it. Bentley Poitra, the plaintiff, on behalf, or his parents, made a claim and brought it into district court. There was a declaratory judgment action, and the insurance company argued, well, resident relative exclusion, homeowner's policy, end of story. The district court agreed, and then it was appealed to the Minnesota Court of Appeals. The Minnesota Court of Appeals agreed, and that's where we left off last year. So now it went to the Minnesota Supreme Court, and the Minnesota Supreme Court ultimately agrees and says, there's no public policy against resident relative exclusion in homeowners' policies. But the Minnesota Supreme Court's analysis was it was deeper than what the Court of Appeals and District Court had done. The Minnesota Supreme Court acknowledged that it has a long history, starting back in, I think, 1966 or maybe even earlier, of abolishing family member immunities. So a spouse could sue another spouse, a child could sue a parent could sue a child for negligence. It got rid of those judicially created immunities that used to exist between family members. And then there were cases in the 80s that showed that the Minnesota Supreme Court places a really high, or places in a really high place, making sure that the injured child is fully compensated for their injuries. And the plaintiffs in this case argued, well, if you're going to have that language that says you place this high importance on fully compensating children and you've gotten rid of these immunities, then it doesn't make any sense to enforce these exclusions that are essentially an end run around your policy of you're allowed to have a claim against your family member. The defense argued at the Minnesota Supreme Court that, well, you can get rid of an immunity, but that's different than requiring insurance coverage. That's something that the legislature has to do. And the Minnesota Supreme Court ultimately agreed with that. I haven't seen anything at the legislature after this case that would show anybody making any moves to try and get around that, but we'll see what happens this next session. All right, the next case is Smits versus Park Nicollet. This is another really recent case. It came out just a couple weeks ago. Again, more sad facts because that's kind of how negligence cases are. This one involved, his name's Brian. He was getting mental health care through the Park Nicollet system, and he had some pretty significant mental health problems that he was dealing with, and he was inpatient with it. Eventually, Park Nicollet discharged him from inpatient therapy, but he was still getting outpatient care. And his mental health deteriorated after he was in outpatient to the point where he ultimately ended up killing his spouse and their children and himself. This was in the news. It happened on Lake Minnetonka. I think a lot of us remember when that came out. The district court saw the case brought by the next of kin, and there was a motion, for summary judgment saying there's no duty owed by Park Nicollet to the next of kin for Brian or the next of kin for his family member because this was not foreseeable. There's no duty here. The district court agreed with Park Nicollet and granted that motion. And then where we left off last year was the Court of Appeals heard it and reversed in its entirety. The Court of Appeals held that as a matter of law, Park Nicollet owes a duty to Brian, and it relied heavily on a case called Tom 4, where the plaintiff was inpatient at the Mayo Clinic and committed suicide as a result of his illness, and there was a duty by the Mayo to protect him from himself because he was in their control. The Court of Appeals expanded that duty quite a bit in its decision and held that Park Nicollet still has a duty even though he was outside of their control. And it held that there was a genuine issue of material fact. That's the GIOMF there. That's how you know you do too much motion work is when you have an acronym for that. So what happened with respect to the next of kin was there genuine issue of material fact about foreseeability? Was it foreseeable to Park Nicollet that Brian would pose harm to a foreseeable plaintiff, his family members that he was being released into the care of? And based on the record, the Court of Appeals said, yes, there's at least a question of fact on that. So we get to the Minnesota Supreme Court's decision that came out 2 weeks ago, and it's one of the more complicated opinions that I've ever seen. You have to read the footnotes and the introductory paragraph to figure out which part of the opinion is the majority opinion and which part is a dissent, because the justices lined up in very different ways throughout the course of the opinion. The takeaway is the Minnesota Supreme Court affirmed the Court of Appeals that Park Nicollet, as a matter of law, owed a duty to Brian, even though he was outside of their control. And then in part 2 of the decision, the Minnesota Supreme Court held that, as a matter of law, it was not foreseeable to Park Nicollet that Brian would harm his family members after he was released from outpatient. The Minnesota Supreme Court emphasized that foreseeability really is a fact-intensive inquiry, and it goes case by case. So it held that on this record, which might not necessarily be the same for future cases, but on this record, it just wasn't foreseeable as a matter of law that Brian would do what he did when he was released to his family. All right. So those are the updates from last year. So we'll move on to some newer cases. This one is Jepson versus County of Pope. And in this case, again, really sad facts. It involves the death of, I think he was like 4, maybe. And what happened in this case was this minor was living with his father and father's girlfriend and some of their children. And there were 7 reports to the county that this child was being abused. Those reports included the child had a broken arm, had a broken back, but the county didn't follow through were the allegations. The county didn't, it didn't notify law enforcement about what was going on. It didn't interview the other children or the father face to face. It didn't consider the prior reports. It looked at each report as its own standalone issue. And it didn't send all of the child's prior medical records to the doctor who was supposed to independently evaluate whether or not there was abuse going on here that would warrant taking this child away from this situation. So at district court, the district court decided to grant the county's motion for summary judgment saying that the county is immune because they're the next of kin for this child brought a wrongful death action against the county and the Child Protective Services workers. At the Court of Appeals affirms it tells there's no duty because the county is immune under official immunity and statutory discretionary immunity. Minnesota Supreme Court takes review and reverses. Minnesota Supreme Court holds that the statute, the reporting statute, abolishes official immunity for the county. So the county has very specific duties that are enumerated in that statute. That's the white bullet point down there. Notify law enforcement, interview, consider prior reports, and send to the doctor. And the county did none of that. And the last part of that statute says, there is civil liability for this. So we get to statutory discretionary immunity. And the county argued that it has discretion to do or not do these things. And the Minnesota Supreme Court rejected that argument. It holds that these duties are mandatory and you have to perform them. And then it remanded back to the district court because there was a genuine issue of material fact about whether the failure to perform these duties, to notify law enforcement, to interview the other members of the household, consider the prior incidences, or to send the info to the doctor, was any of that conduct a proximate cause of this child's death? So we'll see what happens when it's been remanded. We talked a little bit about In re Polaris already, so we'll try and be quick on this one. But it's a products liability case where the person using the Polaris machine suffered burns. And in discovery, what happened was Polaris inadvertently disclosed this report that it hired a law firm to do. And the report is about compliance with safety regulations. And after it was inadvertently disclosed, Polaris tries to claw back this document from the plaintiff's attorney and is unsuccessful. It goes before the special master, this issue about returning this document or about should it all be redacted, should parts of it be redacted. And the special master holds that, most of this is business information, not legal advice. And the parts that are legal advice, those should be redacted. Then it goes to district court affirms. The Court of Appeals also affirms and says, the predominant purpose of this document is business advice. Where there is legal advice, then you can go ahead and redact that. The Minnesota Supreme Court takes review because the Minnesota Supreme Court hadn't officially adopted the predominant purpose test yet. And the Minnesota Supreme Court says, this is what we're doing. We're doing the predominant purpose test, and it applies that test to this document. And it goes through section by section, and it has some interesting language about compliance work, because compliance seems like it could be legal work, it could be business work, it's probably a mashup of the two. And it cites cases and other authorities from other jurisdictions saying that not all compliance work is necessarily legal work. What the legal work would be interpreting the regulation. The compliance part's not necessarily legal work. So the majority of this document is probably going to need to be disclosed and not clawed back and not redacted. But the Minnesota Supreme Court, with those instructions, sent it back to the district court to determine these issues. This is an interesting case for no-fault indemnification, American Family versus Progressive. The issue here is when you've got a really big pickup truck, a pickup truck that weighs more than 5,500 pounds, but it's not gonna carry more than 15 people, it's not designed to do that. Is it a commercial vehicle because it weighs more than 5,500 pounds? Or is it a passenger vehicle? And this gets into no-fault indemnification, because if it's a commercial vehicle, then you've got that going for you. the Minnesota Court of Appeals looked at the arguments. It said, you know, it might not be a pickup truck because it's too heavy, but so it could be a commercial vehicle. However, it's not designed to carry more than 15 people, so it's not necessarily a commercial motor vehicle. It's more properly defined as a personal vehicle. And because of that, the Minnesota Court of Appeals held that these pickup trucks were not commercial motor vehicles subject to no-fault indemnification. And then we've got Glen Eden versus Hiscox Insurance. It's a Rule 504 dismissal case, and it presents an interesting issue. In this case, the action was commenced, so the plaintiff serves a summons and complaint, but doesn't file the complaint. The defense commences the action in court by filing its answer, but not the complaint. And then after the 1 year from service of the summons and complaint run, the Hiscox moves to dismiss, saying that the complaint wasn't filed within 1 year, so the action was not filed within 1 year. The Court of Appeals takes a look at it and says, okay, the Rule 504 says any action not filed within 1 year of commencement is dismissed. The defense did file the answer within that 1 year. So does filing the answer constitute any action under the rule? And it goes through and it looks at dictionary definitions and legal dictionary definitions of action. And action means any proceeding in any court of this state. So the Court of Appeals holds that because the defendant filed the answer, that was filing the action in district court, and denied that motion to dismiss, reversed, and sent it back to district court. Last case I want to talk about is Zika versus Elder Care of Minnesota, another fairly recent case from our Court of Appeals. And in this case, it's another immunity type case. It is a private guardian immune from liability for negligently providing care, comfort, and maintenance to the person subject to the guardian. And the issue here was just really bad maltreatment of this person subject to the guardianship, such that this person passes away allegedly from that negligence that happened there. And a secondary issue that was brought is the Wrongful Death Act, or Wrongful Death Statute in Minnesota at least partially unconstitutional because it treats different classes of people differently. The Minnesota Court of Appeals looked at the first issue and only the first issue, and it holds that the plain language of this statute grants the guardian immunity. And because the types of duties that the guardian has that are enumerated by this statute that gives it immunity, because all of the plaintiff's claims fall within those duties from which the guardian is immune, there is no claim, and it affirmed the dismissal. There is a petition for further review pending with the Minnesota Supreme Court. So it'll be interesting to see if, one, the Minnesota Supreme Court takes review at all, and if it does it take review of both issues, the unconstitutional issue or just the guardian statute issue? I've got a few minutes for questions if anybody has any questions.
That's a really good job.
All right, thanks.
Thanks, Matt. Thank you, Matt. Walt's got a private question for Matt. Walt, is that a question that you should share with the audience, or are you just making time there so he can help you with your next issue? All right. Matt, you're well on your way to a sport coat. Nicely done. Yes, all right. Next up is Shayna Long, who's to my left. Shayna actually works out well because when the ethics folks were talking about the mental health of lawyers and what an issue that's become in these times, and that was not a setup for Shayna, but I heard it and I thought, well, this is perfect timing. Shayna's a little bit of a different topic from our normal stuff that's on the agenda, but I thought it was very timely. The Paul Peterson's bench and bar last letter to readers had to do with dealing with stress and those sorts of issues. So I thought that when Shayna suggested this as a topic, when I asked her if she wanted to speak, I thought it'd be excellent. So anyway, Shayna's with Dave Werwing Associates and State Farm, and she's been there now for 2 or 3 years. 2.5. She worked Foley and Mansfield, actually, in southern Illinois, Marion County, which the insurance industry would say, at least last I read, was one of the United States judicial hellholes where she defended cases. So she's seen the worst of times, at least from the defense perspective. All right, Shayna.
I don't have pictures of Italy, but I do have pictures of my dog on here, so hopefully that'll be just as exciting. So I have a question for you, and I want you to think long and hard about this. What would you do if today your license was suspended for 90 days? Some of these symptoms of depression, anxiety, and stress include outbursts and or having short-temperedness with opposing counsel or somebody you shouldn't have short-temperedness with. That can result in a suspension of your license or potential reprimand from the board. Edward Cleary is the director of Minnesota Office of Lawyers' Professional Responsibility. He wrote an article called Professionalism, More Than Civility, for the bench and the bar. In that article, he wrote that they receive complaints from one lawyer, often filed by another attorney, and it's usually after a round of name calling, saying something derogatory, maybe during a deposition, and usually a lot of those complaints are just, wiped away despite their surprising lack of professionalism. Sometimes the language, however, can be so egregious that under 4.4, they issue discipline. Cleary notes that other jurisdictions, such as New York, have been holding attorneys accountable for whatever they say, and they actually go with severe sanctions. Here in Minnesota, an order came out of a petition alleging that the respondent in that matter committed unprofessional conduct, and he actually got a public reprimand from this. He was in a courtroom in the presence of his partner, the presence of opposing counsel, two co-counsel, and her client, and he referred to opposing counsel with a derogatory expression and told her to shut up. Why is this important? Why am I up here talking about mental health? One, because it's important for your license. Two, because there's a stigma about it that I really want to get rid of. And I'll go through some other reasons why here in a minute. I really wanted to show you this video today. I know with YouTube issues and replaying those over recordings, I can't do that. So if you get a chance, I really recommend you go onto YouTube, find this video by Lawline CLE. It's called 20% of Lawyers Screen Positive for Major Depression. They go through the prevalence rate of depression among our profession. Honestly, some of these numbers aren't that surprising to me. The first study that they talk about was conducted by ABA Hazeltine Betty Ford in 2016. Out of 12,825 active licensed practicing attorneys, this is a self-reported study across 19 states, 28% tested or screened positive for depressive symptoms. Now, they note in the video that out of the general population, only 79% screen positive. That's hugely significant in our profession and something we definitely can't ignore. Lawline discusses in the video that depression can lead to suicide, and we know that's true. And the video goes on to discuss how 80% of the time, major depression is treatable when that treatment is sought. It discusses that 50% of the time, if treatment is not sought, another second major episode will happen. If it's not sought again after the third time, there's a 90% chance of having a fourth episode of major depression. Now, how scary is that? Your friend, your coworker, people that you've worked with in the past, people who deal with this all the time. It's absolutely horrifying. One thing that was said in the video that actually did really shock me was that people are dying because they aren't willing to get help. Now, I know those statistics are pretty depressing, and I'm not up here to depress you and make you upset. But that's not why I'm up here at all. I want to bring attention to this. Again, for your license, you don't want to say something because you're stressed out that's going to get you suspended. Also, to save lives. This is something that's treatable and we can help each other. I don't want people who suffer with depression, with anxiety, with stress, with any of that to feel scared to talk to people when they need help. Or if they don't really need professional help, to seek out the help of a local bar. Just have an organization. I want you to ask yourself, because this is also hitting home for me as well,
Have you been open to somebody coming to vent to you, or have you seen somebody struggling with the signs of depression or anxiety and just walked away, turned the other cheek? Sometimes it's easier to do that. Now, are these statistics surprising to you? Like I'd mentioned, to me, not so much. Compared to many of the highly respected attorneys in this room, I've not been practicing that long. I'm 8 years out from graduating and getting my license, so really not horribly long. But over my career, I have realized how stressful our profession can be, yet I'm still here. What is surprising to me is that there's so many people who are afraid to discuss these issues. There's a stigma about it, and I'm still trying to figure out why. I mentioned to you about that large nationwide study, and I'm going to talk about it again. Patrick R. Krill and R. Johnson wrote an article called "The Prevalence of Substance Abuse and Other Mental Health Concerns Among American Attorneys." They state that a large nationwide study of 12,825 licensed, currently practicing attorneys, 28 reported symptoms of depression, 23% indicated having mild to extremely severe stress, and 20.6 engaged in problematic drinking. You know, some of these studies also show, this one's from Brown GL in benchmark reporting, the attrition rates among women are 150% higher than that of men. You know, I know depression and anxiety, they don't discriminate on who they'll hit. It can be anybody. But there's no doubt about it, a lot of women deal with having children, trying to make a partner, trying to deal with home life versus work life. I have friends with children. I don't have kids, and I don't know how they do it. You have all my respect in the world. This is my dog. I love him. So we all know how stressful trauma can be. The ABA discusses compassion fatigue, and I want to talk with you for a minute about that. If you go on the Commission on Lawyers Assistance Programs on the ABA website, there are a ton of different resources. I encourage you to go check it out. So what is compassion fatigue? The ABA states that compassion fatigue is the cumulative, physical, emotional, and psychological effect of exposure to traumatic stories or events when working in a helping capacity, combined with the strain and stress of everyday life. Didn't I just describe our profession? It's what we do every day. The ABA states that this is different than feeling burned out because burned out is a feeling that's predictable and it builds over time. The ABA lists several symptoms of compassion fatigue, starting with having a client and work demands regularly encroach on personal time, feeling overwhelmed physically and emotionally exhausted, having disturbing images of cases intrude into your dreams and thoughts. I will say this happened to me actually before I became a lawyer. When I was studying for the bar exam, I had a dream that I was late to the bar, they locked the doors, and then I couldn't take my test. It still happens, but with different situations. They go on to list that becoming emotionally detached and numb in your professional and personal life, and with that you experience increased problems in personal relationships, withdrawing socially and becoming emotionally disconnected from others, becoming demoralized and questioning one's professional competence. I won't tell you how many times I go into my colleague Jody's office and I question her on if I know what I'm talking about. We know what we're talking about, but why do we do this? I send an email out, I'm like, did I spell this right? Did I copy the right people? Did I send it to the right people? Did I actually put the attachment on there? I don't know why we do it, but we do. The last couple, secretive self-medication and addiction, such as alcohol, drugs, work, sex, food, gambling, and etc., and becoming less productive, effective, professionally and personally. Now, there's treatment for this. I'm going to go through some tips. I'm going to actually have you all help me with a couple things in a little bit. But I want to talk about what the ABA lists as far as treatment for compassion fatigue. So they list awareness, which you all know about it now, debriefing, talk with a practitioner who understands and is supportive, self-care, balance and relationships, professional assistance, and being intentional. So why is well-being important? Why does this matter? Why do we care about these numbers? Well, first off, they're staggering. Imagine being stressed out, depressed, anxious. You can't get out of bed. You can't function. You don't want to have dinner with your spouse. You don't want to make food for yourself. You're barely hanging on to life. So often our mental health connects with our physical body. For me personally, I know when I get stressed out, I really feel it physically. I start getting sick more in the winter. We know depression, anxiety, and stress all hit us first mentally, right? But in order for me to function, I need a clear mind to be able to physically function. The healthier the mind is, the more the body can function. In order to live, we need to focus on having a healthy body, mind, and focus on well-being. Something else that I thought about as well, and why this is important, for compassion. How easy is it to focus on your own lives, our own problems, turn the other cheek when somebody needs help? It's very easy, but showing compassion to others is worth it because we could save somebody's life. So enough about the depressing statistics. I'm gonna go on to say what can we do now to help fix this, some tips and tricks. Meditation. So I feel like this is one of the most overlooked things that we can do. I'm not telling you to go to a hot yoga studio, fall on your face, try some inversions. I'm not gonna have you do any funny poses in here. But this can be as much as deep breathing. Take a minute to move your mind away from the stressful situation. And I want you to do this now. This isn't a request, it's a demand. I want you to try this with me for a second. I want you to close your eyes. Take a deep breath in and hold it for a moment. Breathe out. Let's do it again. Let's take a deep breath in, hold it for a second, and breathe out. Now open your eyes, shake your body off a little bit, and ask yourself how you feel. Now I know this was only a couple seconds, but really, if you think about this, if you're really stressed out and you can clear your mind, this helps. Now the second thing is pets. Who in here has a cat or a dog or some other animal? Yeah, a lot of us. Sometimes dogs can be slightly more stressful. I'll say I had a mediation with Roger. I had a mediation with Roger Kramer the day after we adopted our dog, and he decided to show up on camera. This was during the pandemic time. But animals can create also a calmness in us. An article written by Johns Hopkins Medicine says that research has shown simply petting a dog lowers the stress hormone cortisol, while the social interaction between people and their dogs actually increases the feel-good hormone oxytocin. And that is from hopkinsmedicine.org. The article is called "The Friend Who Keeps You Young." You can ask my coworkers, I have a couple here with me today, how much I love my dog. I love him more than anything in this world, except for my husband, of course. But it's amazing how much better I feel when I walk him, when he's there with me. He can just, I don't know, feel what I'm feeling. I know probably not all of us are dog or cat people or other animals, but if you have an interest, you want to get involved, you can't own a pet, but you want to get involved with being around them, there's a lot of organizations like Forever Home Rescue, where we got Tate, different rescues that put on events where you can go and pet animals, and we actually had one last week where we had a kissing booth with the dogs. So if you're interested in checking it out, you can ask me more about Forever Home, or you can check out other different rescues. Weightlifting and exercise. Now, who's actually thinking exercise helps when you're putting more stress on your body? This also isn't really a fun thing to talk about. But according to the Mayo Clinic, exercise can help ease depression and anxiety by releasing feel-good endorphins and taking your mind off of worries. Additionally, the Mayo Clinic indicates that regular exercise has many psychological and emotional benefits, and it includes the following: gaining confidence, getting more social interaction, and coping in a healthy way. Now, for some of you that I'm close with, you know that exercise is one of my favorite things to do. In my free time, I work out about 6 days a week, eat pretty healthy for the most part, but I remember standing in my closet 10 and a half years ago, and I was trying on clothes for law school, and we couldn't wear jeans in our law school, had to actually dress professional, and it didn't fit. And I remember feeling an extreme amount of sadness and just upset, and I'm like, I need to take control of my body and my health, and I started from that day forward, and I did. I didn't realize at that point how much of an effect that would have on my mental health and my physical body now. And I'm not saying we need to work out for just physical, but it really helps us mentally. And I'm not telling you to go to a gym and lift 200 pounds and to do some things that you're uncomfortable with. I'm actually telling you the opposite. Start small. Start walking, running, swimming, play with your pets, your kids, your spouse. Just do anything that gets your body moving. Minnesota, how many state parks do we have where we can go out and hike? Just make a commitment to yourself and don't give up. I believe in you. I know you can do it. Now, healthy eating, I know this topic probably sucks a little bit more than the last one, but the Harvard Health Publishing wrote an article that discusses diet and depression. In that article, they discuss how diet is an important part of mental health and that it inspired an entire field of medicine called nutritional psychiatry. They state that what we eat matters not only for every aspect of our health, but for our mental health. Now, does that also mean that you need to go spend thousands of dollars on wiping out your fridge and getting all new food from your home? No, that would actually probably add more stress to your life than what you need. Start small, one change at a time. Instead of a soda, take water if you drink it weekly. Pick an apple instead of a candy bar. And I know this isn't always fun, but if you really want to feel better, this is one way to do it. Don't deprive yourself. Pick and choose healthier options. Now, a couple other tips. Leave work at work. How many of us like to take work home with us? Whether it be thinking of an email that we need to type, trial preparation, thinking of deposition questions that need to be asked. There are times where we have to pull all-nighters. It does happen, but it's not something we need to do daily. When you get home, unplug. Put the phone away, put the email away, and really just unplug and spend time with those who are around you. Some of us also have a stressful at-home life, but do what you can to take a step away. Even if it's just for 30 minutes, your mental health, it will really thank you. Join a group of attorneys or friends. Many individuals are struggling and they think that they're the only ones dealing with what they're going through. That's absolutely not true. Some are also fearful to talk about everything that they're going through because of the stigma that I mentioned. I want to get rid of that. We need to be able to feel confident that we can talk to each other. According to the Mayo Clinic, talking with friends, family, or a local support group can bring many benefits, including feeling less lonely, feeling less isolated or judged, reducing stress, reducing depression, anxiety, or fatigue. You're able to talk openly and honestly about your feelings. It improves skills to cope with challenges, and you can gain a sense of empowerment. Find a local bar group, and I'm not talking about the bar down the street where you get a ton of alcohol, okay? Local bars such as Lawyers Concerned for Lawyers, MSBA, or MDLA. Jody Martineau and I just started the wellness committee with an MDLA, and we're gonna try to have quarterly meetings where we can get together and have a breakfast for people to just talk and vent. There are people out there who care. So be on the lookout for those if you're in the MDLA, Brendan. So, lawyers have one of the higher stress professions. We know that. Our feet are held to the fire constantly with what we have to do. It's hard to find a good work-life balance. Take some time to reflect on the positive changes that you can make in your own life, your own mental health, but also for the others around you, because you're worth it.
Any questions? That was a really good job.
Thank you.
Our next speaker is my law partner, and I'm incredibly honored to introduce Matt Steinbrink. Matt joined us several years ago, and he's actually a trial lawyer who tries cases. And he's one of the smartest lawyers I know. He's going to talk to us about some Medicare issues, and God, that's so exciting. I can hardly wait.
Well, first and foremost, thanks for inviting me to speak here today and spend some time with you all. I feel a little bit self-conscious first off because Jessica, I don't know if she's still, oh yeah, she's over there, had that wonderful Italian presentation of the slideshow, and Jim's talking about all of his Italian vacations and how this pandemic is wrapping up. And I think Jim gave me a Zoom subscription and a box of masks. So I'm gonna have to talk to him after the event and see what we can do about that. But the purpose of what I'm doing here today is just to talk about some issues with Medicare and how you can work with them. The thing that I get a lot of the time is you mention Medicare and you think they're big, they're scary. You hear things like super liens and double damages and all these scary things that can happen. And are they things that can happen? 100%. But you got to be careful and do it the right way. And there's a number of things that you can do when you have a Medicare claim and you resolve a case. One of them, it has become more of a predominant thing now, or there are companies out there obviously offering services to handle Medicare liens, and that's a perfectly fine way to do it. I myself wouldn't be adverse to using one of those if I've got a large claim, but if it's a smaller claim, I may as well try and do it myself rather than burn the money on a third-party vendor. So that's kind of what I wanted to talk with you a little bit about, because when that settlement comes up, you've got a decision to make. And the decision is, am I going to just roll over and pay this claim, or am I going to give it some scrutiny and see whether or not the requests of Medicare are reasonable? Because sometimes they're not. I'll give you a couple of examples, and with most things in law, it depends in terms of what kind of result and what kind of action you're going to take. But first and foremost, you got to decide, look at what kind of claim you have. Is it a slip and fall claim? Because if it's a slip and fall claim, you know what the issues are going to be. They're going to have to deal with the liability prospects and potentially some damage issues. But liability is going to be your number one issue. So you have to consider that when you're looking at a Medicare appeal. You may have an auto case, okay? Rear-ender auto case, there's no liability issues, it's solely a damage case. You could have big damages, you could have small damages. And you've got to look at that and make a decision as to whether it makes sense to get involved from the perspective of, am I going to try and resolve this on behalf of my client without involving some third extraneous party, or am I going to take care of it? In an auto case, again, you can have a multitude of damages, and I'll give you an example, because I've got a couple of these right now, but there's the differing level of damages is really what, for me, in an auto case, sets it apart. You can have death cases, right? But if you've got Medicare, example of that would be somebody is hurt in an auto wreck and they spend 3 weeks in the hospital, the medical bills rack up. Now you've got a Medicare lien of, $100,000. What are you going to do with that? I would encourage you all to think ahead of time on those cases, because if you look at the, is it the Marcotte or Marcotti? Matt Barber would know off the top of his head, but the Marcotte decision, consider whether you want to bring the medical expense reimbursement claim. You don't have to. You don't have to. That's not your role. And if you don't, what are you going to do? Are you going to craft that complaint so that there are medical expenses in it? Because that's not going to get you anywhere. You're going to get tangled up in Medicare's nonsense with that. So that's an entirely different seminar altogether, but it's something to consider when you're looking at, I've got a death case, I've got some Medicare involved. Well, I better think about what I'm going to do with this and how I'm going to get it to the finish line. Also, I think it's important, you got to look at the timing of the claim. Sometimes medical bills will be, decades past, not decades, but distant past, whereas, other bills are still being incurred. So those, again, are considerations. Is the claimant done treating? Have they healed up? Are they done? No. Are there more treatments that need to be coming into play? So when I look at that, those are the things that I sort of take into consideration. And how much time is it going to take me to do this? Because again, if I can pay somebody else, a marginal amount to resolve this for me, and I don't have to devote, 3 days of my time to it, then by all means, it makes sense. But if it's the other way around, then, it makes sense for us to try and tackle it. So those are the things. Couple of case examples I have that hopefully will kind of demonstrate. And I'll give you the easy one first, because the easy one is easy to resolve. I had a client, elderly client, gets in a car wreck, knocks her head on the window, has residual headaches for, 3-4 months afterwards. 8 months later, she has a stroke. Well, what kind of symptoms is she having from the stroke? Headaches. Okay. Well, do you think that those are related to the stroke, where she stopped when she stopped treating and now is dealing with that, or is it from the car wreck? Well, Medicare doesn't care. They may miscode or just simply misapply that. And if they do it, then becomes your problem to rectify that situation. So what are you going to do? What I would suggest in that situation, and I'll get to it here in a minute, but that sort of thing can be easily rectified. Medicare has a 5-level appeal process, and maybe this is a good time to throw some slides up here, but this is their appeal process summary, and it really just runs through the different level of appeals. The first 2 levels of appeal are very cursory. There's not a lot of back and forth with that, but I would encourage you at the first level of appeal to absolutely include whatever you're going to include as part of your appeal, because you want to perfect your record. You don't want a bad appeal when you end up at the 4th level or the 5th level in district court, or the 3rd level even, and find out, oh, I needed to include that IME in my prior submit? Okay, well, I better do that next time. So make sure you include everything, whether it be IME reports, reconstruction reports, medical records, whatever it is, make sure it's included. And the other thing I would encourage you on that, just from experience, is if you put a packet together that you're going to ship off to Medicare by way of either mail or electronic portal, you should base those submissions, because when we get down to the 3rd level of appeal, you're going to be talking to an administrative law judge. And I'll tell you kind of what happens in that situation. But on the 1st level, there's a Medicare portal that folks can access, at least if you're a claimant, to set up a claim, to send a letter of representation, to get the ball rolling, if you will. Once that's done, you'll get a bunch of notices. Excuse me, let me go back here. Notice letters. You'll get a conditional payment letter. That tells you how much is going to be owed. You're going to get a rights and responsibilities letter. That's going to tell you what you got to do. But this is the one you want to watch out for. That's the final demand letter. That's where Medicare says to you, this is what you owe us. This is what we want. Because at that point in time, if you need to make an appeal or dispute their payments, that's when it starts the clock running. So then we go to the appeal process of Medicare, which is not exactly a treat, but it's multi-leveled. So the first level, it's just a claims adjuster, the same one that made the initial determination. I've submitted 2 different ones through that. They get rubber stamped down to level 2 pretty quickly. Unless it's that knock on the head, and then you've got a big causation dispute, and you can clearly see, because of the medical bills or the billing codes that are involved, that, hey, this wasn't related, and it was simply misapplied to the lien. So first level is probably going to get denied. Second level will probably get denied, but the decision maker there is an outside contractor. So it's somebody outside of Medicare that did not take part in the prior meeting or the prior decision. I've had those denied. I've had to go to the Office of Medicare Hearings and Appeals. Those folks administer the ALJ appointments. So what you'll do if you get to a 3rd level appeal is basically set up a hearing. And you're gonna have a hearing with a judge or a judicial officer of some sort that is going to hear your argument. Typically, there's not anybody else there. Typically, it's just you talking to a judge, but you're presenting your case. You're telling them why you think the claim should be adjusted or why the claim should be changed in some way, shape, or form. And so you want to be able to do that. And what I've met, like I mentioned, it's very helpful to have at least a based record, so that if you've got a voluminous pile of medical records for an ALJ to review, you can at least point them to the high points. Hit that one, hit that one, hit that one. Because those are the ones that are going to give you some traction with the ALJ. If the ALJ gets denied, goes down to the 4th level, which is the council. Have not had to do one of those yet. And then obviously the 5th level is a district court action in federal district court. So really it's talking about, what you're wanting to get to here. Oops. There we go. again, the decision makers, I kind of touched on those already. This is just the appeal process. It was a fancy little kind of color-coded appeal thing that came out of this brochure that I was able to get. This is actually part of a Medicare brochure, but it's a very helpful brochure. If anybody wants it here and decides, hey, I'd really like to have that, send me an email. Happy to give you a link to it. But it's a great brochure because it goes through each level of the appeal, tells you when you have to request the appeal, tells you what you got to do, tells you what form to fill out. It's not that difficult, folks. It's really not. And they even go through explaining to you what it is. Hey, this is what you ought to do in terms of looking at big picture stuff and submitting your materials. Again, timelines are outlined there. There's sometimes, you'll see in the bottom there, I don't know if you can read it, but is there a minimum AIC, which is amount in controversy requirement. Some of the appellate levels do have a minimum controversy amount. So if you're talking about a $500 bill, the chances of you having to run through an appeal are probably slim to none anyway, but several of the appeal levels do have a minimum amount in controversy, and they will outline them in this handy-dandy little handout that I have here. Requesting the appeals, you can do it in a number of different ways. You can do it by written presentation. You can do it by this form that Medicare has. You can do it through their portal, which is, I would encourage you to get familiar with because it's a very beneficial way to do it in terms of trying to cut the paper out of the equation. But this is just the form that you fill out for the second level appeal, come up to a third level appeal. Again, you're somewhat presenting some of the same stuff, but you're going to get a different response in all likelihood because you have a different decision maker. Remember the first two decision makers, the first one is just going to be your Medicare claims adjuster. The second one is going to be an adjuster that's independent from Medicare and did not participate in the underlying. So then by the time you get to third appeal, you might be presenting much of the same evidence, but your audience has now changed. You now have a body to talk to and at least argue to and get your point across. Let me just run through here these quick. This, again, this is just another request for hearing after the ALJ makes a denial, if there is a denial from the ALJ. Again, it outlines what you do need to present and what you need to provide to Medicare for them to consider the appeal. Again, just a sample of the form. Fifth level appeal is reviewed by the district court. The thing that I suggest that you think about, again, basic stuff. Make the appeal in writing. File on time. Include the decision letters from the underlying. Include IME reports, stuff that's going to help you out in terms of a causation dispute. If you get a causation dispute, you're almost assuredly going to get to the ALJ level, if not further. So I've found that trying to argue causation through the portal, it doesn't work unless it's just, like I said, one of those situations where it is so abundantly clear that it's not caused by whatever incident brought you to the table. So I think that's pretty much what I had for you guys here today, unless you've got questions or anything I can answer for you. Yes, ma'am. That's a great question.
Could you repeat it?
Yep. What do we do? What's kind of the status of what we do now? Of what do we have to do to consider Medicare's interest at the point of settlement? I don't know that there's a perfect answer to that, Jess. I really don't. I can tell you what I do, which is I look at the things that I mentioned. I looked at my bills. I look at what I'm claiming. I look at what kind of potential defenses there might be to it. But I don't think there's any hard, fast rule at this juncture as what constitutes a consideration of Medicare's interest. That's the stuff that I Absolutely, and the question was, you know, if there's IMEs or those sorts of things, does that help you in terms of presenting to them? And yeah, by all means, I'm gonna use those IMEs that the defense went out and got. I'm not gonna go pay for another one, obviously, so I'll absolutely use that to be able to challenge any decision on causation. So, again, the causation disputes, you're gonna end up back up at the third level anyway, because those first two levels aren't, unless it's such a clear-cut causation dispute, they're going to probably say we want our money. Any other questions? Okay, great. You're right.
Well, we now know who the Medicare go-to guy is. Who knew? Nicely done, Matt. Very good. All right. Next up is Persis Meshkat from Arthur Chapman, who is over to my right, who's going to talk about defamation. And this topic came about based on a case, actually, that I mediated with her and others. And then I happened to be doing a little research on Google and determined that Amber Heard was defended by travelers in the case involving Johnny Depp. And so I think it's going to be a burgeoning area of practice with all the bad things people say about each other on the internet and who they're publishing them to, and the fact that a lot of insurance agreements, specifically umbrella policies, both commercial umbrellas and personal umbrellas that many of you I'm sure have, cover defamation and a lot of other torts that people are prone to commit that maybe they don't even know exist. So she put together this almost like a law review article on defamation. So I thought, well, you've just written yourself into speaking. So with that little bit of background, Persis, come on up and talk about defamation.
Okay, good afternoon, everybody. I'm going to give you guys a little primer on defamation law. I think you guys probably have at least a general understanding of what defamation is, which is somebody makes a false statement about someone else and that hurts their reputation. In most states, it's not a crime, it's a tort. It includes libel, which is written statements, and slander, which is oral statements. For the purposes of my presentation, I'm going to call it all defamation, and I'm not going to distinguish between the two. There are 13 states that do criminalize defamation. That includes Minnesota. And so the balance of competing interests. On the one hand, someone shouldn't be able to ruin your life by telling lies about you, right? But on the other, we want people to be able to speak freely without feeling fear of litigation over every dispute, every disagreement, insult, or mistake even. You know, political and social debate is important in a free society, and we obviously all don't have the same opinions and beliefs. So how do you prove defamation? Defamation laws vary from state to state, but essentially they all boil down to kind of the same things. A plaintiff suing for defamation has to show three things. One, the defendant published a statement about the plaintiff. Two, the statement was false. And three, the statement harmed them in some way. Now, published in terms of defamation law doesn't necessarily mean, you know, published in a newspaper or book. Published just means it was communicated to a third party. So a statement could be published at a town hall meeting, at a cocktail party, in a tweet, or in a text message. Falsity. What is false? That might seem like a straightforward question, and it's really not. According to Minnesota Civ Jig 50.25, a statement or communication is false if it's not substantially accurate. Substantial accuracy doesn't require every word to be true. A statement or communication is not substantially accurate if its essence is not true. So another way to say this is if it's true or substantially accurate, it's not defamation. So if someone goes around telling the whole office that you slept with your assistant and it's embarrassing, it's humiliating, your reputation is ruined, if it's true, it's not defamatory. Similarly, if someone goes around telling the whole office that you slept with your assistant in the elevator, but it actually happened in the conference room, that's probably going to be substantially accurate and not defamation. Another aspect of deciding whether something's false is whether the statement has multiple interpretations. And I saw the case law update had some good cases on this topic. But a statement that has multiple interpretations is not going to be defamatory if one reasonable interpretation of the statement is substantially true. So the Minnesota Court of Appeals has this test, this substantial truth test, and it's very broad. And if any reasonable person could find the statements to be supportable interpretations of whatever the statement's about, the statement's not going to be defamatory. Even if a reasonable jury could find that the statements were mischaracterizations. An example of this is like a sports commentator, who's advocating for one of many feasible interpretations of a sporting event. So he or she's not going to be liable for defamation just because there's another interpretation that exists. And this makes sense, right? Because the reason that these kind of statements can't be the basis for defamation is because there's no ability to show that threshold falsity. There was a case in 1996 where a former medical consultant for the university football team brought a defamation action against a host of a radio sports talk show. And it was based on the host saying that the medical consultant had operated on 12 injured players in one season and that, quote, nobody ever came back to play. The court actually held that the statement, when taken in the context of sports talk radio, was substantially true and wasn't actionable, and that's because a reasonable person could have understood that statement to mean different things. One interpretation would be that this medical consultant is totally incompetent. But another reasonable interpretation would be that the medical consultant insisted that these athletes took longer to recover than this host believed. So the statement has to reasonably reasonably be interpreted as stating facts. And sometimes, surprisingly, it's not clear what a fact is. Sometimes it's simple, calling someone a troublemaker. That's not actionable, and that makes sense. There was another case where an internet statement on this physician rating website posted by a patient's son, stating that the physician told a stroke patient that it didn't matter that the patient's gown didn't cover his backside. And that was held to satisfy the substantial truth test and therefore didn't constitute defamation because the physician had admitted that he told the patient that the gown looked like it was okay because it didn't appear to be at risk of falling off of the patient. I see both sides to that. The case of Ruth Ann Nichols, I think this was a good example of this substantial truth test. This is a Tennessee Supreme Court case from 1978. And in 1971, there was a newspaper article in Memphis that reported that Ruth Ann Nichols had been shot with a .22 rifle, and she was treated at a local hospital for a bullet wound in her arm. The newspaper reported the incident took place when the shooter arrived at Ruth Ann's home and found Ruth Ann with the shooter's husband. The newspaper went on to report that according to the police report, the shooter fired several shots at her husband, who fled the scene, and then the shooter entered Ruth Ann's home and shot Ruth Ann and hit her in the arm. Ruth Ann and her husband sued the newspaper for defamation and invasion of privacy because They claim that by omitting the fact that there were actually many other people at Ruth Ann's home for a party, the newspaper falsely implied that Ruth Ann was having an affair with the shooter's husband. So the newspaper defendant's main defense was that all the material facts that they reported were actually true. And the article never said that Ruth Ann was having an affair with this man. The newspaper said that Ruth Ann was in fact treated at the hospital for a bullet wound in her arm. A 40-year-old woman was in fact held by the police in connection with the shooting. A shot was in fact fired at the suspect's husband, so on and so on. And the trial court actually accepted the newspaper's argument and granted its motion for a directed verdict. And the Court of Appeals reversed, and the Supreme Court of Tennessee granted certiorari. And the Supreme Court affirmed the appellate court's reversal because, you know, even though every material fact in the newspaper article was true, it obviously conveyed a false and defamatory implication that Ruth Ann was having an affair with this shooter. So this really shows how the substantial truth doctrine focuses on the meaning, the gist, and the essence that's really being conveyed by the statement, and not necessarily just if these specific facts are true. Minnesota law imposes a reputational harm prerequisite in all defamation actions. I'm going to talk about defamation per se in a little bit. That's slightly different, and that doesn't require a harm to reputation, but if it's straight up defamation, you have to have reputational harm. And a lot of cases I see talk about this as requiring the statement to expose the plaintiff to public hatred, contempt, ridicule, or degradation. And that seems like a high bar, but it's really not. Okay, so what's the standard of fault here? What does the plaintiff have to prove? Does the defendant have to have intentionally made the false statement? Does the defendant have to have negligently made the false statement? Does it matter? There's two general approaches to figuring out whether a higher standard of proof applies here. The first is the subject matter of the statement. So here, is the statement a public or private matter? And the second approach focuses on the status of the person that's claiming the defamation. Is the plaintiff a private or a public figure? Statements about matters of public concern are generally granted greater First Amendment protection from liability for defamation, and the common justification here is that a well-informed society is a healthy society. And without that protection, the media and people would self-censor, depriving society of needed information. What constitutes a matter of public concern? There's no real clear test in the case law. I've seen so many opinions where the court just issues this unadorned statement that the defamatory expression is a purely private matter or it's a public matter, and there's just no analysis. The Supreme Court has decided that deciding whether speech is public or private does require an examination of the content, form, and context of the speech as revealed by the whole record. But telling courts to look at the content, form, and context of a statement as presented by the whole record, to me, really says nothing at all about how to determine whether speech is private or public. So lower courts have understandably reached widely incongruent conclusions about what constitutes speech on matters of public concern. There's some obvious ones, but sometimes it's tricky. You know, if a former wife claiming she was abused by a former husband in an interview that's published with a nonprofit that supports domestic abuse victims, is that a private matter or is that a public matter? I really see both sides. In addition to cases involving matters of public concern, a heightened standard of fault also applies to public figures. In 1964, in a case, New York Times v. Sullivan, the Supreme Court first announced this actual malice standard to defamation cases that applies to public officials. Public official plaintiffs had to show actual malice meaning that the individuals who criticized them knew the information alleged to be false, or they acted with reckless disregard for the truth. The court set this high standard of proof for public officials to promote the First Amendment goals of open and robust debate and to prevent any minor factual inaccuracies from chilling any criticism of the government. And then in the 60s and 70s, the Supreme Court expanded this actual malice standard to a whole new cast of characters, which are public figures. Involuntary public figures are people who become public figures through no purposeful action of their own as a result of some publicity, even if the person doesn't want it or didn't invite it. An example of this is like an air traffic controller after a major plane crash. That would be an involuntary public figure. All-purpose public figures are people who have attained that status by assuming some role of special prominence in society, right? They have a very strong persuasive power and influence, and so they're deemed to be public figures for all purposes. This would obviously be politicians, professional athletes, movie stars, leaders of big corporations, things like that. Limited purpose public figures are people who have thrust themselves at the forefront of some sort of public controversy. An example of that would be a retired general talking about national security issues, a college football coach accused of fixing a football game, a lawyer engaged in a very public trial involving police brutality. All those people have been held to be limited purpose public figures. So if a plaintiff is a public figure or the matter at issue is of public concern, this actual malice standard is going to apply. An actual malice in defamation context is making a statement while either knowing it's false or acting with reckless disregard for the statement's truth or falsity. And the actual malice standard focuses on the defendant's state of mind, actual state of mind at the time of the publication. So unlike negligence, it's not about what a reasonable person would have done in those circumstances. It's about what the defendant actually thought at that time. And this is a really difficult standard for plaintiffs to establish. So private speech, when the parties are private parties and the topic is a private topic, the rules totally change. The constitutional protections afforded to matters of public concern or public figures goes out the window, and they doesn't extend to private plaintiff, private issue defamation cases. The reason given for this is that, on matters of purely private concern, there's no threat to free and robust debate of public issues. There's no threat of liability, of causing any reaction of self-censorship by the press. In private plaintiff, private matter defamation cases, Minnesota common law is supposed to be followed. And according to Minnesota's appellate courts, under Minnesota common law, there's no distinction between fact and opinion. As crazy as that might sound, there's still good law out there, and by good I mean it hasn't been overturned, holding that statements of opinion can be actionable in a private plaintiff, private matter context. So a communication is defamatory if it causes enough harm to a person's reputation to lower the community's estimation of that individual or to deter others from associating with that individual, period. In a 2000 Minnesota Court of Appeals case, the court held that the First Amendment does not provide any protection to parties in a private defamation action. So this is essentially a strict liability standard. That said, the cases are not clear because there's been later Minnesota Supreme Court cases that appear to indicate that it's not clear. There's a 1985 defamation case where the Minnesota Supreme Court adopted the negligence standard for the first time, applying to a defamation claim by a private individual, but that case involved a matter of public concern and the defendant was a media defendant. Then in a 2019 Supreme Court case, Mathner v. Someplace Safe Incorporated, the Supreme Court noted that it had never applied that negligence standard in a defamation case that did not implicate First Amendment concerns, which means they never applied negligence in a case where it was a private plaintiff, private matter defamation action. And in Madner, the court said that because the parties didn't raise the issue, they were going to reserve for another day the question of whether that 1985 case required private plaintiffs to prove negligence in all defamation actions, or whether that just applied to private plaintiffs involving matters of public concern. And in support of the position that not even a negligence standard applies, you can look at the use note to CivJig 5045, which is defamation-negligence, and that says that the instruction should only be used in cases brought by private persons challenging speech on matters of public concern. So there's a pretty strong argument to be made that in a private plaintiff, private matter defamation case, if you make a false statement of fact, even if you think you're right, or if you make an opinion, and that hurts a person's reputation, you can be liable for defamation, which I think is a little troubling. I mean, I think that would apply to a situation where you go to a restaurant and at some point throughout the service, you think that your waitress rolled her eyes at you, and you later tell the manager that. And this waitress gets in trouble. And then later at some point, they figure out that, no, she actually didn't roll her eyes at you. I don't know if there was video surveillance footage or testimony from a coworker, but that, based on the case law, would be prime for a defamation, actually defamation per se even, case, which is crazy to me. Did I skip? Right, so plaintiff has to prove harm to reputation. Emotional harm damages are not enough. Once you do prove harm to reputation, then those emotional damages can get added on as parasitic damages. Defamation defenses. Truth. Truth is a complete defense to defamation, and true statements, however disparaging, are not actionable. Opinion. The First Amendment protects statements of pure opinion from defamation claims, aside from all the stuff I just said about private plaintiff, private matter cases. This appears to only apply to public matter and public figure defamation cases. So examples are referring to someone as a real tool. That falls into the category of pure opinion because the term real tool can't be reasonably interpreted as stating a fact, or can't be proven true or false. But statements that are susceptible to being proven true or false are actionable even if they're expressed as opinions. So simply couching a statement with the term I think or in my opinion doesn't get someone off the hook. The Supreme Court has explained this as if a speaker says, in my opinion, John Jones is a liar, he's implying a knowledge of facts, which would lead to the conclusion that Jones told an untruth. Okay, so the privileges. These privileges, there's two categories of privileges that exist for defamation cases. There's absolute and qualified, or sometimes referred to as conditional. The absolute and qualified privileges typically cover statements made by varying categories of public officials. Absolute privilege means that immunity is given even for intentionally false statements coupled with malice. The Minnesota Supreme Court has held that statements made in written reports prepared by police officers are covered by the absolute privilege. Statements published in judicial proceedings, which are relevant to the judicial proceedings, those are covered by absolute privilege. It's not lightly granted. It only applies in limited circumstances. The Minnesota Constitution actually provides privilege from defamation liability to members of the State Senate and House of Representatives in the discharge of their official duties. The qualified or conditional privilege, that applies if the statement is made in good faith, upon a proper occasion, proper motive, and based upon reasonable or probable cause. And you see this one talked a lot about in the context of employment recommendations. So courts generally recognize a qualified privilege between former and prospective employers as long as the statements, again, are made in good faith and for a legitimate purpose. And once the defendant establishes that one of these privileges applies, then the burden shifts to the plaintiff to show actual malice. Defamation per se. So the courts have decided that there are some statements that are just so bad that they're going to presume harm. And so far, the courts have just limited it to 4 categories. A statement is defamatory per se if it falsely accuses someone of a crime, of having a loathsome disease, and that's, we typically see this in the context of accusing someone of having an STD, of unchastity / serious sexual misconduct, calling someone a pedophile would fall under that, or if the statement refers to improper or incompetent conduct involving a person's business, trade, or profession. Some cases have described this 4th category, as statements that affect the plaintiff in his business, trade, or profession rather than refer. I think that's a really significant distinction, but there's just no clarity on which one applies. For that 4th category, to constitute defamation per se, the false statement really has to go directly to the heart of that plaintiff's professional capabilities and reputation. It can't just be as an individual without regard to that person's profession. I just tried a case in Olmsted County about a week and a half ago involving this 4th category of defamation per se. This was a case where the defendant walked into a gas station. He saw a woman who he recognized as the wife of a man who was currently suing him for fraud. The woman worked at the gas station, and the woman didn't recognize him, had never met him before. But she walked by the defendant with another coworker, and as she did so, the defendant thought he heard her say something negative about him. A few days later, the defendant goes online to the gas station's website and makes a complaint about this woman, and he names the woman and says essentially that I saw this woman, and I think she made a negative comment about me. And at trial, some gas station employees testified about how important customer service was and how the company really just grilled this customer service is so important into everybody, and the jury found that statement was false, that this woman actually never said that, but more so that the statement went to the heart of her profession, and they found that it was defamatory per se. And you can compare that one to a 2014 Minnesota District Court case where a former employer who was discussing a former employee with a new prospective employee, and it was a car salesperson. And this former employer, in describing this former employee, said that this former employee would come to work high, stoned, on meth, and that was not defamatory per se. The court said that this former employer wasn't communicating on or commenting on the plaintiff's competence as a car salesperson or even as a worker in general, and the court felt that none of the statements particularly disparaged her ability to work as a car salesperson, so they weren't defamatory per se. In another case, the court found that a statement that a plaintiff businessman could not be trusted and would stab anyone in the back, that was held to be defamatory per se. And in defamation per se cases, if the plaintiff's a public figure, they still have to meet the actual malice standard, and those privileges that I talked about, those also would apply in defamation per se cases. In a case of defamation per se, general damages are presumed, and a plaintiff can recover without any proof that the defamatory statement caused him or her actual harm. There's a case, Long Ben v. Schoenrock, and it contains what I think is a really interesting and informative discussion on damages in defamation per se cases. The case was actually brought to the Court of Appeals 3 times, and this involved an oral statement made by Schoenrock in which he referred to Long Ben as Pat the pedophile. And Long Ben was this 34-year-old man. He was at that time dating an 18-year-old woman. And he was employed by the Moose Lake Police Department as a full-time police officer. And a few weeks later, after this statement was made, he was fired. And when he asked, why was I fired, they told him that he was fired because he had lost his credibility in the community. Long Ben's defamation claim against Schoenrock first went to trial in 2003, but the district court dismissed it with prejudice for reasons that aren't important now. But Long Ben appealed, and he was granted a new trial. The case was tried for a second time in 2005, and there the jury found in favor of Long Ben on the defamation claim, and they awarded him damages, including $230,000 for past and future harm to reputation, mental distress, humiliation, and embarrassment, $3,000 for future health care expenses, and $90,000 for past and future wage loss. So Schoenrock then made a post-trial motion, essentially arguing that the jury was wrong as a matter of law, and the district court granted his motion. The trial court set aside the jury's award of the $90,000 because they found that there wasn't any evidence of a causal connection between the award of damages and the harm alleged by Long Ben. And for those of you who don't know, special damages just means economic loss directly caused by the defamatory statement. So that would include lost wages or loss of employment. The court also concluded that Schoenrock's statement was not defamatory per se, and that the evidence was insufficient to support the award of general damages because Long Ben didn't prove that Schoenrock's statements caused those damages, right? So if it's not defamatory per se, you have to have some sort of causation there. Long Ben appeals, and the Court of Appeals affirmed the trial court's ruling setting aside the $90,000 for the special damages because of no causal connection, no special damages. But the trial judge had also set aside that $230,000 award on a similar basis, that the evidence was legally insufficient to establish any sort of causal connection between Schoenrock's statement and Long Ben's general damages. And the Court of Appeals reversed that ruling, stating, because respondent's statement is defamatory per se, general damages are presumed, appellant may recover without any proof of actual harm. Accordingly, the district court erred with regard to this issue. But the fact that general damages were presumed didn't mean that the jury's award was totally immune from review, because the trial judge had also determined that the amount of the award wasn't supported by the evidence, and that ruling the Court of Appeals upheld. And this is a quote from the Court of Appeals decision. The presumption of general damages in cases of defamation per se affords little control by the court over the jury's assessment of the appropriate amount of damages. But in the absence of proof, general damages are limited to harm that would normally be assumed to flow from a defamatory publication of the nature involved. So based on the record in that case, the court concluded that the $230,000 far exceeded the amount of past and future harm to Long Ben's reputation, mental distress, humiliation, and embarrassment that would normally flow from a publication of that kind. Now, I'd have to look further into the briefing to see what kind of testimony was elicited at trial to figure out how did the court determine that that amount didn't naturally flow. That would be interesting. But the case was remanded again for a new trial on the amount of general damages. So the case went to trial for a third time in May 2009. And this time the jury found in favor of Schoenrock. And Long Ben appealed based on alleged errors in the jigs, in the jury instructions and the special verdict form, because there was language in there requiring causation in a defamation per se case, which is crazy to me because you'd think by then they would have figured this stuff out. And the case was remanded again for a new trial on the amount of general damages, and I have no idea what happened after that. They may have settled after 10 years of dealing with this. But it's still the case that juries can award a lot of money as compensation for supposed damages to reputation without any proof that any harm actually occurred. And I don't know any other type of claim where that's true, aside from punitive damages, which requires a heightened burden of proof. You know, under Minnesota law, there's two statutes that cover punitive damages, 549.191 and 549.20, and that requires clear and convincing evidence that the defendant showed a deliberate disregard for the rights and safety of another. But here, you just have to accuse someone of a crime, and if you're wrong, even if you thought you were right, the plaintiff's damages are presumed, and the jury can award whatever the heck they want. There's a concept that I haven't seen addressed in appellate courts in Minnesota yet, relating to this presumption of damages in defamation per se cases. And that involves Rule 301 of the Minnesota Rules of Evidence, which says that legal presumptions are rebuttable. I did see this in a 2007 Ohio case involving a defamation per se claim where the defendant successfully rebutted the presumption of presumed damages for statements that were defamatory per se, because the plaintiff testified that the person to whom the statements were made didn't believe them. So I think that's an interesting concept and some food for thought. That is all I have for you guys. Thank you for your time. And if you have any questions, call, email, find me at the bar.
What were the damages in the Olmsted case?
200,000. 200,000 for the per se, and I talked to I called the jury foreperson afterwards to talk about it, and we talked for 2 hours, and yeah, they didn't think 200 grand was that much, and she had no harm to reputation, FYI. Not that she had to prove that, but yeah. But we're cooking up some post-trial motions right now.
Okay, here, Jim, grab a mic. Pull that on it. All right, so we decided to make ourselves the last speakers, because then we can control how long this goes. And if Jim wants to cut us off, he'll just push me off the stage, and I'll know that's a sign to quit talking. So what I did was I sent an email to everybody. Maybe in here you didn't get it because you weren't sitting there, just to see what issues you wanted discussed. And but before I get to that, also thanks everybody for coming, and thanks for staying, those that you did. And on your way out, make sure you take coffee, wine, and beer. I don't want any left. So, and Jim's wife Molly, who's out there, he's
Already filled up my trunk.
Exactly. So we do not want that to be hanging around. I have to go to a wedding at 4 o'clock. My wife, who may be outside right now, told me. So social hour when we're done will be over there, where Travis is sitting right now. And for those that stick around for that. But whether you stick around for that, on your way out, grab beer, wine, or coffee. Because, well, not all of it, but with a good percentage of it, you actually paid for it. So you may as well get it. All right, so email responses, and it's kind of consistent with what Persis just talked about with respect to verdicts. One of the inquiries I got from one of our attendees was, how does everybody think or feel about verdict trends with respect to COVID? And is there an increase in settlement amounts as a result of COVID and its impact on verdicts? I don't know. What do you think, Jim?
Well, when COVID first hit, I was staring at the ceiling a lot at night, thinking, oh my God, the insurance industry is going to put the brakes on, and we aren't going to see recoveries like we used to, or they're going to delay it and hang on to my client's money. That's the way I look at it. And I found eventually the opposite to be true. And I talked to several very good friends of mine in the insurance industry and defense lawyers, and the reality of it is I think they used it as an opportunity to clear the shelves and get rid of some files. And I thought the offers we received were fair, and with some exceptions where there was delay, mostly in getting a trial date set. But I thought things went just fine, and I really, financially anyway, didn't see any kind of, or not much of a negative impact from COVID. Now, maybe others feel differently.
Any thoughts on that? I generally agree with Jim. I think insurers took a chance to clear the books, and I never saw any change in evaluations, people being unwilling to settle a case that they might have otherwise settled because they thought they'd hang on to the money. And just having spent almost 20 years working for State Farm and knowing how things go, that does them no good, because an increased number of cases in litigation just increase costs. It doesn't do anything because they've already reserved the money. So anyway, that was my sense of the same thing. And with respect to verdict trends, I just have watched the verdict reporter, and there's still a lot of defense verdicts, but I would say the plaintiff's verdicts have been better for the plaintiff than pre-COVID, but that's purely by looking at Twin City Jury Verdict Reporter and then word of mouth. I don't know if that's based on any scientific evidence. Is that consistent with your thoughts?
Yeah, it is. And in my own firm, Matt's a great example. He just got a very significant verdict, and my partner Sue Holden recently got a very significant verdict. So we've seen some very good verdicts over the last couple of years, and I know the folks at Schwabel would say the same thing, I suspect. Where's Paul? Yeah. So I don't know. I don't see anything markedly adversely affected by COVID in terms of verdicts.
We've got one of the top executives at Western National in our audience, Mr. Buckley. He's working on his phone. I see him there, so I'll call him out. What's the sense from inside in terms of how COVID has impacted either settlements or verdicts?
I think if you look at the entire book, you don't see a lot, but I think that there's kind of the nuclear verdict, the case involving medical malpractice up in St. Cloud. There was a burn case in St. Paul a couple weeks ago with millions and $35 million. Those strike fear in the insurance industry and the claims people, because that would represent a significant excess policy exposure. And although we have some insurance coverage to cover that exposure, we probably don't have enough when you're talking about the kind of money that those verdicts were. And they're very difficult to predict. I mean, obviously they're bad injuries, but those seem outliers, even given the serious nature of the industry.
Just for our live streaming audience, that was, you probably couldn't hear him, but I'll just sort of paraphrase what he said. John Buckley, good friend and Vice President of Claims, Executive Vice President, I think now, right? EVP? Senior Vice President of Claims at Western National. Basically, the message was a couple of recent verdicts that were very large that may not indicate any trend whatsoever, but they do make people take a second look at their cases. Anybody else have their 2 cents in verdicts? Okay. Success of remote trials. Anyone had any remote trials? I'm aware of a few, but I'm not sure if any of the folks here are involved in those. In other words, jury trials where it was on Zoom. My information on that, there's been a few, but generally there aren't going to be too many ever again.
Well, yeah, maybe Matt can straighten me out, but I'm not aware of any of our lawyers trying a remote trial during the pandemic slowdown or shutdown. And I was asked to try one, and I, after consideration, said no. And the judge said it was okay for us to say no, and I just thought, I have a hard enough time making a Zoom call if I have to sit there all day on Zoom and try and present a case. I had little confidence in myself that I would be able to do it, or that somehow the technology would frustrate me.
Another issue, anyone else on that? Another issue raised was anything with respect to joint and several liability or joint venture, any recent cases. I think, Matt Barber, there was a recent Staub case. Does that deal with, the old Staub case dealt with joint and several? Does the one you mentioned today have anything to do with that? All right, so we had Fish versus Ramler a couple of years ago that really put defendants, when there's a work comp interest involved, in a tough situation, or at least a situation they didn't like. And then the question to follow was, there any anticipated legislative changes? And on that, having worked on legislative issues for a number of years, I would say, as long as we have a gridlock, I'll call it, like Joel Carlson talked about, where we've got divided government, there will be none. The only way there'll be a legislative change in that respect is if one party or the other takes over the House, the Senate, and the governor's office, and then there may be something on that, but I don't see it. Okay. Next issue up is now this is on my list now, dealing with health insurers. So, and I know that Andy Rorvik may have talked about this because I asked him to, but I probably wasn't listening. But let's name names here. So Optum was difficult to deal with 2-3 years ago. Are they even worse now? Yes, was the answer. Okay.
Yeah, I think they're even worse because you don't have one person anymore. You get one person, then a month later you get another person, and it's, I believe I'm dialing like 1-800 numbers to try and talk to somebody, and I'm not a fan.
Anyone have a different opinion? Anyone from Optum in the audience? Well, I don't care. That doesn't mean that she worked. Was that in the past tense or the current tense? Worked there. Okay. And I'd have nothing. I just know that at mediation, I used to, during the mediation, be able to call certain people. I had a list at Blue Cross who I like to work with, at Optum who I like to work with, and then the folks at DHS, when our health partners, when, what's his name? Help me. You know the guy. Chris? Yes.
Seipel, yeah,
Yes.
Chris Seipel.
And you could deal with them right during the mediation and be done with it. That hasn't happened in probably 2 or 3 years. And I just assuming that that's going to be not getting better, but getting worse.
Yeah, I don't know. I hope it gets better.
Any other comments on that?
I just want to make one comment. I don't know if it's your experience, but it's my experience that 35 years ago, like I said, when I started, when I resolved a case, I resolved the case, and I usually got the check within 30 days, and we had a release that wasn't 8 pages long. It was like a page long. Now I'm getting releases that are thicker than the Bible I have on my bedside. But on top of that, it takes it forever to move somebody's money through the system and get it to them. With the Medicare, Medicaid issues, with people like Optum, and those are things we never had to deal with, or I didn't, or very little. And you obviously had to deal with work comp liens, but it just seems so much more difficult today and time-consuming to process a recovery.
Which the next thing on my list here is actually work comp subrogation issues, because make sure if you have a case, whether you're plaintiff or defense and you want to get it resolved, that the work comp insurer knows about mediation. I try and let them know if I know about it, but a lot of times I don't know about it until the day or two before when I'm reading through the material and find out there's a work comp interest. And that's a whole different calculation analysis. And State Fund Mutual, which fortunately writes half the work comp in Minnesota, is really good to work with. I know the players there, and I'm sure you folks do as well. But the rest can be extremely difficult, and they need to be aware that what's going on, and to be included, I think, in the process. Because to try to deal with them after the fact, like you might a health insurer, you can't do it if you're a plaintiff's lawyer. You can't count on it if you're a defense lawyer that the plaintiff's lawyer is going to be able to get something worked out. So they have to be included in the process. And that's not just mediation. That's if you're settling direct or you're trying to negotiate something. Make sure you include them and make sure you educate them about how things work and that certain things are subrogable and certain things aren't. And if they happen to be located on the East Coast and they have 15, 20, 30 states they're working on, they don't know anything about Minnesota work comp, even though they think they do. They think they can plug it into the formula. That's automatically what they get, and it's not. And so, anyway, there's a lot of education that needs to be done there if you have a comp subro interest.
Brett, I couldn't agree with you more, but the funny situation I think I find myself in, and maybe other plaintiffs' lawyers, is when you go to a mediation, you have a work comp lien, and you call the work comp carrier, and they, okay, you paid this amount, here's kind of the formula amount. will you take this amount? And they say, well, how much are you going to settle your case for? And I say, well, I don't know till you tell me how much money you want back, because then I go back to Brett and he says, how much money do you want? And I say, well, I don't know what the comp carrier will take. And it's a fun little trip around in circles. But anyway.
All right, any comments on that? Comp Subro, Doug?
Actually, when the comp subro thing is done, I comment on in-person trials.
Say that again.
In-person trials, non-Zoom trials. I have excuse me, my youngest daughter is an expert on body language. And I was talking to her when we started to use Zoom to do a lot of our work. And she says, well, you can't do that because the truth of what people say is often reflected in other parts of their body. And actually, I'm thinking about asking her to help me write an article about in-person trials, because she thinks it's extraordinarily important to have people that the jury can actually see their whole body as they testify.
Yeah, I agree.
That was Doug Shrewsbury, trial lawyer extraordinaire, mediator extraordinaire, and making an excellent point on the issue of body language and how, obviously, with a Zoom trial, that is out the window, and it's such an important part of communication. And well, it's basically incontrovertible that that's an important part of communication. And so, if something to consider about with respect to any type of remote trial. Okay, and one more issue.
Okay, you get one more.
Go ahead.
No, I said you get one more.
Oh, I get
That's-
one more. All right, you're cutting me off. Good. So, anyone heard of Allberg versus Department of Human Services of Arkansas? Okay, it's a U.S. Supreme Court case. You really should read it, or at least a summary of it. And it's, I think, could be very useful in dealing with Medicaid, so presumably DHS-type, Medicaid-type liens, and interjecting the issue of double recovery in order for them to get their money back that they don't like to acknowledge. So take a look at Allberg. Came up recently with one of my regular customers who called and asked me about it, and then I really hadn't heard of it, so I looked it up and started reading it, and I said, yeah, why don't you see what their response to Allberg is? So something to do over the weekend. Allberg versus Department of Human Services of Arkansas. Matt, have you heard of that one? Oh, Matt Steinberg, too.
Matt. Two
Matt
Matts.
Barber, U.S. Supreme Court.
It's been double matted.
All right. It's been double matted, and I've stumped the audience, and they'll probably prove to me next week you were completely wrong. Thank you, Brett.
Thank you all so much for coming. Brett and I really have a gas doing this. And I want to thank the people from Town and Country. They're wonderful. I want to thank my wife, Molly, and her sister, Lisa, who are do all the work for us.
Yeah.
So thank you to everybody, and thanks for coming.
And grab beer, wine, and coffee on your way out. And the social hour for those sticking around will be over here to the left, my left.